at some point have a brief caucus, or we could do them individually, but it'd be nice if we just had an overall at some point. Doesn't have to be long. Thank you.
It will be after the public comment on the presentation, which I will set forth.
Thanks.
Order of the day. Are we streaming live? Yes, we are. Good morning, everyone. Happy Friday, March 11th. Welcome to the Joint Standing Committee on Veterans and Legal Affairs. My name is Craig Hickman. I represent Senate District 14, which is comprised of the towns of Chelsea, Randolph, and Pittston, Gardner, West Gardner, and Monmouth, Farmingdale, Manchester, and Hollowell, Reedfield, and my hometown of Winthrop. Today on our agenda, we have a report from the Department of Veterans and Defense Veterans and Emergency Management, followed by 5 work sessions in the later part of the morning or the early part of the afternoon, depending upon how long our morning goes. It's going to be an emotional day. It's going to be a day where I hope that we can all keep focused on the task before us. It is the last day that we have bills in our possession that we are also supposed to vote on. So it will be a robust day. But before we get on with that, we will start with committee introductions, beginning with Senator Meermont.
Good morning, Dave Meermont, representing Senate District 12, which is all of Knox County except the town of Washington.
Representative Riley.
Hi, I'm Representative Riley. I represent House District 34, which is part of Westbrook.
Representative Supika.
Good morning, I'm Laura Supika and I represent House District 126, which is a portion of Bangor.
Representative Wood.
Good morning. Hi, I'm Barb Wood and I represent House District 38, which is the western end of the peninsula in Portland.
Representative McCright.
Good morning. I'm Jay McCright, representing Harpswell, West Bath, and Northeast Brunswick in the House.
And House Chair Representative Chiazzo.
Good Friday morning, everybody. Chris Chiazzo, House District 28, beautiful, sunny, and warm West Scarborough, Maine.
And for our first presentation of the day, we have our analyst, our awesome analyst, Janet Stocco from the Office of Policy and Legal Analysis. And today is the first day that we have our new committee clerk, Darlene Semino, a veteran in this place. She knows it all.
Well, I don't know if I know it all, but definitely a veteran.
So I am going to, is Representative Corey here?
He hasn't come back on yet.
Okay, we will allow members to introduce themselves as they arrive. I'm going to, Darlene, if you could please make me a co-host.
I did.
So I can invite people
Yeah,
into
where'd you go? Oh,
the panel. It's
where'd
okay.
you go? Nope. I thought I had gotten you, but there we go. You should be all set.
Great. Thank you very much. I am inviting the Adjutant General to join us. So with that, I will open the report, presentation, and public comment on Chapter 21 of Resolve 2021 on the Resolve LD 625, directing a review of crucial needs and lapses in responding to and preventing sexual trauma in the Maine National Guard, presented by our very own Representative Morgan Riley. Good morning, Major General Farnham. Welcome to the Joint Standing Committee on Veterans and Legal Affairs.
Good morning. Can you hear me okay?
Yes, we can.
Okay.
Major General, the floor is yours whenever you begin. We are going to hear your presentation and then there will be questions from the committee before we go into public comment. So whenever you are ready, we are all ears, sir.
All right, that's perfect. Senator Hickman, Representative Chiazzo, and members of the VLA. First of all, I just want to make sure you've heard me say there is no place for sexual assault and sexual harassment in the Maine National Guard, period. Okay? And so whatever else we talk about today, I just want to make sure that is perfectly clear. And I really appreciate the opportunity to appear before you today to discuss some of the recent and current initiatives unfolding nationally and at our level for sexual assault and harassment response and prevention programs. Above all else, our people are our most valuable resource, which makes this a critical topic, as in any issue that involves the safety and well-being of Maine soldiers and airmen. Among the staff that are joining me today are Major Katie Trost, one of our staff judge advocates, Ms. Christina Zaberick, our Joint Force Headquarters Sexual Assault Response Coordinator, or SARC, and Major Nehemiah Natras, who has been our Provost Marshal for the past couple of years. Their offices are three of the many key players that are involved in ensuring that we are taking care of our soldiers and airmen. I would like to take just a few minutes to briefly provide some highlights and comments regarding the report that was prepared for you as part of LD 625, after which we would like to devote the most of our time to interacting with you. Also, if there are additional areas of interest that you have for which we do not have available answers, my staff will work to provide additional releasable information to you. Ultimately, I want you all to be as confident as I am that we have a strong program, but that we are committed to always making it better. As you've likely read, federal regulation and policy has changed significantly in the last 10 plus years, leading to initiatives like the CATCH program and special victim counsel attorneys being assigned to each survivor. Additional changes are being laid out, quite literally as we speak. The Department of Defense's Independent Review Commission came out with over 80 recommendations last summer, which are currently being reviewed by the service components in the National Guard Bureau. The current NDAA also makes significant changes. Many of these initiatives are included in the federal FY22 and FY23 budgets, which, as an aside, we might actually have an FY22 budget today. Military sexual assault is receiving a lot of attention, and for good reason. We simply must do everything we can to ensure the well-being of our citizen soldiers, airmen, and it's the right thing to do. As these additional federal measures are laid out, as presented in our report, we have taken steps here in Maine to further complement the federal program. We have hired our first ever victim advocate coordinator at full-time at Joint Force Headquarters. His name is Mr. Eric Carter. This will enable our SAPR program to recruit, train, and credential additional victim advocates, as well as provide additional 24/7 support to victims. We've made our Provost Marshal a full-time position. It had previously been an additional duty assigned to our Director of Military Support. Our newly hired Provost, Captain Dustin Martin, comes to us from the Brewer Police Department, and his experience will prove vital in continuing to build working relationships with departments across the state, streamlining case processes. This is critical since in the Guard, unlike active duty, we rely on civilian law enforcement for our criminal investigation and prosecution. We are working to provide you with draft legislation to streamline military and civilian protection orders, potentially eliminating an extra legal step for those that need these orders. We are also drafting legislation to provide Maine National Guard a seat on the Maine Commission on Domestic and Sexual Abuse. We are making post-discharge travel funds available to former service members to make it easier for them to participate in the administrative matters and provide them the opportunity to make their voices properly heard. And we are working to formalize the partnership between the Maine National Guard and MICASA, enhancing our SAPR program's connection to valuable resources. And finally, we are working closely with the Governor's Office to create an advisory council, formalizing communication and relevant parties to better ensure survivors are connected with much needed resources. All of these measures, as well as the updates on the questions originally posed to us in the 2013 resolve, are discussed further in the document that has been provided. And we look forward to putting these in place to further enhance the critical services of our SAPR program that our SAPR program provides. At this time, we welcome your questions, and my staff and I will do our best to provide the answers you need. Thank you.
Thank you, General Farnham. Chair recognizes Representative Riley.
Thank you, Mr. Chair, and thank you, General Farnham, for coming before us today. I have a series about 10 questions or so for you. And if you need me to repeat anything, and some of them are kind of multi-part, so I'll try to be as clear and concise as possible.
Okay.
My first question would be in response for, and I don't know if you have the report up with you right now. But in response for, I was wondering why does the guard say in response to an independent review panel to examine sexual assaults that the quote recommendation was not accomplished due to changing federal regulation at the beginning, and then at the end, if a further independent panel is legally created to review these cases, the guard would be fully capable of complying with informational requests of the panel. I was just wondering why this difference and what area in changing federal regulation that kind of happened between 2011 and 2014 that you said would prevent an independent review, and how that's changed since then. Is that referring to the Military Justice Improvement Act and the provisions passed as part of the 2022 NDAA under subtitle D?
Well, that legislation you referred to at the federal level is just is the most recent of many years of provisions that have been done at the federal level that has had the program constantly changing, adapted, and been updated. As you've probably seen, there was in some of the articles that I had read referencing that legislation and the process. As you know, it was a many-year process as that worked through the system. One of the senators had referred to over the last 15 years have been no less than 250 different provisions on this topic that had been passed at the national level. So again, over the last 10 or 15 years, the number of changes at the federal level has been significant. And so every time that happens, it affects how the main UCMJ versus the UCMJ and how that all works. So to some degree, it's been such a moving target that I won't say, it's been kind of overcome by events, the different things, that discussion of the main code. So if I get talking any more about the UCMJ and Maine Code of Military Justice, I'm going to turn it over to Major Tross, because she can talk if you would like a more in-depth discussion on that.
Okay, thank you. I guess like one follow-up would be why the MCMJ is necessarily bound up with the USCMJ changes.
I'm going to yield to my JAG, who can talk about that much more eloquently than I.
Okay.
Just slide that over.
Okay. Hi there. Can you
Hi.
hear
Good
me?
morning.
Hi.
Morning. Please
So-
introduce yourself.
Major Katie Trost, Judge Advocate.
Thank you. You may proceed.
Okay. So Representative Riley, just to contextualize, while the UCMJ and the Maine Code of Military Justice are not connected per se, what General Farnham is referencing is our federal control through regulation that is dictating how we process these cases, if that makes sense. So we have requirements under administrative procedures versus the criminal procedures. So those are a little bit separate and distinct, and those are very prescribed.
Okay. Okay, awesome. So I just wanted to confirm that if there was a further independent panel that was legally created, the guard could work with that.
We could. There might be some tension points, again, given the federal requirements. So for example, we couldn't, lessen things that were prescribed by federal regulation, but we could definitely, look into the separate and distinct Maine Code of Military Justice.
Okay. In going down in response 5, would it be possible to see examples of the climate assessment surveys? And I was also trying to see how do the assessments capture issues in culture, and is the data, including URIS, collected somewhere, and can it be shared when the guard starts its yearly report to VLA and the governor, which was mentioned in response 12. And And then I was also seeing, sorry, this is several questions. So if you need me to repeat anything, please let me know. I was also seeing with this, what has CR2C previously recommended, and can that also be shared with us?
I'm looking over. Tina, do you want to jump in here? Sure. Okay, thank you.
Thank you. Good morning. Welcome to the committee. Please
Good
introduce.
morning. Thank you so much for having me. My name's Tina Zabrick. I'm the Sexual Assault Response Coordinator for the state of Maine.
Thank you.
One of them. So the URIs and the climate assessments that we do annually are at the unit level. Those are actually run through the EO program. However, I can certainly get with them and see what we can get for you all and try to incorporate some of that information into the annual report.
Thank you. And then jumping a little further ahead with that report, will this annual briefing include Mikasa as well?
I would love Mikasa to be involved in the annual report, and I can certainly get with them to see if they're able to be involved.
And then in the report, will the guard also provide a summary and kind of share with us the data from last year and the years kind of going back to 2013 or as far back as possible, with what was kind of mentioned in response 13 with sexual assault and rape incidents, their status and outcomes, including the duty status of adjudicated and administratively dismissed military offenders and military victims?
So my office tracks the sexual assault cases. We would have to work pretty closely with the legal office and the provost marshal's office to see how those cases are executed. But we can certainly discuss with our public affairs officer, our judge advocate's office, and clear it through the National Guard Bureau. Those are the three entities we need to check with before releasing any information. So we can certainly do that and work on something that fits what you all are looking for.
Because I would like to kind of see that data, kind of just to see how, to see if there's patterns or if what is kind of going on. It would really help. Definitely the governor and the legislature. I can't speak for the governor, but it would probably definitely help her in the legislature kind of be able to kind of get a better understanding of this. So we would like to see that.
Just jump in.
And then also jumping.
Can I just add to that a little bit, just to kind of, sometimes when we get the questions, I know it seems like we're saying, well, we're hesitant on what we can release. And I just want to explain that a little bit. There's a lot of people with their fingers in this process, as the rules and the policies have been changing so dramatically over the last 10 or 15 years. One of the biggest changes that happened, and as you hear a lot of at both the national level and we've witnessed here in Maine, is the increased reports, is because there's been a conscious effort to get those reports. And one of the things that changed was the breakdown of restricted and unrestricted reports, allowing people to come forward and make these restricted reports to make sure that the victim gets the services that they need, but that everything else is really clamped down very tightly around it to encourage them to come forward. So there's a lot of people in the process that are very protective of that restricted nature of the reports, so that we can continue to get those reports and make the victims comfortable in coming forward. And that's one of the things that has been in my opinion, one of the game changers in the program over the last 10 years, and is that ability to have restricted reports. And so, but it does complicate a lot of the issues that people want all the answers for, if that makes sense.
And then jumping towards the action plans, in action plan 2, who qualifies as eligible service members and former service members? Can you define what that is? What's the eligibility?
Yes, so great question. So per the DoD guidance, My program, the SAPR program, services anyone that walks into my door. Just to be clear, anyone that walks into my door, anyone that comes to a credentialed victim advocate, we're never going to turn folks away. We're going to do our best to support folks, whatever they need, wherever they are. However, in order to do a DD Form 2910, a legitimate report that the military recognizes, there is eligible service members. So service members and dependents that are over 18 are eligible for services. Due to the very dangerous nature of domestic violence and child abuse situations, we don't service those folks in an official capacity. However, we work with MICASA and other state resources to ensure that those folks have the support that they need. And there is a family advocacy program on the active duty side that we rely on our active duty counterparts for.
Okay.
So does that answer your question, Representative?
Yeah. Thank you. And then in action plan 5, who will make up this advisory council, and could this advisory council meet response for a possible collaboration between the Guard and an independent review panel? And would this be also a part of response 13 back? And I'm assuming this is part of the response 13, the report back to our committee here at VLA, and then to the governor as well.
Yes, so we are working with the governor's office to determine who the folks should be on that panel. However, I know that our new provost marshal, a representative who, for instance, someone from my office, a sexual assault, either a SARC or a victim advocate. I know that we were going to try to have the Attorney General's office in some capacity, and some other folks, again, from not only state entities, but the community as well.
Would MICASA also be included as well on this
Absolutely.
advisory council?
And Representative, just to, those suggestions, there's really kind of two parts to this. And like I said, the governor's working on that, on the recommendation for this committee. But there's really two parts. One, this involvement with the MICASA, involvement with the other, what do we call between MICASA and then the seat on the Maine Commission of Domestic and Sexual Abuse. That's a lot of that is all the things around the victims and the support and that type of thing. The new committee that we're talking about is more involved with our provost marshal and getting all the people that are involved when we start talking protection orders, when we start talking about law enforcement actions and how we communicate with law enforcement agencies, how that information is communicated to us. And that is that's a little bit more on that side of the conversation than the seat on the Commission on Domestic and Sexual Abuse and the MICASA program. So that's two different avenues of attack.
And then going back a little bit back to the responses to recommendation 8, the recommendation asks about providing information related to record collection. But I mean, in the response, it only discusses efforts to prevent or catch retaliation prior to discharge. And then it notes at the end that, quote, a SARC or VA can provide the victim with resources to facilitate the process of countering reprisal or requesting a record correction. But to my understanding, that only works for service members who feel safe disclosing that they filed an unrestricted report. And then service members with bad paper from DOD, they should be provided with information about discharge upgrade applications to the Discharge Review Board or Board for Correction Military Service members. And then service members with bad paper from the Guard should be provided with information about the state record correction process to the extent it exists. Can you kind of discuss that a little bit further?
Go ahead. Well, that's a JAG question.
So this is Major Katie Trost again. I want to make sure I understand your question. So with regard to if you have an unrestricted report for somebody who wants to explore discharge upgrades, all administrative separations, my understanding, and I will have to confirm this with our personnel folks, they receive in conjunction with their separation packet an instruction sheet on how to apply for a discharge upgrade, if that makes sense. In terms of restricted reports, I don't see a distinction necessarily in the information given. It's more, are you asking what conduit of resources they have to maintain that confidentiality while exploring a discharge upgrade?
Yeah, I would like to learn a little bit more about that. Yes.
So a little bit shooting from the hip. So excuse me, what I would think would happen is the person is entitled to a special victims counsel. If they've engaged with that special victims counsel, I see no reason why they couldn't re-engage with them for information while maintaining that confidentiality. And I'm going to have to jump over to our SARC in a second, because I believe the same exists for the SARC relationship as well. And again, so you can kind of have a touch point where you can come in with your paper that you get from the discharge and then see, see what resources are available to you. And this might be a little bit off script, but when I was doing this type of work, I would frequently refer people to legal clinics and things like that. Harvard has a veterans clinic, stuff like that. So again, as Tina said, just making sure people have the resources they need.
Because not to my knowledge, I don't believe Humane Law has a legal clinic for veterans, right?
They have
That you can refer to, because
they have a general clinic. They did have some veteran some folks working. This is all anecdotal outside of this, but there are some resources that we track to refer folks to.
Can you would it be possible to share some of that with us?
Sure. I mean, sure. So as I mentioned, I've referred people to the Harvard Clinic specifically for veterans issues. I've referred people back to their either sometimes they'll have a trial defense attorney. So if they've gotten in trouble, they've received legal advice, and you can always, sort of contact that attorney. I have referred people to the Humane program. And again, that was about 5 years ago when they had somebody, I think it was a paralegal who was working with them. And then I think I've referred people to Pine Tree as well.
Okay.
Yeah.
Thank you.
But again, we also maintain our attorney-client relationship if you have a client. So if somebody somebody could call me in 5 years and I would say, this is the form, this is the process, and this is how you do this.
And then I have another question on recommendation 10. The response kind of appears to dispute the premise that retaining survivors on active duty until ALOD determination is completed will help ensure completion of an official investigation and adjudication of the offense. So my question is, does the Guard have any response as to whether completing line of duty determination without the member remaining in active duty status accomplishes the same goal? And then how does the Guard reconcile that response with its response to recommendation 3?
Do you want me to take this one?
Go ahead, yeah.
Okay. So I guess so you're asking whether people need to remain on active duty in order to complete a line of duty concurrently with a sexual assault investigation?
Yes.
Okay. I think that it depends on mostly the member's choice. So sometimes we have people who want to leave active duty. Because we still have our M-Day status, they can maintain membership to complete that process. But in general, very kind of broad picture, if you have somebody who is injured, they can't be released from active duty. So if the condition is such that they're not, I think there's a standard in the regulation. This is medical regulations now. But if you are sort of not cleared to a certain degree, you can't leave in any event. Then there's an intermediate status where you could be cleared to leave active duty, but you can still pursue that line of duty for any future issues, if that makes sense.
Mhm.
And then
Okay.
with regard to recommendation 3, that would be when the termination of military affiliation occurred and you're no longer in the organization. That's when we have a conduit to pull you back to compensate you for your time and participation in this process and kind of facilitate a healthy participation from those folks who are no longer in a status. This goes back to our multiple statuses and the multiple rules that apply.
Mhm.
But
Okay.
does that any follow up on that?
I maybe later. I need to think about it.
Okay.
And then with recommendation 14, when I was looking at it, it says, I mean, the guard has the ability to conduct non-judicial and administrative punishments, not criminal convictions. But I saw in the Maine Code of Military Justice, section 461, which incorporates the Maine criminal codes, a non-MCMJ definition of sexual assault and requires court-martial. I'm just kind of seeing, is the position of the guard member convicted of sexual assault at court-martial under the Maine criminal codes sexual assault standard somehow not conviction for a sex offense pursuant to 42 USC subsection 16911?
Is that the registry law?
Yeah.
Okay, so big picture, if you're convicted in civilian court, that conviction is eligible for registration under the federal law. If we were to conduct a court martial and convict, I don't know legally whether that's sufficient. I'd have to do a little bit of homework on that. With regard, you had mentioned non-judicial punishment. We would have to link with the Attorney General's office to make an opinion as to whether that would cut the standard for registration. Is that kind of?
Yeah. Could you look into that?
Yeah. Yes, I could. We can, and I think that's a good indication of kind of where we are, which is what can we do with the most impact, if that makes sense, with our tools.
Okay. And I only have a couple more questions. So thank you so much for bearing with me. Of course, supporting survivors is very important. And what is the guard currently doing to prevent harassment and assault from happening in the first place? You mentioned training in response 7, and I'm wondering what that training entails and any examples you can provide the committee.
Okay, we'll switch over to this, Sark, to get into some of the details. I'll just, in general, the training changes every year, and so sometimes training, we say training, but it means a lot of different things. I mean, it's not just training what is sexual assault and what is sexual harassment and don't do it. I mean, a lot of it is what is training as to what we have for resources available. Some of it is training in making sure everybody understands what restricted and unrestricted is and what that means and how you handle those cases. For a number of years, every time you had an inspection on a base, one of the things you made sure everybody understood was that difference, because that was, an inspector was going to stop the youngest, newest person they saw and ask them if they what the difference between restricted and unrestricted reporting was. And so that was a big part of training. There's training to commanders as to how to handle cases when somebody comes forward and you have people that have to, report, when they hear about a case. There's training to bystander training has been an emphasis over the years as to allowing bystanders to make sure they had the tools to step in and help. And so the focus on training, even though we say training a lot, has changed over the years. Again, initial training was kind of a generic prevention early on, then it became on reporting, now in the latest NDAA, everybody has agreed we need to go back more focused on prevention. But saying prevention means something different to everybody, and all these the new training programs are still being developed. We just got a message in February from the Army with very specific training that needs to happen all before September. Within a matter of 2 weeks, both the Army, Secretary of the Army and the Secretary of the Air Force and Air Force leadership had both put out messages to the force, talking about training and talking about the priority of attacking this problem. So I'll let Tina talk a little bit more about the training, but when we say training, it has meant something slightly different over the years. And there's been a lot of conversation recently and in this NDA on going back to more of the basic prevention pieces. It's Tina again.
Yes, hi there. Our mandatory annual in-person training requirement does come from DoD, the National Guard Bureau, down to the Army and the Air Force. The Army and the Air Force conduct training for the annual mandatory training a little bit differently. The Air Force has 2 separate trainings, one for leaders and one for lower enlisted folks. But they touch upon similar things, just again, at a more leadership, higher level for the leaders. And then the Army does, an annual mandatory unit training for, units. So the things that are in that training, one of the slides, my favorite slide, and I always say that when I'm giving the training, my favorite slide is that continuum of harm, because that's typically, generally, what we have seen is that without bystander intervention, we go from green to yellow to orange really, really quickly if folks don't intervene. So making sure that folks know how to report a sexual harassment or sexual assault offense is one of the things we train on really, really well. We talk about the continuum of harm, and then we give soldiers and airmen the tools to make sure that they can intervene on a situation when they see one. So bystander intervention has been a huge focus in the last several years. And then, of course, just prevention in general, how to settle things on the lowest level so that they don't escalate. And additionally, the Adjutant General was discussing the Army side, just came out with an X-Ord that requires us to train the force, all E6 level and above, so all leaders on specific items, and that is going to occur by 30 September. We're required to report back to NGB by 30 September, and then they will report up to the Secretary of the Army with our results by October 7th. The other thing that we also try to focus on is, again, not only the bystander intervention, but also, some of the consequences for these actions, right? So the entire process of, if something happens, this is what it looks like. It's not investigated within the chain of command. It's investigated outside the chain of command with a sexual assault. And then we also have on the back end, the bayonet justice, which for the Army side shows the execution of these the cases. So basically it'll show, if there was a sexual harassment claim, how that ended up, how we ended up executing that. It's like a little police blotter for our Army side. And we're working on making sure that we come out with that twice a year. So I think that our prevention strategy is two-pronged really. And this is what the Adjutant General and I had discussed, is that, not only do we have our training, annual mandatory training, but also just getting out into the field more and letting folks know that we're available and we are there for them. We did what we called like a little road show, again, on the Army side, with the Provost Marshal, the Judge Advocate General, the EO who deals with sexual harassment, and myself, the SARC, and Chief Wright, who was the previous SARC. So just getting out into the units and seeing soldiers and letting them know that not only are we here for support, but we're also here for, the execution of justice as much as we can, is really something that we take very, very seriously. We did see an uptick in folks approaching us with issues after the roadshow. So getting ourselves out more, I think, is just one approach, just to show soldiers and airmen that we are available. On the air side, they did a lot of sit with the SARC type events so that airmen could come in and do either crafts or art things, or just really just talk to the assault response coordinator and talk to leadership about their concerns. So two-pronged approach, training and just making ourselves available, getting out there into the field for prevention.
And you mentioned slides. Would it be possible?
Representative Riley, please defer. I know that as people watch, they may not be watching the entire presentation all at once. And so I would just ask for you to introduce yourself one more time so that we know who's actually speaking if someone has come in late.
Of course. I'm Representative Riley. I represent House District 34, which is part of Westbrook.
Thank you. And I also see we have another committee member who has arrived. Representative Corey, would you care to introduce yourself?
Good morning. I'm Patrick Corey, represent House District 25, which is part of Wyndham.
Thank you. And then to the Adjutant General, can you please introduce officially the people who are responding to Representative Riley's question so that if anyone has joined us late, they know who's talking. Thank you.
Okay. I have Major Katie Trost, one of our staff judge advocates, Ms. Tina Zaberek, who's our sexual assault response coordinator for Joint Force Headquarters, and Nehemiah Natras, who has been our provost marshal, working with local law enforcement for the last couple of years.
I appreciate that very much, everyone. Representative, you may please continue.
Thank you, Mr. Chair. So you had mentioned slides. I was wondering, would it be possible to see examples of some of this prevention training? And I also have another question. With some of this prevention training, are you also going to be working with Mikasa as well?
Tina's writing a note, but I'll say in general, we can provide some of the training slides to see it changes every year. And like Tina had mentioned, that training, we don't develop the curriculum. We enhance it some with our folks and their experience, but and try to make it interesting and different every year. But it comes from DOD down through the services, the actual training, and they change the emphasis a little bit each year. And then again, so in our involvement with things like Mikasa and any of the other community organizations, help make our folks better, better subject matter experts so that they can tweak the training better and make a more local flavor to it. But the training itself is going to come from DOD, not from like Mikasa. But I know that a lot of what our SARCs do is informed by what they learn in their association with the organizations like Mikasa.
And then, Mr. Chair, I just have one kind of question left.
You may proceed.
I was wondering, has the Guard used or looked into using kind of Callisto or a similar anonymous reporting system and ESCOW reporting system? I mean, that's one way to kind of catch repeat offenders.
Yeah, Tina can address that. I think that's accurate.
Yes, thank you. Great question. This is Tina Zaberek. I'm the SARC.
Mm-hmm.
So I did address the CATCH program in the report.
Yeah.
And so the CATCH program is a DOD system.
Yeah.
So that's our solution to that. I'm not familiar with Callisto. And I'm not sure
I'm happy.
if CATCH is linked to it or not, but I'm
happy to share it. So does that eligibility extend to drill weekends or state active duty, or is it just available when in Title 10 or Title 32 status for catch?
So the CATCH program is available to all eligible members. So even if a civilian were to be assaulted by a Guard member, they would be eligible to participate in the catch program.
Okay, thank you.
Thank you, Representative Riley. Adjutant General Farnham, the representative there'll probably be more questions about information, but since we know that Representative Riley has been doing a deep dive in this for a while, I'm wondering how long you would need to provide some of the information and examples that he has requested, sir.
How much? I'm looking at the experts here.
I think today.
Yeah.
Get the information.
Matter days.
Yeah.
Some
of it's her stuff might be quicker than the data piece.
Yeah, most of it within in a matter of days. The part that is a little bit more time consuming because we have to go is some of the, and as I referred to it already, is when we start talking some of the specific statistics. We get a lot of people with different opinions. And being a small state is one of the things that makes it difficult, because when you start going down to pick a year and there's one case, and then people start guessing what that one case, that ends up being the thing that puts red flags up for the folks that are concerned about the privacy issues and the restricted nature of some of the reports. When they bring all that reporting together, and when DoD releases their report and it's like nationwide numbers, everybody's comfortable with it, and we talk about it for a period of time, and it becomes the data that informs a lot of discussions. But it's big metadata, and everybody's comfortable with it. It's as the numbers get smaller that everybody starts warning me that we got to be careful. So, but other than some of those real specific statistics, we're talking just a matter of days on the other items that we talked about. And then I just want to throw out there to Representative Riley, this conversation about the LD and the resolve to require this report that you guys and he had the foresight to talk about last year, really, it has been a topic for, like I mentioned, 10 years or more. It has been it's been a hot topic all through DoD, obviously, but that has really turned up over the summer with the Independent Review Commission, the National Guard Bureau having a Sexual Assault Prevention Task Force, and Sexual Harassment, Suicide Prevention Task Force. There has been a real increase in the attention to this topic. The fights that went on, I shouldn't say fights, but the disagreements that went on just during the NDAA process down in DC on which parts of Senator Gillibrand's bill should be included in the NDAA caused a lot of conversation, and good conversation, and proves that we have not solved this. There's a lot of work that still needs to be done. Everybody knows that, but not everybody agrees on what needs to be done. But I appreciated the foresight that we were already kind of talking about some of these things. And so that when those conversations came up, we were a little bit ahead of the game as far as being able to look at ourselves and make some of these things. I mean, having a provost marshal full time has been a huge thing, and getting the ability to allocate some resources to get a full-time victim advocate is a big thing. And some of that came from conversations around preparing this report. So for your foresight, I appreciate that, Representative Riley.
Thank you, Major General. The chair recognizes Senator Mehrmont.
Thank you, Chair. There was proud when you got this position.
Senator Mehrmont, you are breaking up. I don't know if you may need to turn off your camera, or we'll try again. We cannot hear you in one.
Is this better?
Yes.
Okay.
So far.
Okay, thank you. Thanks, Mr. Chair, and thanks, General. I say your brother was proud when you got this position. The thing that gets me in a hierarchical system such as this, one that from day one takes your recruits and teaches them that the only thing is to follow orders. And it's an integral part of everything you teach, believe, and goes on. And especially there's a divide between commissioned and non-commissioned folks. So when it's harassment or assault by someone who is commissioned, then it's an even bigger gap to try to cross that line to say, I have some rights here. I need to speak up. It sounds like at the level you're at and your officers are at, you're doing everything that you should be, trying to integrate it. But how can a soldier ever feel like if they are harassed or assaulted and they cross that line, how can they feel that they have more rights now in this situation than in a situation where they've been told that they always are subordinate to someone, whether they're a colonel or even a general, because there's always another star, so that they go to these meetings and they have these talks and everything else. But underneath is the feeling still like, shit, I'm not going to say anything unless it's just like affects their performance or they're physically hurt. I'm not going to say anything. My career is over for nothing I did, because I've now given them ammunition. Yes, I reported this assault and they don't want this and they'll do everything about the assault. But I also have just crossed the line by not following an order by a superior who told me not to report this because they're harassing me or assaulting me. So that part, I just don't know if you can answer, or if it needs to be a civilian answer or someone else.
Let me start by saying that's exactly what a lot of the training is about reporting, and that's why early on when the real emphasis kicked off, and I always use 2013, 2011 in that time frame when the focus really shifted. Not that it was ever not there. I mean, I've been getting training on this since I joined the military in 1980. So the training isn't new, but the focus, I think, has been sharper since that time frame. But the shift to really talking about reporting and separating out the restricted reporting, so a person could get the services and be able to keep everything else quiet, private. That emphasis was really part of that early on, for that exact reason. The other part of that is there's a whole training. I've got a brochure somewhere I picked up the other day because it caught my eye, and after a conversation that floats around talking about reporting retaliation. So we have a whole training program that involves, okay, now you've reported and now you feel like there's retaliation, what do you do? And we do training on that, and this brochures laying all over the place, telling folks what they can do. There's an IG that we have right here, two hallways down from where I'm sitting right now. We have an IG that I say Title 10, and it's a federal officer, lieutenant colonel, who is not under my command or my chain of command in any way. He's a federal officer who is there for people to take retaliation complaints to. And again, they're not in our chain of command at all. So there's been a lot of emphasis and training and conversation. And when Tina mentioned the roadshow, that was one of the reasons they were out there, is to say, this is your SAR, this is your provost marshal. These are the people that you can go to if you have an issue, and they're going to help you go through the hoops. They're going to tell you who you need to talk to. If you've got issues, they're going to help you navigate all that stuff, from issues with law enforcement, issues with your supervisors, issues with in retaliation if it happens. So again, the tools are all there, and I'm the first to say, when it happens, we've all got the training. We all know what's right or wrong. If you surveyed the people that are coming to the military, they know what is right and wrong. And every time one of these things happen, it's a kick in the gut, because you know it's wrong. They know it's wrong. And somewhere along the line, there was a failure. But what we can do, and I think what we've done as well, or better than an awful lot of different organizations, is provide resources and focus at every angle of this issue. The frustrating thing is General Milley, Secretary Austin will say when questioned, we've put a ton of resources to this. We're prepared to put a lot more resources, but we can't say we've really moved the needle as much as we'd like to. And the conversation continues. So I hope I answered that. And I mean, I sensed a little frustration in your voice when you say it. We have the same frustration, believe me.
Thank you.
The chair recognizes Representative Chiazzo.
Thank you, Mr. Chairman, and thank you, General Farnham, and your staff for presenting this report to us this morning. There were 14 recommendations, I think, that came out of LD 625. If my count is correct, you are performing 11 of them. To fulfilling 11 of them, one is a partial fulfillment and two are cannot be fulfilled. I want to focus, if we could, on the discussion around number 4, which was the creation of an independent review panel to examine the way sexual assaults are investigated, prosecuted, and adjudicated, under the Maine Code of Military Justice. So my question, General, is I understood from the testimony that there is some challenges between the administrative side and the UCMJ, and how that we're waiting for that all dust to settle, I guess, a little bit, if I understood that correctly. My question is, are you aware of other states that have performed independent or have set up independent review panels to address this issue?
Well, not, I won't say other states. I think the discussion on that is more how we use the Maine code and how that connects with the UCMJ and the way the Guard prosecutes on the criminal side, and making sure that in the conversation we're separating out criminal investigation and prosecution from the administrative investigation and prosecution isn't the right word, but you know, how we handle it administratively, whether it be separations or grade reductions, that type of thing. So, but I will let Katie address that better than I can.
Hi there. So this is Major Katie Trost again. I think if it makes sense, I'll do a little bit of a broad picture of kind of what we're dealing with. So back in 2013, I suspect that this request was a response to a perception, at least, of things not occurring, right? So things are not moving the way that you potentially wanted them to. And the idea is take a look at how you're handling these, investigating these, and can we make any improvements? What General Farnham has been referencing in the interim that has changed is that the DoD took a couple of really big steps that dictated how we have to deal with them, you know, on that side of the house. So basically, we cannot investigate sexual assaults. We've said that several times. That's a pretty big deal, right? The command is responsible for investigating all misconduct under it, and so to take something away from it, it was a large change. So we have to request the investigation either through civilian law enforcement or through the Office of Complex Investigations. So when we talk about how things have been overcome by events, if we're referring things to the police, which the person who's not been in the hot seat at all and who's been really the biggest thing that we all reference, who's the provost marshal, he's going to liaise with law enforcement, and he's going to make sure that they understand the magnitude of these cases, because there might be some translation issues in terms of what is kind of relevant in the military side versus the civilian side. And he's going to create these relationships that allow for efficiencies, right? So you work with the same people, develop these relationships. That's going to naturally move over to the civilian law system, right? So we're going to have criminal cases, and we're kind of liaising and working in conjunction with them. If that process does not go through, then we have to request OCI to come in and investigate. We receive the product of OCI. That's an administrative investigation. So the burden of proof in that case is going to be preponderance of the evidence, which is lower than beyond a reasonable doubt. So that's kind of the product we get. At that point, we sit down and we take a look and we evaluate whether we have enough evidence to go through the non-judicial punishment process under Title 32 Maine Code of Military Justice, or whether we can use a Title 32 administrative solution. So my thought with this question is look at kind of that whole universe of stuff in the absence of the federal requirements that I've just described, which were filled in. Now, whether there is an effort to look at the Maine Code of Military Justice with all these inputs, that's I think a different question. Does that answer your question, Representative?
Honestly, Major, it doesn't, because it wasn't really the intent of the question wasn't to discuss how we are currently having conflict. It's more looking at, and I'll be blunt, the perception here is that the fox is in charge of the hen house, so to speak, right? The benefit of an independent review panel is just that, it is an independent review panel, and we can task that review panel with looking at specific areas of overlap, areas that cannot be addressed, or areas that we need to address. So my question was more in line of, are you aware of that process happening in other states? I know that the Maine Code of Military Justice is unique to Maine. It may not be similar to other states, but as a legislative body, we can adjust those policies to make sure that we get that communication and that overlap where we desire it. But we need to have that input first. Does that make sense?
Yes, sir. I think I'm thinking in terms, are you referencing the reviews that were conducted by National Guard Bureau for other states? That's the only situation that I'm aware of.
Well,
Yeah.
I guess I think we're confusing a couple of independent. You're talking about just Representative. You're talking about I guess a review of whether we need to make changes to the code, right?
Well,
and
sorry,
state.
Sorry, General.
Sorry,
I didn't mean to, yeah, sorry. If I didn't mean to, I just want to make sure I frame that question properly, right? Because I know you're right. We're getting in. We're not hitting the note. I mean, the recommendation was the creation of an independent review panel to examine the way sexual assaults are investigated, prosecuted, and adjudicated under the Maine Code of Military Justice. So yes, sir, you're correct. How we would focus in on, do we need to make corrections to the Maine Code of Military Justice in order to maybe better align with federal or get rid of some of these bureaucratic hurdles somewhere?
Okay,
that was the way
I think I see what you're saying, and I'm going to. I think I'm not exactly. I guess one of the things is we're not all sure exactly what the intent was in 2013 when all this came up, and there have been a lot of changes since then. And as Katie referred to, the way we handle, regardless, I don't mean it to diminish what the Maine code means or how we use it, but from my perspective, being not, I'm not a lawyer, right? My perspective is that so many changes and it is so prescribed exactly how, because of all the attention of how we handle these things, I think I jumped to the fact that, the way we do things is so prescribed. It is, if it's a criminal investigation, it goes through local law enforcement. If the burden of proof or the evidence or whatever in law enforcement doesn't take it on, doesn't prosecute, then it goes to the OCI. Again, outside of our chain of command, not the chicken in the hen house or whatever. They're based out of Washington D.C. They're trained and they're experts in these types of investigations. They come in with that administrative investigation that we then take and provide administrative solutions to. And so if there needs to be a better look, every state does their state code slightly different. Some have just adopted the uniform code. I think they call it something else, like it's a generic state code that I don't know what. At one point there was quite a few number of states that had that. There had been some conversations 5 or 6 years ago whether Maine wanted to adopt that uniform. I say uniform, it's like double uniform, but this generic state code. And the determination at that time in dealing with the legislature was, in some conversations was and dealing with our own JAGs was there were some unique things in ours that are helpful, not necessarily related and probably not related to this topic, but that there was a benefit to us having our own code. If we've missed the mark a little bit on what the intent was of this independent review commission on the Maine code, it's only because I don't know if we really understood the intent back in 2013, and the fact that our the way we handle these is not, we don't decide, we're not directed to determine, it's not the Maine code that's determining it. It is very prescribed exactly how we handle specifically sexual assault cases from the federal side. So,
thank you, General. I very much appreciate that. And being a former Navy person, I can't eat a meal without instructions on how to lift my fork. So I totally understand the prescriptive nature of the military procedures. I guess I'm looking at a way where I'm trying to figure out if the challenge is an administrative challenge because we get conflicting codes and we can't make them line up, or is it a challenge that we need to adjust the Maine code, the MCMJ, to some way to better reflect whether we adopt a portion of it that mirrors that generic code or something? How do we know what those recommended changes are? Obviously, DVM has a very, very strong input into that. But is there another independent view, for example, Mikasa or some other group that could come on and say, here, if your goal is to align things this way, here are the changes we would need to see? and then we
Right.
discuss what those impacts would be, right?
So I mean, I agree with that assessment. And I think that when we were going through our review to look at what actions that we would recommend, again, the way we looked at this and way our actions are kind of lined up are to say, what can I mean, we've got policies and regulations and guidelines and we've got plenty of it. Like you said, we've got plenty of that. But the way we had looked at it, and we kind of, between the JAGs and the sexual assault folks, they kind of looked at it and said, what are the, I mean, really it's the small things around the edges that the state of Maine could do that would help make this work and that we can do to make this more efficient. Again, the provost marshal I keep throwing out, but that's not really prescribed. And I guess the part of it is prescribed or alluded to, but the way we're using it is to facilitate and smooth the processes that are in place and that are directed. And so when we looked at the Maine code and we talked about the Maine code, we're saying what can change in the Maine code that would make our ability to live up to all your expectations easier, better, more efficient, whatever. And there wasn't really anything that jumped out at us. There were a few things of state law that we thought might be of use. And we've talked about a little bit. Some of those we've kind of discarded because we said, if some of these other things work, and if some of these things that we think are coming from on the federal side out of this latest NDAA and budget, that maybe we're premature in recommending those things until we kind of see where we're going. So I think that was the perspective we were thinking of the Maine code, was how could it help tweak around the edges, and nothing jumped out at us like, oh, if we added that would make our ability easier. And again, a lot of that is because most of the way we're doing criminal prosecutions falls under state law, not under the Maine code of military justice. It's the state statutes.
Thanks, Chair.
The chair recognizes Representative McCright.
Thank you, Mr. Chair. Thank you, General and staff. And I want to thank Representative Riley for bringing this forward. A couple questions. When we talked about there's no release from active duty if someone is harmed until they're released, does that include, are we talking specifically physical? Or are we talking about something like an emotional diagnosis, a mental health diagnosis, PTSD or something similar?
Hi there, this is Major Trost again. That really is in the medical lane, but if you have a condition and they encompass both physical and mental and psychological, then you'll be evaluated. And there's sort of a bunch of rules. So if we could take if you want some more information on that, I could wrap that up for you. I'm not super comfortable kind of going at length, but
sure.
Basically, if you have a broken leg and you can't walk out the door in any capacity, then that's the circumstances that would be in play.
Okay, thank you. Yeah, I was interested in the ones you can't see.
Mm-hmm. Yeah, for sure. I mean, that's obviously also in conjunction with this been a big part of the past 10 years.
Great, thank you. Another question, Mr. Chair?
You may proceed.
Thank you. I'm very interested in the retaliation the General mentioned. There's information out there. Does that cover what happens, not just for somebody to report retaliation, but for somebody to, but addressing it if somebody is retaliating?
That would be an independent basis of misconduct for the retaliator, and we can and do investigate those circumstances and punish or administratively act appropriate, not accordingly.
Great, thank you. And I was interested way back when Representative Riley was asking about data, and absolutely it needs to be confidential.
Mm-hmm.
So I was wondering when it's appropriate, Mr. Chair, I see Elizabeth Ward Saxel's here. I wonder if she could discuss that issue with us in general, and maybe it would inform what we're doing here. And my final point is, every profession does it, but you get the award for acronyms. It's been very helpful to follow along with the report, because thank you very much for defining them before using them. We all do
Just for the record, the Army acronyms are a lot worse than the Air Force acronyms.
Come on, sir.
Come on.
I believe you. Navy's probably worse.
They are, absolutely.
Thanks very much.
Are there any other questions from the committee for the general? The chair recognizes Representative Supika.
Thank you, Mr. Chair. And I wanted to echo Representative McCrate's thanks to Representative Riley, because I know that when you're a victim having to navigate a lot of bureaucracy and in a climate where people are hesitant to believe you when you speak out is really traumatizing. So I'm really grateful to you and also Representative McCrate for the questions that you've been asking. And a lot of the questions I had, General, have already been asked, but I have a note here. I understand that you have to check with three entities for data release. And so I understood that you couldn't say whether you could release data or not, but I was just wondering how long it would take you to check with those entities and when you'd be able to get like some idea of that back to us. I was unclear on that.
It depends. It depends on the data basically that we're talking about, and you know, and what we're all, you know, what everybody's comfortable with, and as far as releasing. And again, the smaller the numbers, the more difficult it is to get everybody on the same page of what can be released. And then some of it is, you know, when I think some of the things that we can generalize, and then whether or not that's adequate for what you're, you know, what you're looking for. I mean, I know that sounds evasive, but and there's some of the information that I would love to share, and that's but so we will release as much as everybody feels comfortable doing, and then and go from there, and hopefully it'll satisfy what you're looking for.
All right. Thank you very much, sir.
Are there any other questions from the committee for the Adjutant General at this time? Seeing none, thank you, Major, for being here, for answering our questions, for your team for being here and answering our questions. The committee is going to take a 10-minute break. It is 10:15. When we return, we will take public comment on this report from members of the public who are here to sign, who are here. No one has signed up. And so when we return in 10 minutes, anyone who is here to provide comment will just raise their hands and I will call you into the room. I will say before we go, I may say when we return that we welcome public comment. This is a sensitive matter, of course, and we simply ask people to respect the confidentiality of anyone who would need that confidentiality, whether it's a victim or even someone who is a perpetrator. We are not looking for any gotcha moments in this public comment section. If there is a victim who is willing to testify and prefer to have their cameras off, that would be perfectly okay with the committee as well. So with that, we'll take a 10-minute break and we'll return at 10:25. Joint Standing Committee on Veterans and Legal Affairs will be at ease. is now 10:25. If committee members who are returning to our meeting can turn on their cameras, please, so I know that we are here. We do not need a quorum to continue a meeting, but I always like to see 7 members present, if at all possible. On legislative time, 10 minutes might mean 15.
It's probably a good thing because 2 people just called and asked for the links and I'm emailing them to them. So,
Okay, great.
okay.
Thank you. So we'll just wait another few minutes.
Okay.
Welcome back to the Joint Standing Committee on Veterans and Legal Affairs. Committee members, if you could please turn on your cameras. We are going to move forward with the public comment portion of the report on Resolve 2021, Chapter 21 regarding sexual assault and the National Guard. I have promoted Elizabeth Ward Saxel to the panel in order to provide her public comment. Good morning, welcome. Please introduce yourself. We are not keeping a clock at this moment. Let us know who you are, who you represent, and the Zoom is yours. You may begin whenever you are comfortable.
Can do. Thank you so much. Senator Hickman, Representative Chiazzo, members of the committee. My name is Elizabeth Ward Saxel, and I'm with the Maine Coalition Against Sexual Assault, the organization you've heard referred to this morning as MICASA. We represent and serve Maine sexual assault support centers across the state and are here to provide some public comment. Thank you so much to Representative Riley for his tenacious support around these issues, and also to General Farnham for his work on this report, and also most especially to Maine's SARCs, who you've heard a little bit about, the sexual assault response coordinators with whom we work very closely. MICASA has worked very closely with the SARCs since they were created. And I, in fact, have, believe it or not, been sitting in my chair here at MICASA now for 22 years. And so I was around for the 2013 report, which we weighed in on at that time, and have been cheered both on the national and the local level to see how much progress has happened over this interim decade. Just a word about the SARCs, they rock. That's an official MICASA term for we really appreciate the work they do. They work in close collaboration with us on the statewide trainings that we provide on a range of issues. They are often participants. We try and include them as much as possible, and they're just lovely to work with. I also know over time, several of them have taken our required advocacy training for advocates, which is 40 hours plus, and some have actually served on our helplines within our communities. So they're really dedicated and lovely humans. Tina is a little newer to the scene, but we've really enjoyed working with her so far, as I'm sure you saw the work, her commitment to both prevention and intervention is really impressive. Yay. Victim advocate coordinator out of the main office there. I know this was something we were waiting on. I hadn't realized they had been hired yet. So I'm really looking forward to working with that individual as we chart a course forward. I know one of the recommendations within the report is that a seat be statutorily created on the Maine Commission on Domestic and Sexual Abuse. It's a commission I have served on for many moons and chaired for a good stretch. Still a member, and it is a really important place to have conversations about multidisciplinary issues related to domestic and sexual abuse. I know Tina has been attending, and we've been pleased to have her there and look forward to having them continue to participate. Let's see, what else? Also named in the report is an MOU with the Maine Coalition Against Sexual Assault. We welcome a more formal relationship with the National Guard around these issues, and are committed to doing this work with them, with or without an MOU. Let's see, what else am I missing? A couple of observations. Which are, I'm sure, obvious to you all because you work in National Guard issues all the time, but this hasn't been really my main neck of the woods. One is just how little time folks who are in the National Guard are in the National Guard. They're mostly in our communities, right? And so, you know, I think that is both an asset in terms of this work because we have so many great community-based resources. And so we're able to work in close collaboration. So our sexual assault support centers are helping support those individuals. It's not like being on a base where there are entirely insular programs. So I think that that's a distinct advantage for folks in the National Guard, but also the limited amount of time that they are doing that work. And the vast number of things that need to be gotten into that time is really a barrier, right? So, you know, we could say, gosh, we think that folks ought to have an extra X number of hours. And the reality is they don't really have those extra hours with all the other things that they have to, you know, by law get in. And so, you know, we have been very interested, you know, along Representative Riley's line of thinking to dig more into some of the training that they are receiving. But the other observation that I have is I think was very well articulated by the general, which is that they have really limited maneuverability. You know, it's the feds and the EO office that control the initial training around these issues. And so, you know, I think that there is some latitude to improve that training. And I believe they're working on doing that. And we look forward, frankly, to getting our hands on it and seeing what it's all about, which we haven't done before, and providing feedback. But you know, there's just, you know, unlike in so many other settings where we can say, all right, we're going to mandate this new training. We're going to mandate that everyone receive this and, you know, in these pieces and these pieces, there's, you know, they've got some very narrow lanes. Let's see, what else did I write down along the way? Representative Riley, yes, we'd be very happy to be involved in the annual report. We'd be thrilled to be involved in whatever way we can in this process. There's also some questions about the availability of legal support, and I would underscore, I don't know a ton about the program, but Maine Sexual Assault Support Centers have a special relationship with Pine Tree Legal. A number of years ago, Pine Tree Legal Assistance created with our kind of support and collaboration, sexual assault specific attorneys across Maine. And those folks are focused. What happens is folks, survivors come and seek services from our sexual assault support centers, and then they get referred over to Pine Tree Legal, to these very specialized attorneys. And so what's super cool is that it is just not a thing that normally people focus only on sexual violence within their practice. It's pretty much unheard of in the country. And so these folks are amazingly skilled. And they also, a thing I know very little about, have a veterans legal program down there. So it really seems to me that there are some additional opportunities there to be taken advantage of around additional legal supports for survivors that I don't fully understand, but I'm looking forward to digging into more. And then there were a number of conversations about data, and I couldn't agree more that data is critical. And I think we need to get our eyes on data, and that there are many ways to do that that do not identify victim survivors, because I'm sure you know that's the very last thing that we have any interest in doing. Victim confidentiality is among our chief tenets of what we think is most important. And also data in this area is really challenging because we know that sexual violence is the most chronically underreported of all violent crime. What the data tells us often is very hard to understand. So, counterintuitively, when I see Maine's, crime in Maine stats, how many people have reported sexual assault to law enforcement, and it goes up, I celebrate. Most people are like, oh no, it looks like sexual assault has increased. Look at all the additional reports to law enforcement. And I say, oh, more of the underlying folks who have experienced this crime are coming forward. And so in that same way, I think if we are doing our job well in this space, we would hope to see an increase in sexual assault stats. And we need to be really careful to try and understand what that means. Because I would argue that in general, over the last 10 years, we've seen very little change in the underlying prevalence of sexual violence in institutional spaces, in our communities, and not for lack of trying, I swear, we're committed to it. But it's a hard nut to crack. And so, again, my typical response when we see numbers going up is to say, this is good. There's more that's coming out into the community. All right, so I think those are my random rambling thoughts based on what I heard previously. Be happy to answer any questions you might have.
Thank you for being here and for shedding a perspective on statistics that seems counterintuitive and also makes total sense. The chair recognizes Representative McCreight.
Thank you, Mr. Chair, and thank you, Elizabeth Ward-Saxel, for all of your comments. I had asked for your input around the data issue because I know you deal with it constantly. I don't know if there's a roadblock here because of, I don't know if there is one, first of all, with this report. And I don't know if there is, if it's because of different regulations, but I do know that there's a way that we can get at data without revealing private information. And we, as you said, have to protect that information. So I don't know if this fits with the collaboration that's going on, but I'm wondering if that's within all the regulations and restrictions, if there's a way that MICASA could help in making sure data that is needed so that we can see patterns. We can see if we're getting more reports. We can see if maybe we get something that works or doesn't, so we know and can focus in the right way. So I don't know if that is something you can do, but that's something I would put out there. Thanks.
Absolutely. Thank you, Representative. My understanding is, and again, my knowledge in the National Guard space is very, very, very small, but there is a set of data around these issues that has to be publicly reported every year. I actually haven't even seen that. And so I'm interested in starting there with what is, by all accounts, public data, and then figuring out what that tells us and what questions it raises for us, and whether or not there are ways to dig further. It's my understanding, though I don't think you can say, but I'm not sure it's public yet on a public live stream. But my understanding is that we are going to have a seat on this, I don't know what it is, commission work group that's been discussed in the report. And that feels like a great space to, as part of an early meeting, to review what is available and to do that kind of group process to think about, again, what's missing, what else we need to know, et cetera.
Are there any other questions from the committee for Elizabeth Ward Saxel? Seeing none, we thank, the chair recognizes Representative Riley.
Thanks, Mr. Chair. And thank you, Elizabeth, for coming today for representing MCASA. I was just wondering, has MCASA seen any of the climate assessment surveys? And I was just wondering what your thoughts are on those. Okay, you haven't. Okay.
I would love to see them. I mean, and in another space right now, in EDU, we're talking about campus climate assessments, and and those questions are so important, how they're framed. And yeah, I'm really psyched to see that for the National Guard, and I'm hoping that will also be part of this process as well. So yeah.
Are there any other questions from the committee? Seeing none, we thank you for your work and your advocacy and all that you do for victims of sexual assault throughout Maine. We appreciate you being here today and providing comment. Next, we have public comment coming from Representative Patty Hymanson. Representative, please introduce yourself and the floor is yours.
Thank you. Thank you, committee, and thank you for promoting me and inviting me here. Thank you, Senator Hickman and Representative Chiazzo and the entire committee. And spread of thank yous to Representative Riley for introducing this bill. It's very important. I'm here as a representative of House District 4, which is parts of York, Wells, Sanford, and all of Ogunquit. I am a survivor of sexual assault. In college, I was pulled into an alleyway and sexually assaulted. After that, it was difficult to report it because I didn't want to be exposed. I didn't want anyone to say, why were you walking down a dark street in the middle of the night? What were you wearing? What did you do to promote that kind of behavior? I didn't want to see the person who assaulted me. I didn't want to stay on college campus knowing that somebody knew who I was. And so I told my roommates, and I had somebody check my closets on occasion to make sure no one was in there, even though I told them, I know this is silly, but could you look under my bed and in my closet? And then it passed with, the help of my friends. I was also hit across the face with a switchblade during that time. So I had that to deal with. So I wanted to bring that to your attention because I'm deeply aware of how difficult it is to come forward and that women have to suck this stuff up. So this is a culture change that I'm concerned about. And I've been listening to this morning, and I'm grateful about the climate check. And I do hope that you get to see that and understand that, because I think that this is where it starts. And it's a deep culture change. It doesn't start in the armed services. It starts in our streets and our culture and moves into that space. So, knowing, a clearly articulated, once people come into the armed services space, of what is flirting, what is sexual verbal abuse. It's often easier to know what sexual assault is because someone is physically injured. But those preemptive attacks are often sucked up by women because it's part of our culture. And then it's accepted as it moves along. So I wanted to make sure, and I see that you are interested in that culture change. It's deeply difficult, but there needs to be accountability. And you need to understand what the culture in those interactions is, because if you're only dealing with the assault side and who's accountable and who then the proverbial horse is out of the barn, all that kind of stuff. So I'm grateful that you're having this conversation. I was a vaccinator at the Armory as a physician, and I had the pleasure of working with the National Guard, and there were a few women there, and I'm sorry to say I lost my chance to talk with them. I just didn't feel it was the right time, but I wish I had done that. So I'm grateful that you're having this conversation. Thank you.
Thank you, Representative, for sharing your experience. And we are grateful you survived it and that you joined us here today to move this conversation along because it's tough. Are there any questions for Representative Hymanson from the committee at this time? Chair recognizes Representative McCright.
Thank you, Mr. Chair. Thanks so much, Representative Hymanson, for sharing. Very much appreciated. I would like to just add a footnote that this is happening not just to women as we talk about culture. And I think we've had some significant culture shifts where I hope, where we're recognizing what's been happening to women and sucking it up, as you said, is exactly right. And I would just want to add, not to your story or your experience at all, but just that we're more aware that we're talking about people who are transgender, people who are male, female. So I just needed to add that. But mostly I wanted to thank you for sharing. It's really important to the conversation.
Thanks.
Thank you, Representative. Are there any other questions for Representative Hymanson? Seeing none, thank you for being here today. Again,
Bye, everyone.
is there anyone else who is attending this meeting who would like to provide public comment on the subject of sexual assault in the National Guard? If you are, please raise your hand. And again, I will say, just in case people didn't hear me before, we are taking this public comment. We are respecting the confidentiality of anyone else we are talking about who is not ourselves. And of course, people are able, if they are not comfortable with their cameras on, to provide the testimony with their cameras off. That said, welcome, Tyler Backus. The floor is yours, sir.
Hi, so like Representative Hickman said, my name is Tyler Backus, and I do like to always kind of point out, because I do work for Maine Department of Education, that I'm not here representing them. I am here on my own time. So I am a 20-year veteran of the military, and so I did want to kind of provide a different viewpoint. I've never been a victim of it, but what I have been is I've overheard over 1,000 disparaging comments about people from the other sex, from service members. I mean, just even simply from the time I got into the military, I was in basic training at Fort Knox, Kentucky, and we would go on marches. And when we were far enough away from the main part of the base, then the drill sergeant would go, oh, now we're going to do this cadence that we can't do back at the main part of the base, which was a disparaging cadence about women. And so that really sets the culture up within the military to be negative. I've also, I was in actually a training in the Vermont National Guard. So I've been active duty. I've been in the Vermont National Guard where I grew up, and I've been in the Maine National Guard. And so at my time in the Vermont National Guard, we actually had a presenter who was talking about, it was when Don't Ask, Don't Tell first went away. And so we had a presenter talking about new regulations and how those would affect the guard. And she got jeered by the members in the audience, members of the unit that I was part of, throughout the presentation. And the leadership of the company didn't actually say anything about any of the comments. So again, it's showing the acceptance of those comments. I was that same unit, our readiness NCO, who's a fairly high up person within the unit. I mean, it's an E7, had actually been sent back from the unit had been getting deployed to Iraq, and the readiness NCO got sent back to Vermont because they had gone to a strip club and he had inappropriately touched the stripper during a lap dance. But beyond that, nothing happened to him. He was just sent back. I was part of another unit where, though the commander was removed through the reporting process, the person who reported the commander for inappropriately, and I don't necessarily know what went on, but everybody knew who had reported the commander, and she was not treated particularly well by the rest of the members of the unit. And so I just want to, and I only retired from the military in 2016. It's not as if this is distant past. This is somewhat fairly recent. And I would say that, and I mean, though I wasn't ever, I never had anything around sexual abuse, it is a bigger part of the culture of, being part of, it's always kind of referred to as the boys club. I was in a brigade. I was at the brigade level, going to school for military intelligence. And since this period of time, my wife has been diagnosed with depression, but while I was at school, and we weren't married at the time, but she had something going on at home where she really needed me to come back. And so I tried to fit. And so what I was able to do is the school was put into, I think, 3 or 4 different sections. And I was able to finish the first 2 weeks of an 8-week school, but I had to come back, I needed to come back for her, and I was removed from the position. So it's, although I certainly, I don't want to take any focus away from the sexual assault. It's actually, it's bigger than that. And actually, so I've, been talking about talking to people who have been in the military, like myself, and who are still in the military. And one of the things that, we kind of talked about was, we do fill out the climate culture survey, but as a soldier in a unit, we never know what the outcome of those climate culture surveys are. We fill it out, we turn it in, whether it's online or, it used to be in paper. And to us, there was no point to filling it out because we never saw any changes. And then the other thing I wanted to kind of note was, and this, I think this is the last thing I'll note is just, being able to know how to report. I was in the military for 20 years. I'm I have a master's degree, and fairly educated person. I know the legislative process. There's all kinds of things. No, I never remember seeing anything, or if it was posted, I couldn't tell you of where it was posted, of how to report if something happened to me. And obviously seeing it occur with another person in a unit I was in, even if you do the right thing and do it through the right channel, it gets back out and on who reported. And there may not be, any way to kind of take that away 100%. But, I think it could be better than what it is. And I also, So lastly, I just want to note, because I do work with General Farnham, and General Farnham is great. And I think he's probably the person to kind of fix this and make it better. And so I think he's of the right mentality to kind of, move this forward.
Thank you for your public comment today, Tyler Backus. Are there any questions from the committee? Chair recognizes Representative McCray.
Thank you, Mr. Chair, and thank you, Mr. Bacchus. I just wanted to thank you because you highlighted something that hadn't hit me as well until you talked about it, and that's the impact on everybody around the situation. So the broader culture that it affects everybody and does harm to everybody. So the steps that you suggested need to be improved are critically important. And I think Representative Riley's taking notes. So thanks so much for sharing.
Are there any other questions from the committee? Seeing none, thank you very much for sharing today. Is there anyone else in attendance who would like to provide public comment on the subject at hand regarding sexual assault in the National Guard here in Maine? Seeing no other hands raised, I will close the public comment on this topic. I will thank Representative Riley for his tremendous work on this issue. The chair is a survivor of violent sexual assault. And so it is encouraging to see that we are publicly having this conversation, knowing that we can do better and believing that we will. So for anyone here who is participating in our work sessions for later today that are on the schedule, we are going to take a break. And I will apologize for that. We do our best to get our schedule right. When we come back at 11:30, we will begin community introductions, committee introductions all over again. For people who are watching, we will take up LD 2001 first. We will follow that with some update on LD 619. We will then move to LD 1980, followed by LD 1957, and we will close the day with LD 1930. We have, during this morning's presentation and public comment, received a great deal of information about the bills that we have left in our possession. Today is March 11th. It's our day to vote. And so I'm going to give that half an hour so that all of us have an opportunity to breathe from this morning's presentation and comment, and then join in caucuses to discuss the work ahead so that we can use our time for the rest of the day in the most efficient manner. But we will be thorough, as we always are. The Joint Standing Committee on Veterans and Legal Affairs stands at ease until 11:30. VLA Democrats, the caucus link is the same as always, and the room is open. You can join it whenever you are ready to join it. It's 11:33. As members rejoin the committee, please turn on your camera so that I know that you're here and we have a forum. We intend to sort of begin again, have introductions, and set forth the agenda for our late morning, early afternoon. 1, 2. So welcome back to the Joint Standing Committee on Veterans and Legal Affairs. My name is Craig Hickman. I represent District 14, 11 towns in Southern Kennebec County, including my hometown of Winthrop. This part of our day will be dedicated to work sessions. We will not be taking comment from the public. Anyone who will be in front of the committee will be at the leave of the chair. We have 5 pieces of legislation that we are going to work today. We begin with LD 2001 regarding the veterans' homes in Caribou, Machias. We will move then to LD 619 regarding burial at Southern Maine Veteran Cemetery. We will then move to LD 1980, LD 1957, and we will end with LD 1930. I will ask committee members to reintroduce or introduce themselves, beginning with Senator Farron.
Good afternoon, Mr. Chair. My name is Brad Farron. I reside in Norridge Walk and have the honor of representing the majority of Somerset County in the Maine State Senate. Thank you.
Representative McCray.
Good afternoon. Oh, not quite. Good morning still. I'm Jay McCray, representing Harpswell, West Bath, and Northeast Brunswick in the House.
Representative Corey.
Good afternoon. My name is Patrick Coy. I represent House District 25, which is part of Wyndham.
Representative Kinney. Representative Wood.
Good morning still. I am Barb Wood and I represent House District 38, which is the western end of the peninsula in Portland.
Senator Miramont.
Hello, Dave Miramont, representing Senate District 12 here in Knox County with the county seat of Rockland.
Representative Sapika.
Good morning. I'm Laura Supika, and I represent House District 126, which is a portion of Bangor.
Representative Riley.
I'm Representative Riley. I represent House District 34, which is part of Westbrook.
And Chairman Chiazzo.
Good morning still. I am still Representative Chris Chiazzo. I still represent House District 28, and West Scarborough is still as beautiful as ever.
We also have with us our analyst, Sam Prower, and our committee clerk, Darlene Semino. I will open the work session on LD 2001, an act to fund and support the veterans' homes in Caribou and Machias and require legislative approval for the establishment and closure of veterans' homes. Sam, can you please introduce your bill analysis?
Yes, Senator Hickman, I'm happy to. Just give me a second to pull it up on screen. All right, can everybody see this? So before just moving in, and I'm not going to take too long with my bill analysis because there have been amendments, or there are going to be amendments introduced that also change the way the original bill was drafted. But so I just wanted to let you know that at the outset. But LD 2001 is an act to fund and support the veterans' homes in Caribou and Machias and require legislative approval for the establishment and closure of veterans' homes. As printed, this bill requires the Board of Trustees of the Maine Veterans Homes to obtain legislative approval for the establishment or closure of a facility managed by the board. The bill requires the Department of Health and Human Services to amend its rules to allocate emergency payments made in fiscal years 2021 and 2022 and 2022-2023 to the veterans' homes located in Caribou and Machias. And the bill provides one-time appropriations and allocations for the emergency payments. I've provided the committee a link to the chapter of Title 37B that established the Maine Veterans Homes. This will take you, and you'll you'll see all the provisions applicable to Maine veterans homes. I noted that at the public hearing, the sponsor, President Jackson, provided an amendment to the bill, and you all should have that in your inbox with my work session materials this morning. And then also Senator Hickman will be introducing an amendment today at this work session. When it comes time to talk about that, I'm happy to walk the committee through it or let him walk you through it and just answer questions that you might have. And then what I have listed here were just some technical issues and other issues for consideration that the committee might want to think about. And these are largely based on the original draft of the bill. And so I won't walk you through them one by one unless there are questions, but I point these out because there are good things to think about when the committee is thinking about how you want to approach this. And one thing I wanted to point out in particular is that if you're going to require legislative approval to close a home, you should be clear about what that approval looks like. And also at what stage in the process does the board or the CEO have to come to the legislature to receive that approval? And as I noted here, it's actually not clear in the law by what process closure actually happens. And since the bill only, as drafted, only addresses decisions made by the Board of Trustees, it's possible that it could be too narrow to actually guarantee the outcome that homes don't close without legislative approval. I have answers to these questions, or not answers, but I have thought about how the committee could word such a requirement if you're interested in doing that. So just know that if you have questions about these, I'm happy to walk you through how you might achieve doing whatever it is the committee decides. And then the last thing I will note for the committee is that you've all been sent a letter provided by the AG's office at the request of the committee from the public hearing that addresses some of the legal issues that were discussed at the public hearing. And I believe that both, I think it's Tim Stiegelman and Chris Taub are here from the AG's office if you have questions for them about that letter. And with that, I will turn it back to the committee unless there are questions for me. And like I said, I'm happy to walk you through either of the amendments that were being proposed for this bill.
Thank you, Sam. If you could stop sharing your screen, I'd greatly appreciate it. We did finish the public hearing on March 2nd at about 10 minutes of 7. And the last request for work session was to get an Attorney General opinion on the claim made during the public hearing that the bill as drafted and presented to committee would be unconstitutional. The letter that the Attorney General sent to the committee yesterday reads as follows. This letter is provided in response to a request from the Committee on Veterans and Legal Affairs for an opinion from this office regarding the constitutionality of LD 2001, an act to fund and support the veterans' homes in Caribou and Machias and require legislative approval for the establishment and closure of veterans' homes. This opinion assumes that the relevant votes of the Maine Veterans Homes Board of Trustees were properly conducted in accordance with law and focuses on the constitutional issues raised before the committee at its March 2nd, 2022 public hearing. Part 1, Purpose, Structure, and Legislative History of Maine Veterans Homes. Maine Veterans Homes was created by the legislature for the purpose of providing long-term care support and related services to eligible veterans and family members of veterans, 37B MRS Section 601. MVH is also authorized to provide non-nursing care and services to veterans under certain circumstances. MVA must operate public homes for veterans in Maine. We are aware that an earlier iteration of the MVH statute referenced the Augusta MVH facility and listed municipalities where MVH was authorized to build additional facilities, including in Caribou and Machias, while affirmatively requiring that MVH's Board of Trustees plan and develop the Machias home and any non-nursing facility care and services. with certain spending limitations, see 37B MRS Section 601 version effective until July 28, 2016. A 2016 amendment removed references to specific locations. Public Law 2015, Chapter 397, Section 4 from the 127th Legislature, LD 1524. The legislative history notes that specific veterans' homes locations were removed, but does not explain the purpose for that removal. In testimony last week, both Senate President Troy Jackson and former state representative and now U.S. Representative Jared Golden stated that the 2016 amendment was focused on revenue bonds and expanding MVH, increasing MVH's borrowing authority from $15 million to $50 million, and that removing the locations from statute was technical in nature and not indicative of any intent to allow MVH to unilaterally shut down existing facilities. But even if that had been the intent, a future legislature would be free to reimpose limits on the closing of facilities. Part 2, administrative and procedural posture of the MVH board vote to close the Machias and Caribou facilities and applicable licensing requirements. The MVA board initially voted on October 28, 2021 to close the Machias and Caribou facilities. The board then voted on January 27, 2022 to approve the closure plan. On February 9th, 2022, Governor Mills wrote a letter to the board asking it to reconsider its decision to close the Caribou and Machias locations. The board reconvened on February 11th, 2022 to consider Governor Mills's letter and voted 10-1 to continue with the closures as planned. MVH Caribou is licensed both as a nursing home and as a residential care facility, while MVH Machias is located only as a residential care facility. As a result, these facilities are subject to the Department of Health and Human Services, Division of Licensing and Certification, DLC, regulatory oversight, 22 MRS, sections 1811 through 1833, 7801 through 7807, 7851 through 7863. Maine nursing homes are also subject to federal laws and regulations. Pursuant to state and federal requirements regarding voluntary license surrender, MVH Caribou provided notice to DLC of its decision to close the Caribou Nursing Home facility and submitted a closure plan in accordance with 42 USC sections 1320A, 7JH, 42 CFR section 48.701, 22 MRS section 1822, 10144 CMR chapter 110 section 3I. No closure plan is required for the Machias Residential Care Facility or the residential care portion of the Caribou facility. Both MVH Caribou and MVH Machias must comply with voluntary surrender requirements to provide notice to residents and to ensure residents a safe and orderly discharge or transfer. Citations follow. MVH Caribou and MVH Machias must retain their licenses and comply with regulatory requirements while they remain in operation. MVH announced a target date of April 15th, 2022 to close the Machias facility and a target date of May 1st, 2022 to close the Caribou facility. Part 3, LD 2001. As currently drafted, LD 2001 would require legislative approval of the establishment or closure of any MVH facility. Section 1 amends Title 37B, Chapter 11 by enacting a new provision. If the Board of Trustees of the Maine Veterans Homes proposes the establishment or closure of a facility managed by the board shall submit its proposal and suggested legislation implementing the proposal to the Joint Standing Committee of the legislature having jurisdiction over matters related to veterans, which may report out a bill based on the proposal. The board may not establish or close a facility managed by the board without specific legislative approval. Questions have been raised regarding the lawfulness of LD 2001. Part 4, analysis. While we are unable to say with certainty how a court would resolve a legal challenge to LD 2001, it is our view that it would likely withstand any challenge. Primarily, this is because MVH and the MVH board are not private actors, but instead governmental entities created by the legislature. Citations follow. Determining MVH and the MVH board are state agencies for purposes of Maine's Freedom of Access Act based on then existing statutes. See also Maine PERS Annual Comprehensive Financial Report for the fiscal year ended June 30th, 2021. MVH is a participating employer in the Maine State Retirement System. As a governmental entity, MVH's existence is wholly dependent on the will of the legislature. The legislature may at any time abolish MVH. Citations follow. Addressing the effect of legislative abolition of the former Board of Corrections. Subject to constitutional limitations, the legislature also has the authority to expand, contract, or modify MVH's statutory powers, organizational structure, or any other part of its governing statute. Citations follow. As drafted, LD 2001 would require legislative approval before MVH opens or closes a facility. This is not novel, as the legislature routinely requires state agencies to seek legislative approval prior to taking certain actions. See generally 5 MRS regarding legislative review of major substantive rules. MVH's licenses do not foreclose LD 2001's effectiveness. MVH facilities must have and maintain certain licenses to operate. Having received those licenses, MVH must operate in conformance with those licenses or face discipline, including potential involuntary closure. The licenses do not, however, inhibit the legislature from imposing constraints or limitations on MVH's operations. LD 2001 would not appear to violate MVH's due process rights to the extent it even has any as a governmental entity. The current matter under consideration by the legislature is simply an amendment to MVH's organizing statute and is firmly within the legislature's prerogative. We also note that if the legislature were to amend LD 2001 to make it retroactive, such an amendment would be defensible. Although the legislature's rule of construction generally disfavors retroactive effect, see 1 MRS section 302, quote, the legislature may appropriately amend a statute and have it take effect immediately, and it may, within the bounds of the Maine Constitution, make such a change retroactive and thereby undo what it perceives to be the undesirable past consequences of a misinterpretation of the legislature's work product. McImage of Maine, LLC versus Androscoggin County, 2012, Maine 44, Section 23, 48, 3D 975, quotations and footnote omitted. In sum, we did not identify any significant constitutional concerns with LD 2001, and in our view, the legislature may exercise oversight over the operation of the MVH, including imposing constraints on its closure of facilities. I trust this information is helpful. Sincerely, Aaron M. Fry, Attorney General. With that, I will invite, Sam, you said it was Timothy Stiegelman?
I believe so, but if I've mispronounced his name, I sincerely apologize to him.
As do I. And was there anyone else here from the Attorney General's office?
I believe Chris Taub is here as well.
Chris Taub, I do not see. There we go.
Mr. Chairman, Tim Steigelman, Assistant AG.
Good morning, Mr. Steigelman. Did I say that correctly?
You did, Mr. Chair. Thank you. Good morning to you and to the distinguished panelists on the committee.
Thank you. Would you like to provide any comment? I will certainly ask committee members if they have any questions for you, but since you are a part of the office that wrote that analysis, I give you the floor.
No, thank you, Senator. I have nothing further to add. I understand the committee has the letter in front of them, and I welcome questions that may come up. Thank you.
Thank you. The chair recognizes Senator Farren.
Thank you, Mr. Chair. Thank you for being here and for providing that response. One of the questions interpreting, I'm not a lawyer, so I take that to read through that in the Attorney General's opinion that, MVH is kind of an instrument of the state because we created and went through. If we make changes without providing funding, are we providing some kind of unfunded mandate for them because we don't address that funding piece as well.
Thank you, Senator Farron. I understand the concern, I think, and what you'll see in footnote 3 of the letter, that funding issues, especially if there's an allegation I understood from last week's testimony of potential underfunding, that could raise separate issues, but it doesn't go to the constitutionality of such a law in the first place. I would also note, I think, I have it here. Last time I saw LD 2001, there is some additional allocations in there of additional funding to Maine veterans homes. And so I think the discussion from last week was about whether that's adequate or inadequate. But again, that doesn't go to the heart of the question of constitutionality. Does that answer your question?
I believe so. I mean, really the funding piece is a separate component of the Attorney General's opinion of the constitutionality of the law.
Yes, that's correct.
Okay, thank you.
Thank you.
We also have Mr. Chris Taub, if I've said that correctly, pronounced it correctly, from the office. Will you please introduce yourself since you are with us, even if there may not be any other questions, sir?
Good morning, everyone. My name is Chris Taub, and I'm the Chief Deputy Attorney General.
Thank you for being here. Are there any other questions from the committee for the Office of the Attorney General? Seeing none, we appreciate you being here, and just in case, we will ask you to stay in the attendee room as we deliberate, because we may need you to answer a question throughout our process today. We do appreciate you taking your time to be here for the committee as we deliberate this very important issue. Thank you.
Thank you, Mr. Chair. Thank you.
With that, I will ask Sam, please, to walk the committee through the amendment that I am proposing. It's a strike and replace amendment for the committee to consider this morning and early afternoon.
Certainly. I'm going to pull it up on my screen so the committee can see it. And again, this was included with the work session materials I sent the committee this morning. And as I stated at our last work session, I apologize for sending you so many things. I've tried to make it clear at the titles of the documents which bill they're related to by writing RE and then the bill number. So in this case, it's RE 2001, Senator Hickman Amendment. So, as Senator Hickman mentioned, this is his proposed amendment to LD 2001, and it's a strike and replace of the bill. The first thing it's going to do is amend the title of the bill to read an act to clarify state policy and legislative intent regarding Maine's veterans' homes to require notification of closure to the legislature and to fund public homes in Caribou and Machias in order to keep them open. The bill is, this amendment is going to turn the bill into an emergency, as you can see here. So the first thing we do is we add an emergency preamble. I won't read through it. And moving down, now we get to the place where the bill strikes and replaces the original bill. So, or the amendment strikes and replaces the original bill. So, this is making a number of changes to the chapter of Title 37B that establishes Maine veterans homes. As you can see here in section 601, it's establishing the policy and intent of the legislature and establishing Maine veterans homes, and that Maine veterans homes must be located in the counties of Aroostook, Cumberland, Kennebec, Oxford, Penobscot, and Washington. I'm sure the committee will might have questions for me about putting in things like intent and purpose clauses into bills, and I can talk to you about that if and when there are questions. But for now, I'm just going to keep presenting the bill, the proposed amendment to you. Moving down in section 2 of the bill, it's amending the Board of Trustees to add 3 civilian members appointed by the governor. And it's requiring that those three civilian members are not on the list of nominees that were recommended to the governor per the first few sentences of this statute. So moving forward again, it's, you know, in addition to adding 3 members, it's also going to, or adding members is also going to increase the quorum requirements here. Moving down, it's going to require that Maine Veterans Homes shall seek permanent funds or contributions from such state or federal agency, person, firm, or corporation, either independently or in conjunction with state funds appropriated or allocated, in order to ensure the continuous operations of the homes. Moving down, it's going to require that the Board of Trustees follow the Administrative Procedure Act when adopting rules, and also require that they submit an annual report to the governor and the Joint Standing Committee of the Legislature having jurisdiction over Veterans Affairs. And that the report, and that's going to be by February 15th of every year, and the report is going to be required to contain a copy of audited financial statements, statistics on members who resided in the homes during the year, any amendments to the rules necessary to administer the homes, recommendations to the governor and the legislature, and such other matters as the board deems pertinent. It's also going to allow the committee to report out legislation based on that report.
And Sam, if you could just stop right there for a second, I just want to clarify. I think you said this would require an annual report. It is my understanding that the law currently requires an annual report. This suggested proposed amendment simply adds a few more sentences to what is already required by NVH's board. Is that correct?
Yeah, I apologize for the, that's an important clarification. And you can see in the original language that's not added, you see the board shall submit an annual report to the governor and the Joint Standing Committee of the Legislature having jurisdiction over Veterans Affairs. Apologies for not making that clear initially. And then it's going to, so moving forward, bill is going to establish requirements that the Maine Veterans Homes Board of Trustees and Chief Executive Officer must follow when authorizing the discontinuation of services at a veteran's home. And that's going to be in this new section, section 612. And I didn't summarize all of the different components of this. I'm sure Senator Hickman will be able to speak to the process and things included here. But as one thing that's distinct about this from the original bill is it's requiring a process before closure that the original bill did not provide, and it's not, and then it's providing the committee again with the authority to report out legislation. And then finally, the last section of the bill is an unallocated section, and it's going to require the Board of Trustees, in collaboration with the Commissioner of the Department of Defense, Veterans and Emergency Management, and the Commissioner of the Department of Health and Human Services, to convene a group of relevant stakeholders to develop a plan for the long-term viability and continuous operation of the Maine Veterans Homes locations designated in Title 37B, Section 601, and report the plan to the Joint Standing Committee of the Legislature having jurisdiction over veterans matters in its annual report presented to the committee in February 2023. And then the last thing I'll say just before turning this back over to the committee is, I know Senator Hickman was working on this, for much of the week, and I helped him put this in like a amendment format prior to the committee meeting today. The language here might have to be tweaked, and some details might have to be ironed out prior to the final version of the language. I just didn't have time to help him with that before the meeting today. So if there are questions on clarification or specific wording, I'm very happy to help the committee with that. So that is all I have at the moment.
Thank you, Sam. I am going to request, please, sir, that you read the language that is in the discontinuation of services section of the amendment, because I think it's paramount for anyone who doesn't have this up on their screen, who may be watching on YouTube, to hear what the proposed amendment would require from the Board of Trustees of the Maine Veterans Home or the Chief Executive Officer if they have to close a home.
Absolutely. So this is going to be a brand new section within the Maine Veterans Homes statute. And it reads, Section 612, discontinuation of services. If the Board of Trustees of the Maine Veterans Homes or the Chief Executive Officer of the Maine Veterans Homes authorizes the discontinuation of services or care in any public homes that have been established in any region of the state pursuant to Section 601, the Board or the Chief Executive Officer must notify the President of the Senate, the Speaker of the House of Representatives, and the Joint Standing Committee of the Legislature having jurisdiction over Veterans Affairs within 3 days of the decision and at least 45 days before submitting a plan to close the homes to the Department of Health and Human Services pursuant to applicable laws, rules, or regulations. Within 10 days of receiving notification under this section, the Joint Standing Committee of the Legislature having jurisdiction over Veterans Affairs, with as much public notice in advance of the meeting as possible, shall convene a meeting where public comment must be invited. At the public meeting, the board shall present its financial reports and demographic data for the regions served by any home approved for closure, including, but not limited to, information supporting that the home is no longer necessary to meet the needs of eligible veterans and their families in the region, the board's plan for the care of veterans and their family members currently receiving care at the home, and the board's plan for the use or disposition of the facilities after the home is closed. The committee may report out legislation based upon the board's presentation and public comment at the meeting.
Thank you, Sam, for that reading of the new provision of law that would describe the process for a board authorization to discontinue services at one of the homes in statute. You may stop sharing your screen. The chair recognizes Representative McCright.
Thank you, Mr. Chair. Just a question going back further where the different areas, locations are listed. The way I read it, it's saying there could be more, but there have to be these. Is that right? I'm asking Sam or Senator Hickman.
I don't want to jump in front of Senator Hickman, but I'll let him answer what his intent was, and then I can say whether the language does it.
There could be more. And because we are prescribing a process for closure, there could be fewer.
Okay. But we've restored the naming of them here, but there's a process. Okay, that helps. Thank you.
This amendment restores the locations where they currently exist to the law. They were removed as a technical change back in 2016, and also provides a few other details to update the enabling statute. Yes.
Right. And one more comment, just I want to make sure at some point we invite the sponsor, Senator Jackson, to weigh in on the amendment. Thank you.
You're welcome, Representative. The bill sponsor and the President of the Senate has been promoted to panelist. He is with us, his camera is on. And so I will first turn to Sam, then to the bill sponsor, and then I will recognize Representative Chiazzo. Sam?
Thank
you. Went on mute.
I just muted myself. Thank you, Senator Hickman. So I just wanted to clarify one piece when it comes to the closure of any of these homes, which is that because the bill is going to put the locations where they must, where homes must exist in statute, the legislature will have to remove those locations if any of those were to stop operating or be shut down. So that would be part of the discontinuation approval process that's at least as the way the bill is drafted currently.
Thank you, Sam, for that clarity. President Jackson, you may have some questions from other members of the committee, but I will first ask you if the strike and replace amendment that the chair is offering, having worked in collaboration with the department and the administration, is something that you see or not?
Thank you, Senator Hickman and Representative Chiazzo, members of the Joint Standing Committee on Veterans Legal Affairs. State Senator Troy Jackson. I'm here in Allagash today and have been trying to get my van fixed, so I'm a little bit underdressed for this prestigious committee, but I wanted to say that I actually been listening throughout all morning, and I think that Senator Hickman has done an unbelievably fabulous job crafting this. Of course, there's been a lot of discussions since we presented the bill 10 days or whatever it was ago. But I think it's very well done. The idea that, the funding is not included or is not the right amount. Of course, whenever we found out, we were told there's no amount of money that could keep these facilities open. So I had no idea what to include in there. And I understand that there may be another funding stream coming forward here shortly, but as far as the policy of keeping the facilities open, I feel, like I said, very strongly that the veterans homes are going to get the amount of money that they need to keep these two facilities open. But as far as the policy of keeping them open, I think this lays out a very good policy, something that's fair to the people that are in the homes and the families, the public, and to the legislature going forward. And putting those names back in, I think gives me a lot of assurance that something like this won't happen in a way that was so dramatic and really so unfair to the families and residents of these homes. So I feel very good about what Senator Hickman came up with, and I hope that the entire committee will endorse this process to make sure that we put a pause on this and then get the funding and then do whatever else we can to make sure that these homes are going forward, doing as well as possible.
Thank you, Mr. President. The chair recognizes Representative Chiazzo.
Thank you, Mr. Chair. I don't necessarily know if this is a question for the Senate President or not, but welcome to chime in. Yes, the first question for Sam is, this process, is this a unique process that we're coming up with, or are there other is there a model that we're basing this off of? That was for Sam, through the chair, if I may, please.
You may, Sam, you may answer.
Thank you, Representative Chiazzo. I don't know if I can answer that at the moment. I am not aware of other processes we have, for example, where we have an organization that's created by the state and operates certain facilities, and then we have a process for closing them. It's in the sense that we have organizations like quasi-independent agencies, for example, that have to report to the state or have their budget approved, things like that. And that's not unique, but I can't speak directly to this particular process at the moment, but I can look into that for you.
Okay, all right. Thank you, Sam. And if I understand the process as proposed, continuation services, really the only action that the legislature takes has to be legislation, right? So if a veteran's home, if they come to this same situation again next year, let's say we pass this, they come to us, they present us with a plan to close Machias. Let's just pick on Machias, for example. Come to us with a plan to close Machias. We run through this process. We then have to put into statute whether we are going to allow that or not, correct? Or only if we don't agree with them do we have to put it in statute?
So just given the way the bill is drafted, I think that the legislature would at the very least have to, if you're going to let a location close, remove the requirement that that location exist from statute. And then and then the process is also going to obviously require you to have a public hearing on the matter, and report out legislation, or you allow you to report out legislation. So as to what else you could do with that, what other kind of statements or directives you could give, I'm sure you could direct Maine Veterans Homes within the scope of to act within the scope of what they're allowed to do under the law as well. Does that make sense?
It does a little bit. I guess maybe if I could follow up, Mr. Chair.
You may proceed.
So it sounds like, if I understand the Attorney General's letter, we already have that authority anyway, correct? We could tell the veterans homes right now, without this process, that we don't agree, and we'll put in statute that you just can't close it, right?
I believe so. I was, as I noted in my bill analysis, I'm not sure what it looks like. For instance, if in the situation where a home wanted to close and didn't have the funds to operate, like what not closing looks like. But the committee does, have because it was established by the legislature, you do have the authority to direct them or narrow or broaden the scope of what they may do.
Okay.
So if I may, I will tell you what my intent is so that it's clear. The original bill requires legislative approval for the closure of a home. Technically, we already have that authority, yes. But there is no process by which we would require the closure of a home. And so I took into consideration the concerns that by requiring legislative approval to close a home, it might conflict with the board's authority to authorize that closure according to its own deliberations. So instead of requiring approval of the legislature, I'm requiring notification of the closure to the legislature for the purposes of having a public conversation about it. As we know in this case, from the Attorney General's letter, he lays out the timeline, which corresponds with much of what we heard in the public hearing, which is the board voted or authorized the closures of these homes in October of last year. And we found out about it as the legislature in February of this, with the announcement that the homes would be closed. Both homes would be closed by the beginning of May as target dates. What the intent here is to provide the legislature its appropriate oversight of such a decision and allows the communities who are going to be most affected directly by the closures to be able to weigh in on what they're hearing. It also gives the board an opportunity to make its case to the legislative committee of oversight about why it is necessary to close the homes, which is why the language in the proposed amendment is very clear on what it is we are asking the board to present to us when they make this decision, which is ultimate and final, to close a home that is caring for veterans in the state of Maine, many of whom are struggling with dementia. And so because one of the inputs, the critiques of the original bill was simply that even if we require legislative approval, it doesn't outline a process, I decided to take both of those criticisms to heart and not require that we have veto power in the law, but simply to allow us an opportunity to weigh in on the matter. Because it could also be that when the board comes to us and explains to us exactly why they need to close, other than taking names out of the law, the legislature may have to take some other action to make sure that we do not have anything that will come back to the legislature. Because remember, the state, the people who work for the veterans' homes are part of our retirement system. And we have to make sure that not just the veterans who need care have a plan for their replacement. We also need to make sure that the employees who are working in these places are well cared for as well. And we may need to have a plan to place them. We may need to have a training program. We may need to do something. And I don't know what that is, but this is why we need a process that has public input so that we can make sure that we are not going to leave anyone destitute in a situation such as this. So that was the intent of describing it that way. If it's novel, if there's nothing else in any other agency and statute, I'm okay with that because we're clearly laying out what will be required in this case for these homes because we have a partnership with the board by virtue of the fact that we created the board in statute. So I hope that helps. If anyone on the committee has any questions for me regarding what I just said, please raise your hand anew and I will do my best to answer. If not, Chair recognizes Representative Chiazzo.
Thank you, Senator. And I appreciate that clarity. That makes perfect sense. And I think this is a process moving forward. I think the issue at hand is how do we, and it was very clear to me during public hearing, the goal right now, today, is to keep Machias and Caribou from closing. And my understanding is that revolved around a certain amount of money. Now, whether that's all that money or none of that money, this doesn't, and I think I agree, this addresses the issue moving forward. The appropriation section was taken out of it. Maybe this is a question for you, Senator Hickman, or maybe the Senate President. Of the funding was the key, right? I think that we had talked about. And so my question is, how is I'm sure there are other discussions and other mechanisms talking about the funding. I want to make sure that we're not just kicking this can down the road because I know funding has always been an issue in front of this committee when it comes to the veterans homes. This committee has always made that a priority, and it continues to be our priority. So I appreciate moving forward. This is the mechanism that describes how to close that. I can totally understand that. How does this impact directly the decision made right now for Machias and Caribou in terms of if they need funds to keep them open, how are we going to allocate those, or is there another mechanism that's going to be utilized to transfer those funds over?
Thank you for the question, Representative. I'm going to ask if Major Farnham would like to, who is
General Farnham.
Excuse me, Major General Farnham. Excuse me, sir. It's been a long morning already. From the department, the Adjutant General, who is also the Commissioner of the Department of Defense, Veterans, and Emergency Management. Welcome back, Major Farnham.
Thanks, Senator. So as far as the question on the funding, I mean, I would leave most of the discussions on the funding to the administration and to the governor's office and DHHS. However, I think they have been conversations, and I think the intent is to provide adequate funding. And I won't speak for the veterans homes whether it's adequate, but I think that's where we're at. It's adequate funding to get through this next near term. And meet the objective of having the ability to stay open from the financial side of the house, and so that a long range, long-term solution can be obtained. And whether that I think would be more involved in future budgets and how we're gonna provide funding to meet the to what's acceptable by all parties going forward. So that I think that part of the financial question is there. The LD 2001, I think the questions there revolve around, I think, Senator Hickman's thought process of preserving the ability of the Board of Trustees to be the Board of Trustees. And I think I digress just a little bit, but if you don't mind, I just throw in a little bit of my 2 cents. This has been very difficult for a lot of people. And it's difficult. One of the reasons it's difficult is we're one of only 2 states that do it this way, that aren't state run. Now, there's arguments, I'm sure, all sides of the issue, but I think we've been very proud of the homes that we have. For instance, New Hampshire has 1 home. Vermont has 1 home, state run, but only 1 for the entire state. Massachusetts is state run. They have only 2 for the entire state. Now, there's all kinds of differences, I get that, but we are fortunate to have what we have and providing the service they've done. And a lot of that is because of the efforts that the trustees have to own this. I mean, they've owned these homes. They have made it work, and I know bumps and along the way, but they've done a great job, and the way they've weathered COVID. I mean, I think without having this conversation and acknowledge the job that our veterans homes did during COVID in an industry that had a very difficult time, they're beat up, and so they've done a great job from, the entire staff there. And then, and this comes along, and again, I like to make sure we point out that they are all passionate veterans who have done have done due diligence, thinking they're doing what is best for the veterans of Maine. Certainly understand why the legislature has a different opinion and why we're working to this end. So anyway, I digress a little bit, but I hope I answered your question, Representative.
Thank you, General Farnham, and I agree. I'm glad to hear that there is a discussion around the funding mechanism. I think that's key. Certainly is key to alleviate the immediate concern. So thank you for that. I appreciate it.
And thank you, General Farnham. I do want to say that I think I heard you say that the legislature may have a different opinion about the work and the quality of care in our homes. And I just want to make it clear for the record that even though this is a committee of oversight, we don't really represent the opinion of the entire legislature, but I can say from everything we heard in the public hearing, I'm very well aware that the care that is provided to our veterans in our public homes is extraordinary. We have had, since the public hearing, another 40 pieces of testimony come in, at least. And those who know or have had individual family experience with care in the home have made it very clear that they're getting the best care that's out there. And so the chief executive officer and the board of directors have clearly done an exquisite job in running the homes in such a way that no one who is in them, including the employees, can say anything other than good things about what's going on there. So I just want to make it clear that this committee, I do not believe, the chair certainly doesn't believe that we have any opposition to the way or any disagreement with the fact that the board has done an extremely excellent job in making sure that our veterans are cared for and their families are cared for in all of the homes, in particular, Caribou and Machias. So
I understand that. I was alluding more to the decision of the closure and how that's all gone, but appreciate you saying that, and I'm sure they do too.
Thank you. Sam?
Thank you, Senator Hickman. I don't want to derail the discussion, but I just wanted to note for the committee, since there's been, since the committee is discussing the new process proposed in this amendment for the discontinuation of services, and that process is triggered as proposed in the bill by the decision to authorize the discontinuation, either by the Board of Trustees or the Executive Director. It's not clear, even though the bill is an emergency, and even if it were effective, immediately, how that impacts the decision that was currently made for Machias and Caribou. So I just think that to the extent that the committee is still concerned and wants those homes to follow this particular process, we should just make that clear, or you should just make it should be clear in the amendment. So I just wanted to point that out, that I think we can either do that through unallocated language, or we can say it particularly in the statute. I just wanted to notify you that should be clarified if you're going to move forward with this proposal.
So thank you, Sam, for that. I did not include retroactive language because the board has already authorized the closure, has already submitted its plan, and is already working under the rules that are set by DLC, which is Division of Licensing. I can't remember the other word. And so the Department of Health and Human Services introduced testimony, which we have in the record, that basically says that that has already happened and that they have not yet approved the closure plan. And so in some sense, I left that out because it's already going on. And if the decision to provide stopgap funding is enough for the board to understand that the legislature is also asking for it through a vehicle in this amendment to convene a stakeholder group and report back to us in February of 2023 about how we are working together to come up with a long-term solution to keep the homes viable. That could be, should be, hopefully will be enough. But if we need to, in the language review of any amendment we pass, make sure that we have our T's crossed and our I's dotted, then we will certainly do that at the recommendation of OPLA. Chair recognizes Senator Miramont.
Thank you, Mr. Chair. A couple things, just because that has gone on a long time. Let me see if I can keep it all together here. We'll start with, as we have to, that they're doing a great job about giving care to the veterans in the homes. If we skip that, everybody will focus on the omission. Sometimes people deliver exceptional results by their management getting out of the way, not because they led well. I don't know that that's the case in this situation or not, but judging from the other part of leading, that they are supposed to be managing these homes to take care of the veterans, as in that they still exist, that they still continue to be open and available. That part was not convincing that they have done that well, because there should have been much more attention brought to it, and what the funds needed folks should have made it aware to the legislature and how dire it was, and that wasn't done. So now I believe that everybody has been trying to get a number to keep them open through the life of the people who are in those homes, maybe not letting new in, but working towards that end, that it takes care of them. And as far as I understand, management has not given a number or been willing to work with them. So that's where I stand. Just so you know that there's some division here that I think that maybe the Senate President can make clear. I know you've been working on it, Mr. Chair, but here I am thinking somebody's not working together to keep these folks in their home for a little longer. And then what we do further about them and managing them, since the AG's office said we can, is another matter. Thank you.
Thank you, Senator. President Jackson, would you like to weigh in on whether or not we put clarifying language in the amendment regarding retroactivity as set forth in the Attorney General's letter to the committee, which may also address Sam's concern that we haven't made it clear in the amendment that's proposed, that this will take care of that?
Sure. Thank you, Senator Hickman, members of the committee again, Troy Jackson. And I too, I want to say, I mean, obviously everyone believes that the care being given at the veterans homes is absolutely, without question, outstanding. I mean, that's obviously why we're fighting to keep these two places open. We wouldn't be fighting to keep them open if the care wasn't as good as it is. And so that goes without saying. But that being said, I mean, at the same time, there's two places in rural Maine that are scheduled to be closed, and I just don't, I'm just never going to agree with that. And to the point on the funding, I mean, I kind of left it out there. I mean, we didn't know what the amount was. We were told that no amount could keep them open. I actually used Senator Lucchini's bill as just a vehicle with the same amounts, knowing that that was not the right amount. Now, I've been assured that when the change package comes down, there'll be funding to keep these homes open. And so that actually works better than having an appropriation in this bill that goes to and sits on the appropriations table, and we have to wait till the end of session like we often do for bills to come off. So I feel very, very comfortable that the right amount, the amount that the Veterans Home says they need to keep it open for the next 2 years, is going to be there. And then that gives us time to work on some of the other issues, or the legislature time. I think the big thing about it is that it keeps them open. I mean, that's the goal, is that it keeps these two facilities open. And so, yes, I feel very strongly that, ongoing, we know what we can expect, but these two are scheduled to close. And I would like to see something retroactive to make sure that at no time will these places close over the next 2 years. So the legislature does have time to work with the federal delegation and come up with ways that helps for ongoing concerns to keep these two facilities open. I mean, these are rural Maine, and we can't afford to lose them, and that's why it's so important. And like I said, I appreciate everything Senator Hickman has put into this, but I'd like to see something that slams the door on them being shut over the next 2 years.
So Sam, but I think I heard you say that we might need another unallocated language section to clarify that the legislature's intent is to keep these open so that we can actually work out a long-term solution in the short term.
Thank you, Senator Hickman. Yeah, I think just looking at the way the proposal is put together, in some sense, in section 601, where you're saying each county where a home must be located, that is doing some work, but it's not necessarily saying that these particular homes need to stay open. So you could theoretically see a situation where they close and then a new one or a different one or is open, and I don't know what those particular ones look like, So I think if the committee's intent is to require that the homes that are currently scheduled for closure are going to stay open until they have a chance to follow this process, or until the legislature has a chance to determine what adequate funding looks like, that should be made clear. And I think I'm relatively sure that the unallocated portion of the bill would be a good place to do that, because it's you're giving a directive essentially.
And in the second paragraph of section 601, restoring the actual locations of the homes and not just the counties where they exist is also another strengthening of the fact that if there must be homes in Augusta, Caribou, Machias, Scarborough, and South Parish, that the process to close them would need to be what we were putting in statute if in fact this was enacted as emergency legislation before the planned closures could take place. Would that also help?
I think it may. I'm hesitant to do like the particular language on the fly, but the fact that we have the counties and the municipalities, I think, does provide clarity there.
Thank you. Chair recognizes Representative Chiazzo.
Thank you, Mr. Chair. So I just want to make sure that we're all on the same page, which I think we are. We got the amendment at 9:30 this morning, so I apologize if I'm asking a lot of detailed questions. I'm trying to digest it. I think it's very, very clear to a T. Nobody wants these facilities closed. I think it's a question of how we do it and how do we do it in a way that doesn't create unintended consequences. And I'm tired of hearing that word, but it's true. Down the line of, we do something reactionary here with the best of intentions, which I think we all have, and it ends up creating more problems for us later on. So I'm just going through the amendment on section 7, the rules, and maybe Senator Hickman, this is for you or for Sam. I'm just curious to know why the requirement for the Maine Administrative Procedure Act in terms of rulemaking, why was that specifically put back in? And because I think it was originally, it says, but the Maine Administrative Procedures Act provisions regarding rulemaking, Title 5, Book, Chapter 375, Subchapter 2 and 2A do not apply, but that's been stricken. So I guess what impact does that have? I'm wondering if because they're a care facility, do they have to have a different set of rulemaking than MAP? I mean, MAP is for all of us bureaucrats, right? That we're making sure that everybody gets this and that and the other thing. How will that impact the operations of the Maine Veterans Homes? Will it restrict them? Or let me back that up here. Sorry. what was the intention of taking that section out, I guess is probably the best place to start. Senator, if you wanted to respond, or I can ask Sam what the impact will be. It's entirely however we want to start that discussion.
I'll defer to Sam to talk about the impact of that, because honestly, that was a suggestion from his office to include them. And so obviously routine technical rules provides for oversight. And it makes it clear that the input going forward that is already prescribed in statute has a formal process attached to it. Routine technical rules do not require legislative approval under the Maine Administrative Procedures Act. It requires a process with input, public comment, but it doesn't require legislative approval. It requires, when they are adopted, that they are shared with the legislature so that we understand if the board has decided to change the way it operates, we know about it. It's oversight. But Sam may have a different opinion about that, since he did recommend that we include it. And so I will defer to him on that.
Thank you, Senator Hickman and Representative Calzo. So when I was helping Senator Hickman put this together, he had expressed an interest in having, more oversight over the rulemaking provisions. And as you correctly pointed out, currently the Board of Trustees of Maine Veterans Homes is exempt from the Maine Administrative Procedure Act provisions when adopting rules. And so if you're going to remove that exemption, it's important to be clear about, if they're now brought under the Maine Administrative Procedure Act, which types of rules they're required to adopt, and that delineates which process they have to follow. So I suggested that if you're going to bring them back in to the Administrative Procedure Act, it should be clear which type. And I think Senator Hickman liked the idea of doing routine technical rules. And so routine technical rules, as you know, they require a public process. There's a public hearing, there's input, there's also once they are, the agency has decided that they're, good with the final form of the rules, there's a legal review process of them too. And then, agencies also provide notice of agency rulemakings to their legislative committees of jurisdiction. So what this does is essentially it brings them in a place, the rulemaking procedures into a place where all of that is now included, where it's currently not required. In terms of them being not a typical state agency, like in terms of them being a nonprofit, I don't think, I'm not aware of any reason, like legal reason, that they were exempt. It appears, and if I end up being wrong with this, I will let you know. It appears it was a policy decision to do it that way. As you might be aware, we have a number of quasi-independent state agencies that essentially operate like state-owned businesses that do have to follow the Administrative Procedure Act when they adopt rules. And I have not identified a problem with doing it that way. It's really a policy decision about whether you want to have a certain kind of oversight of their rulemaking process.
Follow up, Mr. Chair, if I could.
You may proceed.
So there's nothing that you're aware of from a DHHS perspective, let's say, on other nursing homes. I know those are privately regulated, they're private, right? My concern is that we're going to put a bunch of bureaucracy in place, then they're having to make rules or decisions based on patient care, and we don't tend to be the swiftest of responses. I don't know if that will, if there is a precedent or in a situation where another healthcare group has similar requirements under MAPA. And I know we're going to make this decision now, so it's going to have to be, I'm going to have to flip a coin and decide if that's a problem or not, I guess.
I can address, I'm sorry, Sam. I just want to address the legislative history of the bill that I researched. In a previous iteration, there was language that actually required the board and the Department of Health and Human Services to together have a plan for how funds were going to be used to improve nursing care in the facilities under the board's operational control. That was removed from statute, and I couldn't find the reason why. It was just taken out. And so we are in a situation where I believe that oversight is crucial. But remember, routine technical rules do not require our approval as the legislature. It's just a process that everyone who is a state-owned entity, who is actually in statute required to make rules, which were there from the beginning, have a process that they must follow in order for those rules to go into effect, become operational, and also report back to the legislature. Because we get rulemaking reviews and notices when agencies, quasi-independent agencies, executive branch agencies enter into that process. We get the notification of that. And so that's really why I believe that as a policy decision today, it's a good idea. The chair's going to recognize Representative McCray, and then Sam, you can weigh in on all of this.
Thank you, Mr. Chair. Going back a few beats, I'm still on the two homes that we're talking about, and the discussion about, do we have enough here that, as Senator Jackson said, you mentioned 2 years, written in a way such that they're open while this process develops. My fear is maybe this conversation has been had and I don't know it, how much money is needed. And my fear is the pushback could be, well, that's not enough. So we close anyway, regardless of everything. So I just want to be sure that what we're doing protects the two that we're first hear about, along with all the other things that the amendment does. So if the decision is this is enough, I'm not sure. I'm worried that it's not enough to make sure we have that process available so that these two continue with funding and sufficient funding, but sufficient is not a clear term, but to say sufficient so that we have just repeating myself, so that we have the other pieces, but we also make sure that these continue. And if at the end of whatever time frame, 2 years, we're in a different place, but I want to make sure that we have that protection clearly. And have we answered that, I guess, is my question, and maybe we have, but I just want to be sure. Thanks.
Thank you, Representative McCray. In the opening changes proposed in the amendment, where we were talking about legislative intent and purpose, we're strengthening that to make it very clear. And Sam, I don't know if you have the amendment up, or could you please put it up again? I want to at least address the policy part of it, because since we have bifurcated out the policy and the funding, if that's the concern of the committee, we can, in order to move the conversation forward, we can certainly talk about what is happening around funding in a little more detail. I can say that in the process of writing this amendment, the executive branch wants to take care of the funding stopgap measure in the change package so that it can be made available as soon as possible.
Thank you. And I understand that. I'm just worried about, have we dotted those I's and crossed those T's so that there's no loophole?
Correct.
But I understand that's the intent. I want to make sure if that's what we decide, that that's what happens. Thank you.
And so in this opening proposed amendment, if you look at the second paragraph toward the end, it says, therefore, in cooperation and partnership with the Board of Trustees of the Maine Veterans Homes, the legislature shall employ the powers vested in it by the Constitution of Maine to ensure that the homes and the locations named in this paragraph, and as you can see, we named them again, that have been established by the legislature under the provisions of this chapter remain in continuous operation by the Board of Trustees of the Maine Veterans Homes pursuant to Section 603. And Section 603 prescribes their authority to operate the homes. Sam, if you could scroll down a little bit more in this amendment. I guess I'm just trying to point out a few places where we are crossing T's and dotting I's, and then we can actually add a very explicit statement in unitalic language to make sure that these two homes don't close while this process unfolds. So if you continue down, Sam, in the proposed amendment, let's see, scroll back up just a bit. This is the part of the amendment we haven't discussed very much, but it's here, other funds. Right now, the board may apply for and receive any grants and aid for which the state or the home may be eligible. The addition is, and shall seek permanent funds or contributions from such state or federal agency, person, firm, or corporation, either independently or in conjunction with state funds appropriated or allocated in order to ensure the continuous operation of the public homes established in Section 601. So that section of law talks back to our intent and purpose, and it requires that the board fulfill its fiduciary responsibility by trying to find permanent funding for the homes that are currently in operation in statute. So if we scroll down again, Sam, if you follow me, please. When we get to discontinuation of services, all of those elements become a part of the process. And if you go to the unallocated language we currently have, can you please scroll down again? It basically says, once again, that the stakeholder group, shall convene a group of relevant stakeholders. This is in the middle of the proposed unallocated language section to develop a plan for the long-term viability and continuous operation. So there's that continuous operation phrase for the third time in the statute of the Maine Veterans Homes locations designated in Title 37B, Section 601, which are the ones named in the second paragraph of that section. And so this all talks to each other. What Sam is recommending and what the president wants to see is another unallocated language section to make it crystal clear that while all of this is happening, the homes called Caribou and Machias cannot close. We could direct, and I did have a version of this, we could direct, and I think Sam saw this version and has the language for it already. We could direct the Board of Trustees in statute, in unallocated language, to rescind its closure plans from the department. Do you remember that language, Sam?
I'm sure I have it somewhere, and I am familiar with it. I can, when I stop sharing my screen, I can try to pull it up.
So if we were to direct the board to rescind its closure plan, the legislature would be saying, like General Farnham alluded to earlier, that it doesn't agree with their decision. And whether they take a vote to reconsider or not, we are telling them to rescind their closure plan. And if there's a different way to do it that doesn't sound so prescriptive, I would be open to it. But it seems to me that if we want to cross T's and dot I's, we probably ought to tell people what we want them to do. Just a humble suggestion. The chair recognizes Senator Farron.
Thank you, Mr. Chair. A couple things, I guess, is first of all, going back to reiterate a little bit of what I've heard, and I want to say this, right? Maine Veterans Homes has done a tremendous service for our veterans throughout this state for many years. including during the pandemic when our nursing homes were losing our loved ones at a abnormally high rate compared to the Maine veterans homes. And that just needs to be recognized, as well as the board, who are all veterans, who some of us know very well, who agonized over this whole process and had veterans concerns. And as I've listened this morning, I've actually written it down a couple of times. We've talked about money, we've talked about rules, we've talked about oversight, but we really haven't spent a lot of focus and attention about the care, the level of care that our Maine veteran homes provide. And that is what differentiates them from some of the rural nursing home and healthcare facilities and settings. They provide a level of care that is unprecedented for our veterans. And I'm speaking from the heart. A World War II buddy, Nunzio, who was in Augusta, who I just had visiting hours for last night, Omaha Beach on D-Day. And I take my hat off to all the staff members and everybody else at Maine Veterans Homes. So I am all for trying to do some kind of stopgap to reassess, because I have heard the willingness of the board and of MVH to keep the two locations open while we work through a long-term process. And Senator Hickman, as you and I discussed yesterday morning for a long time on the phone, I think a stakeholders group that comes together, as General Farnham mentioned, we're one of only 2 states that oversees these. But I have some real concerns about us passing a major piece of legislation of oversight and rulemaking and everything else on something that was a lot of these members on here saw at 9:30 this morning. And we're going to move it along that quickly and could impact the long-term care of our veterans. And so I don't know where that goes. I'm still want to continue to listen as we go through this process. But you mentioned about stakeholders, and I do believe Colonel Cash and maybe Adrian Horn, one of the board members, is in the waiting room. I'd like to hear their thoughts on the amendment and the impact that it might have on their day-to-day operations from their view of the Maine Veterans Home.
Thank you, Senator. I will invite Colonel Cash into our conversation at this time. And while he joins us, I did receive feedback from one of the representatives of the Maine Veterans Home. And narrative and language are important. And the term unfunded mandate being used in this process is inappropriate. And the reason why I say it's inappropriate is because a mandate is defined in the Constitution of Maine regarding the state requiring that municipalities, a political subdivision of the state, do something that we ask them to do. If we do not fund what we ask them to do at 90%, then it's considered an unfunded mandate and must receive the vote of 2/3 of the legislature before such a policy goal can move forward. This is not a situation where the term unfunded mandate applies.
What to VLAC?
It doesn't. It doesn't. The state.
One. Is that what you need?
Can everyone please mute themselves who isn't speaking? I don't know what happened there, but I think it's been settled. So in this situation, there is no such thing as any mandate, because mandate has a specific definition in the Constitution and in state law. If we, as the legislature, are going to require and fulfill our policy to have our veterans in these homes, in these places, the state has to do all that it can to ensure that that is so. The fiduciary responsibility of the board is not the same exactly as it is in a completely private nonprofit organization. Throughout the legislative history that I have researched, I have seen testimony after testimony where there is a pride in running these homes without any state funding. It's in the record. And so, if you don't ask for help when you need it, I would say you are shirking your fiduciary responsibility, especially when the instrument of your existence was created by the legislature, who has the power to appropriate money for that which it has asked to be accomplished. So I just want to make it clear that the term unfunded mandate has no application here and should be rejected out of hand. With that, I will ask Colonel Cash to provide feedback to the committee on how he reads the amendment. Please introduce yourself. Colonel Cash.
Yeah, can you hear me?
Yes, sir.
Great, thank you. So I think we're all in agreement that MVH has an award-winning history of providing the highest level of care to our veterans. And our goal is, of course, to take care of veterans in the best manner possible and to preserve the financial footing in the mission for future years. And that has really been our driving goal the whole time. So we remain committed to working with the administration and legislature to find a way to adequately fund the operations at the homes. I must take exception that we have not, the statement that we have not come forth before and pointed out our concerns about the funding. I think LD 606 and 614 are clear evidence of that. But as soon as 2017, we approached the then administration to say these are concerns that we have. And we've identified the Medicaid funding gap over the years, which has been fairly extreme. And for these two facilities, Caribou and Machias, last year it was $3.5 million. When I say Medicaid gap, I'm talking about what were reimbursed minus what the allowed cost would be under Medicaid. And that delta again was 3.5 in the whole. While we appreciate our communication with the amendment sponsor, this proposal does not advance those goals. As drafted, the amendment eliminates the board's ability to manage operations. It mandates the locations of the home, and it requires their continuous operation without any dedicated or certainty of funding. Section 4, for example, requires APA rulemaking for every rule adopted by the board. Does this just relate to the bylaw adoption, or does it, apply to the hundreds of operational and maintenance policies as required by CMS and DHHS? Also, Section 1 mandates the locations of the homes and requires a continuous operation. Does this mean that the homes are an instrumentality or an agency of the state? And through this amendment, does the state functionally take over the homes and their operation? The MVH Board of Trustees is an all-volunteer, all-veteran board. This amendment would remove its authority and responsibility and mandate that it absorb costs with uncertainty of funding. It does not provide a solid financial footing now or in the future. In fact, one could argue that the amendment makes the fiscal situation far more dire than the present, given the uncertain funding mandates that are embedded in the amendment. If we looked at this in reverse, if you said, we wanted to establish facilities in these locations, we'd have to go through a certificate of need process. That would require us to, one, identify that there is a need, and two, show that we could sustain it over time. I think we'd be hard pressed to do that with the numbers that we see for the future population or the ability to operate these facilities in a self-sustaining mode. And so really, I think that's just the fiscal realities are out there. I would ask, though, that I believe at least one other board member has joined us today, and perhaps two, and I would certainly invite them or ask that they be allowed to present as well. I'd also like to mention too.
Thank you, Colonel Cash, for your remarks. I have one question for you.
Yes.
Around rules. So the enabling statute required that you draft rules regarding how your organization and operation runs. How has the Board of Trustees and the Chief Executive Officer and the Chief Financial Officer interpret that statute in its own operations? What are the rules that you have drafted based upon that provision of law?
Yeah, so we have policies, management policies and governing policies. We have a dozen or so governance policies that are board policy levels, and those have been, reviewed and approved by the board, and those are reviewed periodically. So like GV1, governance 1 is our bylaws. Others talk about finance and property, real estate. So those overarching policies, so to speak. Beyond that, we also have management policies and procedures that number well into the hundreds. And again, are required by CMS and DHHS that talk about a variety of things, how the care is delivered, our compliance program, our financial procedures, all of those, which are required, again, by CMS, the Centers for Medicare and Medicaid Services, and of course by the Department of Health and Human Services.
I appreciate that, because you have been exempted from the Administrative Procedures Act from the start. And if we were to move forward this amendment and you remained exempted from the Administrative Procedures Act, there is a provision in this amendment that would simply ask you to share with the committee when you report to us every February, if you have had to make any changes to some of those policies by just reporting those to us in your annual report, without necessarily writing them all down for us to read, because we know headlines are headlines, and you can say we've developed new policies for this and that and the other and written new rules around it. Would you have a problem with that, sir?
I'm still trying to digest and absorb the amendment like everyone else. We got it mid-morning, and
actually you received it last night.
I did not receive it last night. I got it this morning.
But so would you have a problem with the status quo around rules, with simply in addition to reporting in changes or updates to those things to the legislature in your annual report, which is also proposed in the amendment?
I would not have a problem with us being able to do our policies and rules and procedures as we do now, because we do now.
Yeah. And may I ask, please, what your conversations have yielded with the administration around funding? It is my understanding that you have been offered $3 million. Yeah. Is that appropriate? Is that accurate in the negotiations that you are having with the administration?
That is accurate. We met with the TAG and the commissioner yesterday morning. The offer was made $1 million for the rest of this fiscal year, and approximately $2 million next fiscal year, contingent on that would be a state and federal match. So the federal match would have to be applied for. That is what they offered. we are, the funding, I think that people, don't understand that funding alone will not take care or address or overcome the challenges that we have with workforce. And, I think people don't fully appreciate, understand the challenges of workforce. Yes, we all understand that workforce is a problem across the state, not only in the nursing home industry, but in other industries as well. But it is a hugely limiting factor. The only way we can overcome that would be it would probably be with funding, and it would probably be taking from others, poaching from others to do that. Or, if we can get them, bringing in travelers. So it's going to cost even more money than what the state is probably offering us. Again, in Caribou alone, in 20 and 21, we spent over $1 million in each of those years in agency staffing.
So, Colonel Cash, around the term you use, poaching other people from other places, we heard testimony in the public hearing from CNAs who work in Caribou, especially the last person who testified, that she has personally turned down a $20,000 and now a $10,000 sign-on bonus to work, as she said in her own words, up the road.
Mm-hmm.
And so I'm wondering how the concern that you would have to take people from other places applies with that reality that we were given in the public hearing by people who work in Caribou and do not see any staffing issues regarding the operations for their community.
Well, Senator, in truth, what you heard was anecdotal story, but we have the empirical evidence. We can show you that we've had as high as 21% vacancy rates, and that we spent $1 million in traveling and agency staffing to make sure that we can meet the staffing standards. So, I can only say, and I certainly understand the individual's testimony, what she said, and I'm thrilled. But that's one person, anecdotal. I can show you the empirical evidence. I can show you a trend, and in fact, it's included in the information that I provided to the analyst yesterday, that shows you what our vacancy rates are over time, and they're there. And again, as much as 21% vacancy, which is, and that's calculated by budgeted hours versus hours worked. It's not physicians, but it's the hours worked.
Thank you. The chair recognizes Senator Meermont.
Thank you, Mr. Chair. Mr. Cash, you're not restricted by any rules about setting the hourly rate for your employees, are you? And that's just the start of the question, but
that's correct, sir. We set our wages.
Okay, so you could be competitive and get some of those folks, keep them from going to other places, which may not just be nursing homes. It may be that with some of the restrictions on nursing homes and wages based on who runs them, they could be quite low, whereas McDonald's or Walmart would be paying more. So they'd be not worrying about their earned credentials and just going somewhere else. So that's part of it. So you could do that without going to outside agencies. Have you figured how long you would need to keep those two open if you stopped accepting people and just took care of the people as they aged out in those homes, to know that it was a decline that was X number of years, so you only had to focus on that? And that 3 million that you mentioned, that's in the change package coming up, which you do know is, as soon as we heard that it was dire, to keep these open. We've had legislation put in. You've been told that there's 3 million in the supplemental. And who knows what else, if you're willing to get us working together with you, because it's dire, not just that you need more money. Everybody always needs more money. It's what we hear every day here. But for an important thing like this, that when you bring it to our attention and not, just October or something for the first time for most of us, that we would have tried to do more. And now we're scrambling to do more, which makes it all the harder. And the last part on that 3 million is that 3 million from us, and it triggers other matches from other federal or private organizations. Thank you.
Senator, I just wanted to make sure I understood your first question, and that is, have we calculated how long it would take if we stop? Did I hear you right? If we stopped admitting and just took care of the current admissions and didn't allow anybody else in, is that what your question was?
Yes, because yes, if that's enough, an answer, yes. Just because we may not be able to fund forever, but we could for now. This is their home right now.
Right. So or what you're suggesting is that's a pathway to closing those facilities?
It's just a thought in my mind, but I don't know that it's even possible or what anyone else on this committee or in the state would entertain. It just came to mind.
Okay, I just wanted to understand that. And then again, the funding that the state offered us was 1 million this year and 2 million next year. We weren't made aware of anything in a change package or the certainty of that funding. When I asked for clarification from the commissioner yesterday, she did not express that it was in the change package, and it was contingent on the legislature, which we certainly understand as well. And again, I just want to bring up the point that, we have been making efforts to identify these challenges. And actually, there were comments in the last two reports that I gave to the VLAC in 20 and 21 about how a permanent funding solution is needed. Otherwise, the financial viability of the entire system is threatened. Did I have an alarmist warning? Obviously not. I can tell you, certainly, on this end, we know that our communication could have improved and we've done missteps. But I think, from our assessment, looking at the needs, looking at the costs, looking at everything, I think that we're just postponing the inevitable. And I think what the offer that we got from the state, from the administration, and I think General Farnham, if I heard him correctly, said that the intent was to give us what money we needed for the short term while working on the long term. So I just wanted to explain that on the funding.
The chair recognizes Representative Chiazzo.
Thank you, Mr. Chair, and thank you, Colonel Cash, for participating this afternoon. Now it's this afternoon, started out being this morning. I think obviously we all want to achieve the goal of keeping these facilities open. I think I hope we're not losing. I hope we're not getting into a turf war, so to speak, where we're. And I'm not suggesting this is you or anybody. I want to make sure that we separate out the emotions and the policies from what do we need to do to move forward to make sure these facilities stay open. So while I can appreciate your outlook of this would be just and not putting words in your mouth, but so to speak, delaying the inevitable. I think there's a big appetite for us to delay that inevitable while we can work out other solutions, right? So while we can work together to try and come up with a common compromise, and if we can't, then let's be very clear and precise and exact of why we can and how we might be able to fix that. So having said that, sir, do you have access or in front of you your annual report for the joint standing that you presented on February 18th, 2021?
Yeah, my screen just went down, so we're bringing it back up.
Okay, thank you.
And Chairman Piazza, if you can, please email that document that you are reading to Sam.
I believe he has it. I think it was the annual, titled the Maine Veterans Home Annual Report for Joint Standing Committee on Veterans and Legal Affairs, dated February 18th, 2021. I pulled it off the website, so let me see if I can. I'll stick it. Do you want me to stick it in the chat?
Yeah, that's why I asked you to email it or put it in the chat so that we don't have to go looking for it since you have it in your possession. Thank you.
Yep. I will put it in there right now. I hope this is the right one.
I want to also respect the fact that we have people participating or watching this who are on YouTube and will not have access to the chat. And so I would like, as you walk through this and ask your questions, Representative, that Sam can put this up on the screen so that everyone can see what it is we'll be talking about in this.
Yeah, and I thank you, Mr. Chair. I certainly do not want to do a full forensic audit of the Maine Veterans Home at all. I just I want some clarity on what the operating budgets are and whether we are looking at surpluses overall or whether we're looking at deficits overall, because I think that is germane to the conversation of how much funding are we talking about needing, right?
And while we wait for that to be shared on the screen, I will ask you to just hold off on your line of questioning. I also would like to ask Colonel Cash if you have an electronic copy of a document, sir, that you shared with me in our meeting, I believe yesterday, of some of the reimbursement shortfall for the last 5 years in all of your facilities. Since I know part of a long-term solution has to be addressing that deficit, do you have an electronic copy of that document, Colonel?
I do, Senator.
It may already be in the materials that you have submitted, and we certainly appreciate you submitting all the materials that you did. But if you have access to that particular document,
sure,
I would certainly ask that if you have the ability, since you're a panelist, to put a link to that in the chat, that would be great. Or if not, email it to me or to our analyst. Sam?
Thank you, Senator Hickman. I think I found it. I can share it on my screen, and then once you've confirmed that it is in fact the right one, I can put a link to it in the chat.
Okay, great.
Does that work?
And why don't you share it on your screen? Yes. And then we will check with Representative Chiazzo, who asked to discuss this document to make sure that we are literally on the same page.
Is this the correct one?
Yes, sir. That is the document that I was looking at.
Okay, great. So with that, Representative Chiazzo, please continue with your questions related to the document.
Thank you. Thank you, Mr. Chair. So Colonel Cash, do you have the document in front of you now?
I do.
Can you point us to the, again, like I said, I'm not looking at a full forensic audit here. Just can you point us to the line or the location that shows your operating, your net positive or operating loss for the year? For I think this is 2019's figures.
Yeah, yes, those are going to be close of fiscal year 19. Because the audit's always a year in arrears, so to speak.
What page is that on in the document, Representative Chiazzo?
I'm looking at the very last page, but I want to make sure I'm in the right spot. So I was hoping Colonel Cash could point out the area he would identify it in.
I just want Sam to be able to scroll to the page that you are looking at.
So the very last page is going to be cash flows. That's going to include restricted funds, which are going to be, which is going to include grants for capital expenses, which are not reflected necessarily on income. We're not doing that. If you go to
Colonel Cash, can you please tell me which line you are referring to? Can you look at the computer screen that we are looking
Yeah.
are you able to do that? I don't have any idea if you are able to see the screen the way we're looking at it. Although since you are a panelist, I'm assuming that there may be an ability for you to do that. I just want to make sure that we're all talking about the same numbers, the same form, on the same page of the document.
So if I understand Representative Chiazzo's question, he's wondering what our net income was, correct?
No, sir, because I know it's very complex in terms of restricted, unrestricted funds. I'm looking at it from the pretty much from the operating fund, right? The amount of money you take in versus your expenses, right? So I think the conversation, where I'm going with this, our conversation is talking about I think we can all agree, I can speak personally, the level of care at the Maine Veterans Homes across the board are premier. They are the gold standard. And I would expect and want and demand nothing less for our veterans, but that comes at a cost. So my concern is that we're being a little bit cavalier when it comes to saying, you know, you just hire more people or give them raises or do something, because that money has to come from somewhere. And so in order to know how much money we need, we have to have a real finite understanding of how much of a deficit, operational deficit we're running. So it's not like I don't believe there's a large sum of cash in the bank that we can draw off of to keep these facilities open. But if there is, fantastic, then we can work that out. If there isn't, can you show us why that isn't the case based on this financial report that was given to the legislature?
I think if you go to page 5, the top half of page 5 is going to show you the operating fund. That's it, correct. If you look at that, you're going to see what our operating revenues were and the net, the service revenue and the pharmacy revenue. We do have some contracts. We support Down East Community Hospital. So you can see our total operating revenues of almost $75 million. You're going to see our total operating expenses of almost $88 million for a delta of $12.7 million. You know, the restricted funds that come in are going to be, you know, in this case, it's going to be for probably the Augusta, the new facility in Augusta. Even with that, you can see that
Can you
delta.
1 second? Colonel Cash, you're breaking up. So I'm just going to pause for 1 second. I'm going to ask Sam to stop sharing the screen, please. And I'm going to look around the room. Anyone who is not speaking right now, if you could just turn your camera off. Thank you. Just for a minute. And that may help Colonel Cash's remarks be heard more clearly. There we are. So Colonel Cash, can you please begin again with what you were saying so we can all hear you?
Certainly. So if you were to look at page 5, which is a statement of revenues, expenses, and changes in net position, you will see our operating revenues and our operating expenses outlined. And you will see that for operations, you're going to see that we took in about $75 million and we expended about $88 million for a delta of almost $13 million a deficit. You know, when we're talking about operations, again, that's what we take in from revenues, and that's what we expend for that. We also have some non-operating revenues and expenditures, and you can see that in that line, you're going to have $24.6 million in the VA construction grant. Again, that was primarily for the Augusta.
Sorry, Mr. Cash, can you, sorry, Colonel Cash, can you do it for a second? Senator Hickman, can we have Sam put that up on the screen, please? Because we're still looking at blank screens.
Thank you. Sam, can you please share your screen again?
Sorry, Colonel Cash, I wanted to make sure we could walk through your description.
Okay.
So again,
I think you were talking about the unrestricted portion or the restricted portion.
Yeah. So again, you can't quite see the top of the page, but you have our operating revenues and our operating expenses. And if you're just talking about operations, you're talking about a deficit of about $13 million, $12.7 million. And that's just for the operations to do the homes. The non-operating revenues and expenses, you can see that we have a variety of sources that we can draw from, including our investment gain we have a capital reserve used to fund future projects. One of the things that we have done at Maine Veterans Homes that no other state has done other than Tennessee is we have paid the state share for all of our construction projects throughout the years. And during my time here, that's equated to about $70 million that we have not come to the state, ask for to fund projects, including the Augusta home that's being built and will be moving into later this month. But you can see from the operations that there is quite a delta there. The delegation's letter said there appears to be a $25 million surplus that was reported in the 990. That's true, but that represents $24.6 million that of VA construction grant revenue that was reflected on the 990 in revenues, but the expenditures of $39.9 million in capital expenses for the Augusta home were not reflected on the 990. And again, that's a delta of $15 million that was spent above that. I do have my CFO here. If you have questions, more technical questions that he can answer.
I don't, Colonel Cash. I just wanted to make sure that we were all on the same page with what the operating status of the Veterans Home really was. And I think this is I don't think this, I mean, we can go back to previous annual reports, and I think we'll see that there's typically a pretty good delta there through most of them. I guess my question would be, and this is real, oh, sorry, Senator, sorry, Mr. Chair.
Thank you, sir. Sam, can you please stop sharing your screen? And I'm going to ask committee members to turn back on their cameras to see if we have cleared up the static, because we were doing just fine for a very long time. And so it might have been a temporary glitch. So if you'd like to turn your camera back on, please do. If you are not speaking and you are anyone waiting to be called upon, please keep your camera off. Thank you very much. Chairman Chiazzo, you may continue.
Thank you, Mr. Chair. My real question, Colonel, around, so we've identified the shortcomings. That's, we can plug as much of that as we can short term. I think we've all agreed with that. We want to delay this process as much as problems so we can have that real meaningful discussion. If this is the catalyst to start that now, fantastic. Let's move forward, right? Instead of looking backwards, let's move forward. The real question I have is around, if you are, I don't understand the bonding relationships that you have with the private sector. And I don't know if you or your CFO could speak to what happens if we get in a situation where fiduciarily you're not able to meet those expectations. We don't back that up as a state. How does that impact your current private financing mechanisms? Are there guarantees in place? Is there a default process? We've given you I know we've authorized a bond limit for the Veterans Home. Do we secure those bonds, or are those secured through a different mechanism?
Yeah, I'm going to ask Kevin Brooks, our CFO, to explain that.
Sure, thank you.
Thank you.
Good afternoon, everyone. Thank you for having me speak. We did borrow money for the construction of our Augusta project. We borrowed $20 million for that.
Sir?
That was,
Can you hear me, sir? I know you're far away from the computer. There we are. Just for the record, please, can you please state your name and who you are? And then you can answer Chairman Chiazzo's question.
Sorry, my name is Kevin Brooks. I'm the Chief Financial Officer for the Maine Veterans Homes. Thank you for having me this afternoon. To address that question, we did borrow money for the construction of our Augusta project. We borrowed $20 million in tax exempt revenue bonds. And the guarantee on those bonds is the asset itself. So the state is not guaranteeing the repayment of those bonds. That's done totally within the realm of Maine Veterans Homes, and it's secured by the asset that we use to borrow that money for.
May I follow up, Mr. Chair?
You may.
So does the operational revenue from the Augusta facility, is that enough to cover the bond payments for that outlay? Or are you having to rely on other operational revenue to offset some of those costs for the bond payments?
Yeah, currently we haven't opened the new home. Yeah, it's opening this month. We have just started paying back those bonds. We're just paying interest on those bonds now based on the terms of that. So, but it is our intention that the operations of the new home will allow us to service the debt that we've undertaken by incurring those revenue bonds. That's correct.
Okay, thank you, sir. Thank you. No other questions, Mr. Chair.
Thank you. Colonel Cash, may I please ask a question on that matter? Is it the intention of Maine Veterans Homes or the board to propose to close the facilities that it has closed in order to move the veterans from where they are to the Augusta facility?
No, we're not. Our plan is not to move those veterans to our Augusta facility. As the closure plan that we submitted to DHHS, we would move them to a facility of their choosing, and some may opt to go to another Maine Veterans Homes, but that was not our intention. Was to close those to fill the Augusta home. No.
And when
that's your question.
Yes, I appreciate the answer. And when you say that your closure plan is of their choosing, do you have a list of facilities that they can choose from that you think they may want to be? And if so, how many are on that list?
Yeah, yes, the closure plan requires a draft of the notice that we would be sending the residents once that plan is approved, and it includes a list of homes within a 60-mile radius, nursing homes and assisted living facilities. I don't know the number off the top of my head, but I want to say in Caribou, it's probably a dozen or so, and a smaller number in Machias. We also obviously include our other Maine Veterans Homes if they want to stay within the Maine Veterans Homes.
So in 60-mile radius?
Yes, within a 60-mile radius. We would certainly entertain moving them wherever they want to go if it's farther from that, but the closure plan requirements are you must list within a 60-mile radius.
So within that, I'm sorry, there is a delay. I don't mean to talk over you.
Okay.
I'll wait for you to finish completely. Great. So in that 60-mile radius that is identified as a part of the closure plan, when we talk about demographics of the area, do you know if in those choices available in that 60-mile radius, what the population of veterans are, if any, in those places?
If I understand your question, you're asking me, do I know how many veterans are in those nursing homes that people, our residents may be moved to? Is that your question, Senator?
Thank you. Yes.
Okay. No, I don't know the exact numbers of veterans that are already in those homes. I do know that we have identified VA contracted nursing homes on those lists, but I don't know if they're veterans or not, how many they have.
And my final question for this moment is, in the negotiations that you have had with the administration around the amount of money that would be offered by the state to help delay what is considered inevitable would you prefer that the legislature appropriate that money as a part of this piece of legislation should it pass, so that it is clear that we would be approving all of it at the same time?
I have no expertise or knowledge in how the legislature works the funding issues. I do, in 2000, for our previous bills that we did that, we got a little bit of a exposure to that, and I know it went to appropriations. I guess my question is, yes, I'd like to see more certainty. I did get a clarifying note here from Commissioner Lambrou on the offer. 1 million in net general fund in the fiscal year 2020 and 750 in net general fund in 2023 with a federal match that would yield a total of, as she says, about $3.5 million. Again, I don't know how that's done, and I am concerned about the certainty that it would happen. I feel better about if it was in the change package and coming from the general fund than dependent on a federal match at this point. Certainly for the next year, one of the things that we're having to deal with is uncertainty is hitting our homes right now. We have staff that, because of the limbo that they're in right now, are looking elsewhere for jobs. And we certainly understand that and appreciate that. And that's one of the reasons that we took the communication plan that we did. And again, that was learned from others who have had to close during the year. That if staff here and uncertainty pops up and there's not a plan in place, it's really hard to staff the facilities. So I'm concerned about being able to keep it open for the next year. The workforce challenges we're going to have because of the uncertainty that we're dealing with right now.
And what is the percentage occupancy at this moment of both homes that have been authorized for closure by the board?
Yeah, I'm having somebody look that up so I can give you an exact figure.
Thank you. The chair recognizes Senator Farron.
Thank you. So Colonel Cash, on that particular, while you're looking that up, if we were able to provide this additional funding, would you and the board still have the latitude, because having learned the process, dealing with it personally, that you would not take in additional veterans so that you could maintain the level of care for the residents that you have with the staffing that you have?
Let me go ahead and tell you what the census is, and then I'll, so the census currently at Caribou, total census is 57 of 70 beds for a census of 81%, 35 veterans, 22 non-veterans. At Chias, we have 21 for a 70% occupancy rate. That's 14 veterans and 7 non-veterans. Senator Farron, to answer your question, right now we are not allowed to take any more admissions while our closure plan has been submitted to DHHS. That's one of the requirements, is that you do not take any new admissions. I believe what you asked was would we, or would our plan be not to take any more veterans to close? We have not contemplated that, if I understood your question correctly, sir.
Follow up, Mr. Chair. Yeah, and I don't know if it's 2 points. One is, I just say, and I listened to that testimony, and I apologize, I missed a big portion of the public hearing, but I have gone back and listened to a number, and I just want to share with the committee, if you haven't visited Maine Veterans Homes, I suggest you do. I can tell you, whether we heard testimony or not, but I spent many evenings and weekends at the Augusta home talking with staff who are dedicated and care about our veterans, and to a person. And I'm talking at least 12 or 15 that I ran across while I was there. When I asked, I'm from the government, I'm here to help. It wasn't about more pay. It wasn't about more resources. It was get us more help, get us more assistance so we can take care of it. So I do believe the workforce issue is a huge part of that. And Mr. Chair, Senator Hickman, I would like to be able to bring in Adria Horn to part of this discussion as well as a board member, as we're asking the question of how some of this amendment may play a role in how they administer their policies at the Maine Veterans Home.
And that will be appropriate. I will promote the vice chair, I believe, of the board momentarily. I just want to ask 2 more questions. Actually, I will promote the vice chair of the board, Adria Horn, right now. And I just have 2 more questions for the colonel related to the census data that you have presented. So if I heard you correctly, Caribou is about 81%.
Correct. Yeah,
Machias is about 70%.
correct.
Do you have numbers on how many people, if any, are on wait lists in either facility currently?
I do not.
Is that something that you can get for us? I would actually like to know how many veterans or their family members, any eligible person, was on a wait list in October when you took the vote to close Caribou, and how many people were on a wait list for Machias in October when you took the vote to close Machias.
Sure, but let me explain to you what wait lists are and what the requirement is. So we are required by DHHS to maintain wait lists, and anybody who expressed an interest in our homes is added to that wait list. We go through that wait list and we find out how many veterans or spouses are ready to come into the home. And the vast majority of the folks that are on our wait list have expressed an interest in our homes in the future and are not ready.
Okay.
Now, when somebody is ready, we don't always have a bed. And that can be because we don't have a bed, but typically what it is we don't have a bed for that specialty service. For example, our memory care, our nursing home memory care level of folks, those beds are generally filled and those folks are with us for a long time.
Yep.
But our short stay, our skilled, those are folks who come into us for typically a 2 to 3 month stay. There's more turnover there, but that's not always the next need. So I'll certainly find out what those numbers are and pass them to you, but you need to get the whole story behind that.
Yes, I appreciate the story behind it, but it still would be good to see the actual numbers of each of those wait lists. And if there is a way to break down what you just said, those who are interested and not ready, and those who are ready, but there's no bed available. If you can get that breakdown for the committee, that would be great. I also want to tell everyone that we are planning in the next 2 weeks, within the next 2 weeks, to have a more robust conversation with the Maine Veterans Homes and anyone else that the Chief Executive Officer brings to present their annual report for 2022, which the committee has not yet received. And so some of the information in the documents and the information requests that we have gotten answers to from the Chief Executive Officer will certainly be a part of that report, and also that conversation that we may have or will have between now and say March the 25th, when our committee work will come to a close. And so these information requests today will certainly help us with trying to find long-term solutions should we find a way to keep these homes open until such time as we can find a long-term solution. The chair recognizes Representative Chiazzo.
Thank you, Mr. Chair. Mr. Cash, I'm wondering if in parallel to the occupancy rates, you could share with us the staffing levels, right? Because if my understanding is if I don't think you're 100% staffed all the time, which means you have an 81% occupancy rate, but that doesn't mean you have a 19% capacity to take in new patients. Is that fair?
Yes, sir. That is fair. And let me pull up a document here that I can read off to. So we monitor. I can tell you what our vacancy rates are for Caribou. I don't have the Machias ones in front of me. I'll ask somebody to pull that up for me. But for instance, in Caribou, which I mentioned earlier, we follow the staffing rates. Right now, our last measurement on this chart is December. We had 11.1% vacancy rate. Ideally, you'd want to be at about 5.5 would be the industry best. But anytime you're over 8%, that's when we've found out that we have to really start relying heavily on agency staffing to do that. Over last year, the average vacancy rate was 13.8% at Caribou. And it was as high as 22.2 at one point.
Thank you.
Follow up, Mr. Chair.
Yes, thank you.
Thank you, Mr. Chair. So I guess I want to help me understand this too. You may not accept a patient, not because there might be a vacant room, but your staffing levels are going to dictate the patient load at the time. Yeah, meaning that if you happen to be at one of those peaks where you have a 22 or at your high point is a 22% vacancy rate, you may have the capacity for beds, but you can't accept that patient because you can't give them the quality of care that you're required to. Is that fair?
That is true, and we have stopped admissions, or we've paused admissions at other facilities because of that, and then and of course, COVID exacerbated that. Just pulled up the vacancy rate for Machias last year was 17.45%. Again, almost 1 in 5 positions.
Thank you, sir.
In the 2016 update to the statute, there was a provision of the statute removed regarding, if my memory serves, I'm not multitasking today, I'm focused, so I can't see it, but there was a provision removed around a geriatric training program. Does that sound familiar? How much of that, or were you involved, were you the CEO at the time that program was in statute and functional? Because if I remember correctly, the language was this is a pilot program for 3 years, and that at some point there needed to be review, and there was prescriptive language that required the board at the time to seek permanent funding for that program so that it would always be there to try to make sure we were training people to serve the veterans. Can you just talk a little bit about that program, your experience with it, why it didn't continue, and how long before we repealed it from the statute did it end?
My understanding, and that was well before my time, was that was early on.
Was the initial home.
With the initial home when it was built in 1983. And so that requirement had been met, and yet that remained, that was residual, I guess, from that time. It was still in the statute. And in 2016, our efforts were to, remove things that no longer applied. So to clean up the bill, so to speak, that was our intent, and we did that in that areas and in other areas that just no longer applied. But that program was well before my time, so I can't speak to any other aspects of it.
Have you, as you have faced a staffing issue throughout the years, thought about maybe reconstituting some form of a training program for direct care workers that will work specifically in the homes that you operate?
Yes, we have over 24 training affiliations, and we also have gotten waivers from the state to put on our own training, our CNA training, in some of our homes. We have been, I think, very proactive and creative in trying to set up affiliations and set up opportunities. One is a unit helper, where we hire somebody on as basically a unit clerk, but we put them through CNA training and get them certified as CNAs, and all the while they're being employed and they have a job. We have looked at that as well. We also have a very a robust tuition assistance program that, we would love to have, CNAs stay with us and continue their education, become RNs, whether they stay with us or not. We just think that's the right thing. Yeah, if I may, I have my chief of operations here, Deb Fournier, who's been with the organization. She helped open the Scarborough facility in 1990. She was away for a while, but came back. But she certainly might be able to speak more on that history if you would let her.
I appreciate that. What I am going to do today, with no disrespect to your chief operating officer, is that Senator Farron has asked for the vice chair of the board to come into the room. I'm going to recognize her shortly after I recognize Senator Miramont. And then what we're going to do, because we're going to need a break, not just from the discussion, but it's time for staff to stretch. It's time for some of us to rest our eyes because it's going on 2 o'clock. We're going to be taking a break after the next line of questioning with the vice chair, Adria Horn. We will take a break and discuss amongst ourselves on a lunch break and in our caucuses how best to proceed for the afternoon regarding this legislation and the rest that is on our schedule. Now, here's the thing about work sessions. If we get to a place in committee where we run out of time today because it's too late to take up all of the bills that we have in our possession, we will have to get permission from the presiding officers to vote those out next week. I don't expect that will be a problem, but I'm not a presiding officer, so I can't say. I'm saying this to the audience. If you are here on a bill and we don't get to it today, we're going to apologize in advance that we didn't get to it today. But as you can see, we are in the middle of a conversation that must be had. And so we're going to do our best to complete our work in a timely manner and before the cows come home, but we might not make it. So I just want everyone who's watching to understand that we have the liberty to not take up bills in work session, even though they've been advertised. So with that, Senator Miramont.
Thank you, Mr. Chair. Mr. Cash, what's the vacancy rate in Augusta, please?
Oh, I'm going to have to pull that up. That's on a different chart that's being done right now.
Okay, in the meanwhile,
7.80.
I think that vacancy rates in all of the facilities may be a question that can be answered. But in the meantime, Colonel Cash, we'll come back to you on the answer to that question. And right now, I will recognize Adria Horn. Please turn on your camera. Introduce yourself. It's great to see you.
Senator Hickman, thank you. Thank you, everyone. My name is Adria Horn. I am the Vice Chair of the Board of Trustees for Maine Veterans Homes. And I am in Senator Hickman's district, Pittston, Maine.
Thank you for being here today. The chair recognizes Senator Farron, who I believe has some questions for you. Senator Farron, you are
muted.
Yeah, most people like it when I'm muted. Thank you, Adria, for being here. Great to see you, and thank you for continuing doing the great work you do for our veterans and everybody else. But specifically, and I know we did get to Senator Hickman's point, he did share the amendment with a couple of us last night, and I'm sure it probably did not make it to board members and others until sometime today. And so I know this is kind of short notice and don't know how much time you've had to take a look, but my overriding concern, and I'm going to do what politicians do, repeat themselves, doing a short-term solution, finding a long-term solution, but I'm also afraid of Representative Chiazzo's statement about, unintended consequences, because we move, believe it or not, too quickly sometimes. And what I'm still ultimately concerned about is the legislature passing an amendment or a law that ties the hands of the board members to provide the world-class service that Maine Veteran Homes provides to our veterans. And just wondering if you have an opinion or a comment that you'd like to share with the committee on that.
Thank you, Senator Farren. I'm not sure I can really speak articulately to some material changes that would impact that right now as it relates to the short-term solution that we're looking for that would enable a long-term discussion, right? I think that's sort of the collective that we're looking for. I do think this is actually much more complicated than any one of us really understood. And when I mean complicated, I think I mean, the way the board runs the homes right now, the way we vote on things, and the way this legislative consideration actually requires the board to vote. I think one of the things that we had talked about in our chair, Jim Settley, we were really looking for an opportunity to bring something to the board. And I don't understand how this amendment comes first, or the vote comes first, before we bring something to the board and have a continued discussion procedurally. So I think procedurally, what comes first and how discussions work to actually work this out, I'm not sure we fully understand how the administration's change package offer, the legislative amendment, and the board decision all work, because I think it's actually much more complicated, which obviously is what the amendment entails. And I think we would probably need to review that to understand how we can align those efforts. I don't, like you said, know how it materially changes the facility's ability to provide world-class care. The structure itself, which is, I know General Farnham referred to, Tennessee and Maine are the only two that are not in the entire country run by what would be in Maine, the Maine Bureau of Veteran Services. All other facilities are run by the State Department of Veterans Affairs, whatever that is called within its state. And that's why oftentimes the numbers are low. The facility numbers are low because it's expensive. It's also really challenging to run a world-class healthcare system on a fiscal budget cycle, which is oftentimes why even you on this committee have heard legislative bills and initiatives that would oftentimes complement VA initiatives, because the VA itself as a federal entity can't always be responsive. That oftentimes comes to the state and comes to you for some support. And so the unique structure actually enables the world-class care because it isn't tied to a biennial budget. But I think this amendment, and if I heard correctly, this is keep me honest, and I think this is still something we need to discuss, but if I heard the Attorney General's interpretation that as a quasi-state entity or agency, that the construct of funding can be there, but isn't right now, and is something we have asked for. And perhaps the AG's determination is something that we should have had maybe 5 years ago, that maybe even would have led to some type of construct of funding, because the lack of state funding is also where we have gotten to this point right now, acknowledging how to cover that gap so that the entire institution can survive, and a couple don't actually threaten the viability of the rest of the organization.
Thank you, Adria Horn, for that. The partnership seems to be what you just referred to, that there wasn't an understanding 5 years ago of it. And that is a part of what is also in this amendment. If we just strip away the changes to the enabling statute, we know that we need a different arrangement of partnership. The statute requires your fiscal year to align with the state's fiscal year, but you are right. There is no biennial budget that you all work with in your own operations, correct? Is there any other question for Adria Horn from the committee before we take a break? And again, when we return, we will do what we do, but everyone who has spoken may be asked to speak again or not. It just depends on what we decide to do when we return. Before we take a break, I will turn to Colonel Cash to tell us if he has an answer to the question that Senator Miramont asked and the question that I amended to include the vacancy rates of the other 4 facilities in the last year. Colonel Cash, you are on mute. It happens. Thank you.
Sorry about that. So Senator, our current vacancy rate at Augusta is 26%. That's based on hiring for the new facility. Prior to using those numbers, the old numbers, it was at 12.6%, the latest year that was measured.
Great. Any other questions for anyone at this time? Chairman Chiazzo?
Thank you, Mr. Speaker, Mr. Chair. Apologies. It's been a long morning, as we all know. Ms. Horn, did you have something else you'd like to add?
I did. It's sort of a rhetorical question, or just one that I would propose to the committee if this is, talking about sort of a new definition of a partnership, if there is one. Given the precedent of state-run homes, state-run veterans homes across the country, and oftentimes every home or entity, the National Association of State Veterans Homes, is an association that Colonel Cash was also the president of at one point in time. And Dave Richmond, who's the current director of the Maine Bureau of Veterans Services, and my former position, member of a National Association of State Directors of Veterans Associations. And everyone uses the same data. Everyone uses the same VA projections. It's actually VA federal driven for data projections of state veteran populations. So we're all really working with the same data set. And that data set is used also by the VA and by the states in different areas. So this conversation about veteran demographics and population is not isolated to decisions that Maine Veterans Homes would make. It is certainly, decisions that the VA makes for moving CBOC or for expanding a clinic or something like that. And the reason why I bring that up is because it's also the reason some of the state homes have only 1, 2, or 3 homes, even based on their veteran population. So given some of the amendment and a very long-term view, at some point, the legislature has to acknowledge that right-sizing homes and facilities is an ongoing and expected discussion because veteran population changes. And so at some point, I think, we're very emotional and we really are very concerned about this constituency in our state, which is phenomenal. But I do think there's a reality, which is continually right-sizing homes or right-sizing facilities based on our demographic is always going to be a hard discussion and one that we have to acknowledge will continue to be present for us. Thank you.
Thank you. Thank you very much for that background, that the data is shared in databases by the VA across the state. I've seen a couple of those projections. Some of them match each other. Some of them are a little off, but generally speaking, they are exactly what you said. And I think that what the committee is in the process of deliberating, of course, is not just that fact. The state, when it ran an institution, did choose to shut it down. So it's not as if there's no history of having to make those tough decisions. We are deliberating sort of the why of the location that is being chosen. And that's okay. We can do that questioning of the decision to close the ones in the farthest and most rural parts of the state. And when we come back, Director Cash, I would also like to know the occupancy vacancy rates of Scarborough and South Parish, but not before we go on break. So unless there are any closing thoughts for this portion of our day, it is 10 minutes after 2. We are going to break until 2:45 so people can get food and beverage and clear their minds. And I would urge members of each caucus to do that while we take this break. VLA Democrats, you know where we are. The room is already open. The Joint Standing Committee on Veterans and Legal Affairs will be at ease until 2:45.
Was that it? I guess, unless we want to hang out a little bit more. I mean, I think we're all that's left, so. So the only part I missed, which is not relevant, we go back. But what were you upset about? I'm hearing you.
Well, hey, what's up? Yeah. Yeah, Dillingham just tried to call me, so let me call her before VLA goes back in. Okay.
Good afternoon. Welcome back to the Joint Standing Committee on Veterans and Legal Affairs. We will return shortly. I know we said 2:45, but in legislative time, that might mean 3:15. Members of the committee, when they are ready to return, please turn on your cameras so that we know that we can continue forward with our work. We will be reconvening the committee meeting momentarily.
The joys of multiple computers.
Wow.
Looks like we need a motion.
We can't do anything with 4 people. 5.
No, we can't.
Senator Miramont, you don't get to vote twice just because you have 2 going.
I was just going to say that.
I'm just saying.
Trying to help the process.
Senator Miramont, are you really on both screens?
He was. Oh, yes.
1, 2, 3, 4, 5, 6.
Don't count him twice.
Yeah, hey, Dave, and just so you know,
5.
1 is enough.
1, 2, 3, 4, 5. Yes. Representative Corey, I kind of heard him say that he needed to take a quick phone call before he turned off his mic. And I know Representative Wood is still with us as well. So we'll just give them a few more minutes.
I would just like to say that interestingly, for the record, we have more senators present than representatives. I don't know if I've ever been on a committee where that's happened before.
That may not be true.
Only when you guys have like sessions that run over. And the House is still in and the Senate's waiting, or vice versa.
It's usually not vice versa. It's usually we're waiting.
Yeah, I know. Once in a while. 1, 2, 3, 4, 5, 6. I need one more.
No, we have 7 now.
Oh,
No?
he just popped in.
Great. Thank you all for your patience. The Joint Standing Committee on Veterans and Legal Affairs is reconvened. We are in the middle of a work session on LD 2001 regarding the closure of the main veterans homes in Caribou and Machias. The chair recognizes Representative Chiazzo.
Thank you, Mr. Chair. I will move ought to pass as amended on LD 2001. And the amendment will be to remove the language in reference to the main administrative procedure act, to add a language around funding that I think we might be hearing from Sam, and then to add unallocated language to ensure that both facilities are not impacted by closure moving forward. So this impacts their status as well.
And Representative Chiazzo, you are amending the amendment, not the bill.
Correct. I'm amending your proposed amendment to LD 2001.
So Sam, do you at least have enough information to draft the amendment for the motion should it prevail?
Thank you, Senator Hickman. I think I have everything except I have not received the funding information yet. But if there's a committee member or if someone's aware of what's there, I mean, I'm sure. So for the purpose of your vote, we can make sure we pull it from the right place after. Yeah. But otherwise, I'm clear.
If it pleases the chair, I just want to make sure we have funding in there. We can maybe look at that at language review at some point. If it's not sufficient, we can take action then.
The funding amount and the language regarding that amount is what has been offered up to us through the testimony in this work session of Colonel Cash. It will be the $3.5 million that has been negotiated, and that language that will be in the change package will be in the bill. So it will be whatever that language is to make sure that what part of those negotiations has been addressed and agreed to, at least, are the language that will be in this motion. So for my own clarity, it's the amendment minus the section regarding the Administrative Procedures Act, plus unallocated language to ensure that nothing closes until the appropriate process occurs in the beginning of next year at some point, and the funding.
Correct.
If that is your motion, is there a second? The chair recognizes Senator Farron. You are on mute, sir. And just so everyone knows, I don't know what Senator Farron is about to say. So there we are. There you are, sir.
You couldn't read my mind? I just, before we move on, I know we'll have a discussion piece. I'd like to ask Representative Chiazzo, one of the things in section 10, the stakeholder group, I know it reads, and I'm reading it here again, that shall convene a group of relevant stakeholders, develop a plan for the long-term viability and continuous operation of the main veterans home locations designated. And then but it goes on specifically calling out the Caribou and Machias locations and served by those homes. So I think we're covered, but I want to make sure for my support of the stakeholder group, that we're looking at the entire Maine Veterans Home platform, long-term funding, oversight. I mean, it's a fairly big deal, right? And that language is inclusive of everything.
The chair recognizes Chairman Chiazzo.
Yeah, thank you, Mr. Chair. Yeah, I mean, I agree. I think Caribou and Machias are mentioned because they're going to be the ones most immediately affected. So they should probably have some representation there. But the goal is to come up with, because it's multifaceted. It's not, we've heard from Colonel Cash, it's workforce, it's not just funding, it's multiple other things that I think we just need to start coordinating. Because again, from, this is my analogy for the day. It's the tactical thing first is to keep the facilities open. The strategic is to figure out how we do it long term. So I'm hoping that group can really sit down and start mapping out solutions to the problems, or at least some pathway forward, so we're all on the same page together.
And
Senator Farron?
I would refer Senator Farron that upon language review, we will make sure that the language meets exactly what we're all talking about and that it satisfies your concerns if in fact you support the amendment. The chair recognizes Senator Miramont.
Thank you, Mr. Chair. If you didn't get a second, I'm seconding. Thank you.
It's been moved by Representative Chiazzo, seconded by Senator Miramont. Sam, you are clear what the motion is?
Yes, Senator Hickman, I believe I'm clear.
Okay, great. Is there any further discussion of the motion from the committee? Committee is ready for the question. Darlene, please call the roll.
Senator Hickman.
Yay.
Senator Miramont.
Yay.
Senator Farron.
Yay.
Representative Chiazzo.
Yes.
Representative Kinney. Oh, she's not there. Okay. Representative McCray.
Yes.
Representative Briley.
Yes.
Representative Supika is absent. Representative Wood.
Yes.
Representative Kinney. She's there on this.
Yes. Yep.
Thank
Oh,
you.
no, I'm here, sort of.
Okay, gotcha.
Thanks.
Representative Harrington is absent. Representative Corey.
Yes.
And Representative Dolph is absent. 9 in the affirmative and 3 absent, none in the negative.
Thank you, Darlene. The motion, 9 members of the committee having voted in the affirmative, 0 in the negative, 3 members absent, the motion prevails. Absent members will have until noon on Tuesday to cast their votes. Is there anything else the committee needs? Seeing none, I will close the work session on LD 2001. It is 3:16. We are going to take up at least 2 more pieces of legislation. We will not be taking up, I don't have my sheet in front of me, it's all over the place. LD 69, I'm sorry, we will not take up LD 1980 this afternoon. LD 1980, an act to create a small nonprofit raffle operator license. We will return to that on Monday. So with that, I will open up the work session on LD 619, an act to allow Christine Pratt to be buried at the Southern Maine Veterans Cemetery, presented by the late and Honorable Representative John Tuttle of Sanford. Sam? Chiazzo.
Thank you, Mr. Chair. Sorry to put Sam on the spot like that. Director Richmond is in the attendee room. If we can bring him in, that would be very helpful, because he might be able to provide some clarity as to what I'm about to suggest. So we've held over 619. It was originally for Christine Pratt to be buried in the cemetery in Springvale. That was the last legislative piece that Representative Tuttle, our colleague, had in front of our body. And so we were holding on to that to try and give him some time to work through the difficulties. I don't believe that they were ever able to resolve the challenges with making that happen. However, there has been a request, if you will, to have Representative Tuttle interred in Springvale. He was a veteran, but does not meet the current federal qualifications. My understanding is that there is a bill pending, and I hope Director Richmond can correct me if I'm wrong here. There's a bill pending in Congress right now that would grant the states the ability to inter Guard members in veteran cemeteries. So what we would do is amend this into either a resolve or a statute that would grant the department the administrative ability to do that. Once that happens, then Representative Tuttle's request could be considered and hopefully approved based on the standards that he would meet. So, Director Richmond, did I miss anything there, or did I misspeak or quote anything incorrectly?
Director Richmond, welcome. Thank you for being here today. Please introduce yourself.
Thank you. Thank you, Senator Hickman and the rest of the VLA committee. My name is Dave Richmond. I'm the director of the Maine Bureau of Veteran Services. Representative Chiazza, you got it right as far as I can see. As I understand it, that federal legislation has passed both the Senate and the House, and it's on its way to be signed by the president, is what I understand. And you're right that it would allow the burial of National Guard soldiers, Air National Guard personnel, reservists, eligible family members of them, ROTC cadets from the Army, Navy, Air Force who pass away while in that program. And it would allow the burial of former Representative Tuttle. And it would allow it, but we would still have to make a law change because our state statute does not allow it at this point. But I believe you have an amendment that we worked on that would be a quick fix for that. And it would still allow us to look at whatever finally passes at the federal level to make sure that we can align our state statute with it in the future.
Thank you, Director. I will recognize.
Oh, we had a strange audio thing. Was that for me, Mr. Chair?
That is for you, Representative.
Oh. Okay, thank you. Sorry, that sounded very strange. I just wanted to say, and the reason why I don't think we were ready to vote, and I'll let Sam speak to this if he chooses to, is that, thank you, sir, is that if we didn't want to supersede federal action, so we couldn't pass a law that referenced the federal law in case the federal law doesn't pass. So the question was, did we need a resolve to address it in case the federal law passes? But if the law passes, we can do it in statute. Is that correct, Sam, or am I off on that? And in fairness to Sam, he was working his tail off last night on a lot of the key things we were talking about. And I purposely told him that we didn't need to definitively lock this in right now. So I'm putting him on the spot, and I apologize, but I know he's good for it.
Sam.
Thanks, Representative Chiazza. So I looked at the department did provide me with language, and I'm happy to pull it up on the screen just so you can see what the preliminary language is. The reason I didn't have it prepared and send it out to the committee today is I do just want to make sure that I have an opportunity to work with them to make sure that it's like really does what the goal is here. And I think the way that they have proposed it will essentially allow the director to make a determination that a veteran has met whatever new requirements might be passed by the federal government. And for that reason, I think it makes sense to have it just in the allocated statute. moving forward, and it's not going to give them the authority to do anything the federal law doesn't let them do. So there's no reason to prevent it. But I just, it was just one of those things that I want to make sure that we draft it correctly, so it really gets at what they're trying to achieve here. And I think it's close, but it wasn't quite ready for me to send it to the committee.
Thank you, Sam. Chair recognizes.
Thank you, Mr. Chair. I'm going to be bold because I know it's Friday and it's our last day. I hope there's not controversy here. If there is, then absolutely I will defer until we can get language. But I would love to move an ought to pass as amended, and then we can just do that upon language review, because it sounds like we're looking at a statute, not necessarily resolve, and that was really my only concern, that we would have the right vehicle. So does that make sense, Sam, that it's probably going to need to be a statute and not a resolve?
That the way I'm thinking about it right now, I think it would make sense. And basically, and I don't want to get ahead of the department here, but I think what we would do is essentially add this to the definition of eligible veteran under the burial section, and we would allow the department to make a determination of eligibility for these members that in accordance with federal law. So.
Okay. So thank you, Sam. And I think it would be some poetic justice to have our colleague's name on that legislation, because that will be enshrined in perpetuity. So I think it would be nice to have his name, basically allowing National Guard veterans to be interred in the state cemetery, the veteran cemetery. So I'll be bold and move on to pass as amended, if that's appropriate, and hopefully we can address this.
It's been moved ought to pass as amended. Sam is clear what the motion is, even though the language will need to be worked out with the department. Chair recognizes Senator Farron.
I'll second the motion.
Been moved and seconded. Chair recognizes Senator Mirmont. I would like to say that for those who do not know, Representative Tuttle was a member of this committee. He chaired this committee. He lived and breathed this committee. He also sponsored the legislation that created the Southern Maine Veterans Cemetery in Springville. And it is ironic that he currently does not qualify to be interred in the place where he wishes to be laid to rest. And so his last will and testament to all of us, should this pass, is that his name will be on the bill that allows his body to be laid to rest in a cemetery that his legislation created a very long time ago. Chair recognizes Senator Farron.
Thank you, Mr. Chair. And I guess I'll ask Representative Cazzo this. So with this, we've changed the intent of the bill, right? I mean, and really for Representative Tuttle, it's a bigger deal, right? It's going to open up the roles to national. Should we consider a change in the title so it reflects what we're actually?
Yes.
Mr. Chair.
The chair recognizes Representative Chiazzo.
Yeah, I concur 100%. I think that we'll change definitely the title change as well, because it'll expand the intent for sure, from 1 to. Jackie Mayer. Apologies. So yes, I think absolutely that's warranted. And for those of us on the committee who served with Representative Tuttle, he always used to tell us we were, as soon as we'd say something that he'd ask for something, he'd say, well, you're in the will. Well, I think this is his way of putting everybody in the will, and all the veterans will get a chance to this will be his last gift to them, I think. So I appreciate what we do as a committee to honor that, for sure.
Sam?
Thank you. Senator Farron brought up a good point, and I guess I should have not assumed, but yeah, whenever we make a kind of, I think a germane but big change to a bill, we do change the title. I think normally for me, it's like it's kind of a matter of fact thing with the title, like this is now what the bill does. In this case, I don't know if the committee has a particular feeling about what it says, just given the context. So I did want to leave that open for you to discuss if you wanted.
Representative Chiazzo.
Thank you, Mr. Chair. Well, I know we don't typically, it's not permissible to put names in bills. We don't name bills and things like that. If it's okay, I think we leave it open and then we can talk about that in language review, and maybe we could come up with something that we can all agree to that's within the framework of the reviser's structure, that we can make sure that we give him the correct homage, if you will, in some way, shape, or form.
Chair recognizes Senator Farron.
I volunteer the House Chair to take the lead on that and bring something back to us.
House Chair volunteered. Is there any objection? Is there any other discussion of the motion? The committee is ready for the question. Darlene, please.
Senator Hickman,
Yay.
Senator Marymount,
Yay.
Senator Farron,
Yay.
Representative Chiazzo,
Yes.
Representative McCrae,
Yes.
Representative Riley,
Yes.
Representative Supika is absent. Representative Wood,
Yes.
Representative Kinney,
Yes.
Representative Harrington is absent. Representative Corey,
Yes.
and Representative Dolph is absent. So 9 in the affirmative, 0 in the negative, and 3 absent.
9 members voting in the affirmative, none in the negative, with 3 members absent. The motion prevails. I will close the work session on LD 619. We will take a moment of silence to honor our fallen comrades. With that, we will now move. I will open the work session on LD 1957, an act to promote equity and increase opportunities in the cannabis industry by removing restrictions related to convictions for drug offenses, and to replace the term marijuana with the term cannabis in the main revised statutes, sponsored by Assistant Majority Leader Representative Rachel Talbot Ross of Portland. Just a moment to invite the bill sponsor to be part of our discussion. And I know that there's been amendments worked on, so I will turn this over to Sam and allow the bill sponsor also to weigh in on the amendment when she is ready.
Oh, I'm sorry, Senator Hickman. Actually, did you want to let Representative Talbot Ross speak first, or should I go through the bill analysis?
Just go through the bill analysis first, okay. And I will invite the representative to speak about the amendment. Yes.
Okay. So, as stated, this is LD 1957, an act to promote equity and increase opportunities in the cannabis industry by removing restrictions related to convictions for drug offenses, and to replace the term marijuana with the term cannabis in the main revised statutes. So I'm going to walk the committee through my bill analysis, which is mostly about the bill as drafted. And as Senator Hickman mentioned, Representative Talbot Ross, the bill sponsor, has a proposed amendment to the bill. And so I think what I'll do once I get through this is, you guys can ask me questions, and then I'll let her present it. But I also did help her put it together. So if there are questions about it, I'm happy to answer questions. And as many as you are now familiar with many of our marijuana program bills this session, I helped her put it together just in plain language, so it was easy for the committee to vote on the concepts and be clear about what's being discussed. So with that, so this bill removes the prohibitions on participation in the cannabis industry under the Maine Medical Use of Marijuana Act and the Marijuana Legalization Act for persons convicted of disqualifying drug offenses. Under this bill, as directed by a revision clause, it also replaces the term marijuana with the term cannabis in the Maine revised statutes. This bill also provides that when adopting or amending rules and developing or publishing forms, policies, and publications, the Department of Administrative and Financial Services, Office of Marijuana Policy, and the Department of Health and Human Services must replace references to marijuana with references to cannabis. What I have provided here for the committee is, so currently the term marijuana is primarily used in 3 titles within the Maine Revised Statutes. And these are not the only places where the term marijuana comes up, but I think they were the ones that the proposal in this bill have the biggest impact on. And it's Title 17A, Chapter 45, and this is about certain crimes related to drugs. Title 22, Chapter 558C, the Maine Medical Use of Marijuana Act, and Title 28B, the Marijuana Legalization Act. So as I mentioned, there are other instances where the term shows up, but these 3 locations would be significantly impacted by this bill. And one thing I wanted to just note for the committee here is that the Maine Criminal Code, which is Title 17A, still includes crimes for the cultivation and trafficking of marijuana. And Maine's medical use and adult use programs are both set up as explicit exceptions to those criminal provisions. So if for anyone who's wondering why we still have those crimes on the books, I mean, the programs are written explicitly as exceptions to those crimes. So moving forward, I have provided for the committee an excerpt from both the medical program and the adult use program of the definition of disqualifying drug offense for those statutes. And as you can see, they are almost identical. To the extent that the wording is slightly different, they are just to be like internally consistent within those chapters. The only issues with this bill that I have for the committee to consider, and I do, if you have questions about how the bill works or what the implications of doing this certain ways are, I certainly have answers for you. But just for now, based on the way the bill is drafted, so sections 2, 3, and 4 of the bill, in addition to removing provisions related to disqualifying drug offenses, also implement the change of term from marijuana to cannabis in the parts that are being amended. But I just wanted to note this for the committee because the committee has other bills where it has voted to amend the marijuana laws this session. It may help avoid the creation of conflicts to only make language changes with this proposal where absolutely necessary, and instead rely on the directive provided in the bill as printed to direct the reviser of statutes in section 10 of the bill to do the work of implementing the change of term. So I am going to show this to the committee before we go forward. So I'm opening up the bill as drafted, and I apologize for any motion sickness this may incur. Moving down to the bottom here, and you can see we have an unallocated section 10 and an unallocated section 11, and these are directives. So section 10 reads, wherever in the Maine Revised Statutes the word marijuana appears, it is amended to read cannabis, and the reviser of statutes shall implement this revision when updating, publishing, or republishing the statutes. This directive, I think if you just have this and you're not going through and trying to change every instance in the draft of the bill, you'll avoid creating conflicts with the other laws that are being passed this session. So that will probably be the cleanest way to make the change. With that, I'll turn it back to you and see if there are any questions. And as I mentioned before, I'm happy to help answer questions with the amendment I assisted the sponsor in putting together.
Thank you, Sam. No motion sickness here. Are there any questions for Sam from the committee about the original bill and the analysis? Chair recognizes Representative McCright.
Thank you, Mr. Chair. Sam, when we've done language changes like this before to get the statutes up to date, changing language, it's excluded things like names of agencies where there's funding attached, that kind of thing. does that work the way this is drafted?
So when I look at this bill as printed, I also see in section 11, it reads that on or after the effective date of this section, when adopting or amending rules and developing or publishing forms, policies, and publications, the Department of Administrative and Financial Services Office of Marijuana Policy and the Department of Health and Human Services shall replace references to marijuana with references to cannabis. I think that is I read that as a directive to change the word in each instance. So I think it would probably, we may have to be even more clear about this, but the way I read this is that it probably will change the references everywhere, not just in statutes, but also like the name of the programs and the name of the department. And if that is, if that's what the committee wants to make sure happens, we can also be extra clear about that. Like if that's what you want to move forward with, I will make sure it does that.
Follow up, Mr. Chair.
May proceed.
Thanks, Sam. That sounds good. My only question was, and I don't know if it applies here, but we did this around some mental health language, substance use disorder language, but there was some grant programs that we couldn't change the name because it wouldn't have worked for getting funding. So that may not be relevant at all. I'm just asking in case it is.
Thank you, Representative, for that. I'll just jump in and say, from my knowledge of working on these bills almost from their inception, we get no federal grant money for anything related to cannabis because it's federally illegal.
Good point. Yeah, thank you. Appreciate it.
One of the reasons that was given for why the original language in the referendum of the Department of Oversight of Agriculture, Conservation, and Forestry really couldn't be the place where this sits because it might threaten some of the federal funding that department receives. It was a fear. We never got confirmation of that, of course, but that's just one of the reasons why I know that we don't get any federal money for any of these programs. Chair recognizes Representative Chiazzo.
Thank you, Mr. Chair. Thank you, Sam, for that. And I apologize. It's been a long day. I'm a little foggy. You may have mentioned this already. So does this mean that if we make these changes, it would become the Office of Cannabis Policy? So it would be OCP and not OMP? And or is this moving forward from now? Every reference will change marijuana to cannabis moving forward.
I think it would become the Office of Cannabis Policy, and like I said, if we can dot the I's and cross the T's to make that absolutely clear. One thing I will also mention too is I think the way this is written, and this is what they were going for when it was put together, is that basically like this would happen after the bills from this year are finally passed, such that it wouldn't like create a bunch of conflicts and nullify like all the other things the committee has done.
Mm-hmm. Follow up, Mr. Chair.
See.
Thank you. Yeah, I'm just thinking. I wouldn't think there would be much of a fiscal note attached to it unless we're making changes. So I don't know. I mean, it's not going to preclude me from supporting it. I'm just wondering if we are aware if there's going to be a substantial fiscal impact for them to change letterhead and signage and pretty cars or whatever it is they have, everything that has Office of Marijuana Policy on it. I guess I don't know.
We haven't received the fiscal information yet, and I'm sure if there is an impact related to that, it'll show up on any potential fiscal note.
Okay.
Chair recognizes Representative Corey.
Thank you, Mr. Chair. I just wanted to give a little bit of history with the word marijuana. I know, people had sort of brought up books like Chasing the Scream and, all of that other stuff in there. The reason why, the word marijuana got used in here, having sat on that Marijuana Legalization Implementation Committee a while back was because the sponsors of the referenda to legalize marijuana used the word marijuana. Their campaign was actually called the Campaign to Regulate Marijuana, like alcohol. So that was actually their choice of wording. They didn't use the word cannabis. Groups like the Marijuana Policy Project was the second biggest donor, to this. So even within, the cannabis, community, they frequently use the word marijuana. Maybe there's, a change in the acceptance of that word over the last few years, but I think that this is why, all of this, has some sort of residual, impact. If you even go back and you look at the original ballot question that put, at least recreational marijuana on the ballot. Let me see if I can find the original ballot question. Anyways, I do believe that, it says a yes vote is supported legalizing recreational marijuana I'm saying there's some history here with the word, marijuana, and that's why it's included in statute. I don't think it was, put there for other, intentions, and it was certainly supported by the community that passed those laws at the start. But thanks.
Chair recognizes Representative Chiazzo.
Thank you, Mr. Chair. This might even be a question for you, Mr. Chair. I know we had brought up in our discussions before about how there were other references to cannabis, and it was a bigger topic. There were other things under cannabis that weren't necessarily classified as marijuana, like hemp, let's say, or something. How does this change impact that at all, or is it doesn't matter because we can segregate that out in other language somewhere or statute somewhere?
So sometimes the chair overthinks things. I was overthinking it. And having had a conversation, and Sam can speak for himself, that there really is no issue with the definition of hemp and what it actually means, because in state law, we can do what we want and it doesn't affect the fact that even though hemp is a form of cannabis as well, it's clearly defined in statute, and it doesn't matter that we change marijuana to cannabis in all the other places where we're thinking of doing it. But I know there's an amendment coming that carves out a part of the law where we won't change the language, but I'll let the bill sponsor and Sam talk about that. Sam?
Thank you, Senator Hickman. Yeah, I partially just wanted to respond to that and just confirm what we had talked about. Because hemp has a specific definition in the Maine Revised Statutes, I don't think this is going to impact or mess with the way that works. And then, as you'll see when you discuss the amendment that's put forward, I think there are going to be some instances where we keep the word as marijuana, and I will help explain to the committee why that is why that's useful in terms of creating certain distinctions in the law. Yes, yeah, I'll stop there for now.
We'll get to it. I know how this works. I can say, Representative Chiazzo, had I not overthought it, I would have done this 3 years ago because I did have a bill in to do this, and then I overthought it and withdrew the bill. So here we are, and it's perfectly fine. With that, I will ask Representative Rachel Talbot Ross to present the amendment to the committee that I know a member of the committee needs to sponsor. And in that case, once it's presented, I will let Sam know, should there be a motion, who will be sponsoring the amendment for the committee. Representative Talbot Ross, please introduce yourself and the Zoom will be yours.
Well, thank you, Mr. Chair. My name is Rachel Talbot Ross, and I serve as the Assistant Majority Leader in the House, and also proud to represent the people of House District 40, which is part of Portland. I did put together this amendment that Sam has generously prepared for you today. After thinking about it, the public hearing and some of the commentary offered, working with stakeholders, talking to other legislators, interacting just recently with OMP, I present this amendment so that we can do a couple of things that feel like the right next step. And that is to really make sure that what we're removing as an automatic disqualifier would just be limited to marijuana, except for the synthetic cannabinoids. So it really was a bill that was presented to you at the public hearing applied to all disqualifying drug offenses, and we've narrowed it. We've now really narrowed it through this amendment to just applying to the offenses related to marijuana, except for the synthetics. So that's number one. Number two, we have looked at those other disqualifying offenses. There has been some consensus that 10 years is a long time for folks to wait to participate in an application process. So this is still an application process. And we believe that 5 years from the date that all has been satisfied by the courts is a reasonable amount of time period in which to then be able to apply and be considered. What we're not doing in this bill is replacing the word marijuana for cannabis in the criminal code. So that's a really, really important distinction. There may be a time when that is pursued, but that is not this bill. That was not my intention for this bill. And I just respectfully want to look at our adult use program and the medical use program and make sure we have the right terminology for that. And allow for the way in which the criminal code reflects the meaning and history and usage of the word marijuana, to allow that to be the connector. Sam and I had a great conversation about this, and he may be able to make it even clearer, but the term marijuana within the criminal code allows for us to think about that, the history of the criminalization embedded in the name marijuana. To change that to cannabis would mean then we are equating the criminalization of this product with cannabis. And so I'm not at all suggesting that we should do that. I am really happy with this amendment. It is a nice next step on many levels, and I believe it allows for our industry to become more equitable for those who actually have been most harmed, provides them with access. So that's the amendment that I offer today.
Thank you, Representative. I will say that this discussion makes it clear that even though the state of Maine has legalized cannabis, we have not decriminalized marijuana because it still exists in the criminal code. Chair recognizes Representative Corey.
Thank you, Mr. Chair. Thank you for being here today, Representative Talbot Ross. Representative Talbot Ross and I have worked, pretty closely, working through this amendment. One discussion that we had was that, that 10-year to the 5-year look back instead of getting rid of the look back altogether. I'm hoping Sam can bring his analysis back up real quick. And I'm only saying that because I want to go back and I want to look at, how it's currently defined. You had those two pieces of the look back that were in there. One discussion that Representative Talbot Ross and I had was that, basically, my concern was that that look back started once somebody actually satisfied sort of the sentence they had been adjudicated. And it looks like it does. It says an offense for which the sentence, including any term of probation, incarceration, or supervised, was completed 10 or more years earlier. So if we're just changing that to 5 years or earlier, then I'm fine with that. I think that, my initial concern with just removing that provision, altogether was that, we have, all kinds of people that have gotten caught up, in the world or in the war on drugs. And, certainly, those people have gotten there, in different ways. You've got, people trafficking, humongous amounts of drugs into our state that, may not have, ever used the drugs, or, aren't suffering from SUD. And then you've got people that maybe are suffering from SUD that have, hawked a few, oxys or something like that. So they've gotten, caught up. But I think that kind of looking at that 5-year, sentence term or whatever, plus, the adjudication, period, and then 5 years on top of that, I think that satisfies all of that. One of my big concerns all along wasn't necessarily that, I didn't think that people could, become reformed. Do you know what I mean? I think that sort of my concern was for the industry in a lot of ways itself. That certainly I think that the reason why we put these in laws was to keep, potential bad actors out of the industry. But I think that, 5 years from, having completed your sentence and everything, I think that that's adequate. So I'd be willing to move ought to pass as amended, using Representative Talbot Ross's language. Thank you.
Been moved ought to pass as amended. Before I ask for a second, Sam, will you mind sharing your screen and showing us the amendment that we are voting on? I know we don't always have to do that, but since I know you have it in your possession, I would like for people to see it.
Absolutely. And I might, if it's okay with you, just walk the committee through the elements of it one more time.
Thank you.
Okay.
That is a part of asking you to share your screen. But you do it. Please proceed.
Okay. Absolutely. Yeah. So specifically, this amendment is going to do like 2 categories of things. The first is that it's going to remove the prohibitions on participation in the cannabis industry under both the Medical Use Act and the Adult Use Program for persons convicted of state or federal drug offenses, only if the offenses are for the trafficking, cultivation, possession, or consumption of marijuana. So that's in an exception explicitly for marijuana-related offenses. And the exception is not going to apply to offenses related to synthetic cannabinoids, and that is currently defined in Title 17A, Section 1102, subsection 4, paragraph G. You can click here to get to link to that section. And it's going to move the look back from 10 years to 5. I just want to be clear with the committee. When I wrote only if here, it's not going to remove the other any other applicable pieces that are currently carved out in the definitions. So if we go back to the definitions, we're not going to undo an offense that consisted of conduct that would have been permitted under this chapter, and we're not going to like remove anything else. We're just going to change what's explicitly stated in the amendment. And then moving down to the second piece, it's going to replace the term marijuana with the term cannabis for both the adult use program and the medical program, but it's not going to do that in the criminal code, and it's not going to do that when referring to previous drug convictions related to marijuana. And then this is a key distinction that's important from the way the original bill was drafted. The original bill was drafted to strike the previous drug convictions out of the statute completely. But since the amendment's going to continue to refer to previous drug convictions and just change the scope of the disqualifying convictions, you need to be clear that if you're going to make it so convictions related to marijuana are not disqualifying in the program, it should still be clear that those were convictions that were either state convictions related to marijuana or federal convictions to marijuana. And that is a key point to not changing what it says in the criminal code, and also not changing what it says when we're talking about previous drug offenses, because even if you were to change in the criminal code the word to cannabis, the conviction was still a marijuana conviction. You know, it's not going to undo convictions of the past. And also, we cannot control what the federal government calls the term. So if you've been convicted of a federal marijuana crime, it still needs to be clear that that a federal marijuana conviction is not a disqualifying offense. Does that make sense? I think that's a key part to being careful about just where the term's being changed. So
thank you, Sam, for the clarity. What you are telling us as lawmakers is something that we hear all the time in our own deliberations, which we don't want to do something that causes an unintended consequence. And so being this thorough with the language, and language is everything, means that we will not be creating unintended consequences and that this will apply the way we want it to apply. So it's been moved by Representative Corey, all to pass as amended. We've just had the amendment on the screen. Is there a second?
Mr. Chair?
Yes.
Sorry, okay, never mind. We didn't have a quorum to vote, sir. Sorry, now we do. Thank you.
Thank you for clarifying that. 1, 2, 3, 4. The chair recognizes Senator Mirmont.
Yes, second, thanks.
Thank you. It's been moved and seconded. Is there any discussion on the motion? Chair recognizes Representative McCray.
Thank you, Mr. Chair. Just a question, Sam, on the analysis, the synthetics. I keep reading that sort of as a double negative. Can you just say that again?
Sure. This amendment is going to make it so no marijuana-related offenses are disqualifying drug offenses for the purposes of participating in the adult use or the medical use program, except that's not going to apply to offenses related to synthetic cannabinoids. And we have those specifically defined in the criminal code. And personally, I don't know much about synthetic cannabinoids except that they are defined in the criminal code. So if others have information to speak to why that distinction is being made, I'm sure they can. But I personally don't know what the difference is. I don't deal in criminal law all that often.
Thank you. That's answering my question. I just wanted to be clear. Thank you.
Are there any other questions? Discussion from the committee on the motion. I won't propose to tell you that I know exactly what synthetic cannabinoids are, but I think they're more chemical than marijuana. So I'll leave it at that. The definition is in statute, and I'm sure there are a lot of people who can tell you exactly what they mean on the ground versus in the statute. I cannot. Is the committee ready for the question? 1, 2, 3, 4, 5, 6. I need to see 7 faces, otherwise we cannot actually vote. So Representative Wood or Senator Farron, if you are here, we would appreciate a camera turned on. If not, the committee will just be at ease until we see one or both of them turn on their cameras. We'll be at ease. We're not turning off our cameras.
Well, you're at ease because you said you were going to do the work session on 1980 on Monday. What time? Hope you're muted.
Thank you, Darlene, for the question. We will probably add that to after the work session on the budget on Monday. But we're not going to know the time just yet, but for anyone who's listening. And if we don't have a quorum, we won't be able to work LD 1930 either. Here we are.
Okay.
Is the committee ready for the question? The motion is ought to pass as amended, made by Representative Corey, seconded by Senator Mirmont. Darlene?
Senator Hickman?
Yay.
Senator Mirmont?
Yay.
Senator Farron? Absent. Representative Ciazzo?
Yes.
Representative McCray?
Yes.
Representative Briley?
Yes.
Representative Supiker is absent. Representative Wood?
Yes.
Representative Kinney is absent. Representative Harrington is absent. Representative Corey,
Yes.
and Representative Dollop is absent. 7 in the affirmative, 0 in the negative, and 5 absent.
7 members having voted in the affirmative, with the 5 members absent, the motion prevails. Absent members will have until Tuesday at noon to cast their votes. The chair recognizes Representative Corey.
Thank you, Mr. Chair. I just want to say this was a huge evolution for me personally on this issue and everything. So I really appreciate Representative Talbot Ross really working, with me on this to get me to a place where, we could be comfortable. So I want to thank her for that.
Thank you, Representative Corey. Thank you, Representative Rachel Talbot Ross. I will close the work on LD.
Thank you all very, very much. Thank you, man. Thank you.
What can we do? I close the work session on LD 1957. Sorry, it's a lot going on. And if we still have 7 members present, I will ask them though to turn on their cameras because I won't open up another work session until I know that we can vote. And the vote on the rules, I believe, will be rather straightforward to the chagrin of some, but we'll talk about that if we do have 7 people present to vote. 4, 5.
So does anybody else wish that Adria brought her yak to committee today?
About their who?
Her yak. Has anybody been following that on Facebook? The porch yak named Oreo.
I hear text messages going on, so we will see if our committee members whose names are on the screen are still available to participate for another short period of time. We only need 1 more person. The chair recognizes Representative Piazza.
Thank you, Mr. Chair. I just got a text from Senator Farron. He is on a work call right now, but he's going to try and get back as soon as he can.
Okay, great. So with that, we will just simply be at ease until we have another member show their face. This is the way we do quorum check in the virtual world. It appears that there are 8 of us here, but since we can only see 6 of us, we cannot proceed with a work session. Now I see 2, 4, 6, 7. I will open the work session on LD 1930, a bill resolved regarding legislative review of portions of Chapter 1, Adult Use Marijuana Program Rule, a major substantive rule of the Department of Administrative and Financial Services, Office of Marijuana Policy. It's an emergency. Chair recognizes Representative Piazza.
Thank you, Mr. Chair. I move ought to pass.
The motion is ought to pass. Is there a second? Chair recognizes Senator Miramont.
Second.
Been moved and seconded. The motion is ought to pass. According to the rules, if we vote this out ought to pass, it will allow the rules to finally be adopted. I will say that there was some consternation about this among certain parts of the industry, which we all understand. But the truth is this: we can change the statute to solve any problem that may be created by these rules for the industry, and we will continue to work with the Office of Marijuana Policy to make sure that the way they enforce these rules is not as a law enforcement agency, but as a regulatory body that will help the members of the regulated community know what to do and reasons why without any overreach. Is there any other discussion of the motion? Seeing none. Darlene, please call the roll.
Senator Hickman,
Yay.
Senator Miramont,
Yay.
Senator Farron is absent. Representative Piazza,
Yes.
Representative McCray,
Yes.
Representative Riley,
Yes.
Representative Supiker is absent. Representative Wood,
Yes.
Senator Farron.
Yes.
Thank you. Representative Kinney is absent. Representative Harrington is absent. Representative Corey
Yes.
and Representative Dollop is absent. 8 in the affirmative and 4 absent.
Thank you, Darlene. 8 members of the committee voted in the affirmative, none in the negative. The motion prevails. Absent members will have until noon on Tuesday to cast their votes. If there are no other comments on this, I will close the work session on LD 1930.
Can I get Senator Farron's vote on 1957? It was ought to pass as amended.
If Senator Farron is willing to vote right now, he may not be, but I will leave that.
Yeah, I missed a lot of the conversation on that as well as the amendment. So I want to have a chance to review, please.
Nope, that's fine.
Thank you, Senator Farron. I thought you might say that, so that's why I said it. So before we finish our work today, based upon the resolve LD 625 that Representative Riley presented that brought us to the report back that we had in the opening part of the day, the committee has the authority to report out a bill. Even though we are late in session, we understand that this is a subject that must be addressed, and we would like to do that as expeditiously as possible, knowing that we have a very receptive, something just got caught in my throat, a very deceptive department that will look at trying to make this better. So what we need to do today is discuss the process by which we report out a committee bill and get that process started before we adjourn. Sam, are you going to be the one working on this, or will that be Janet? And if it is Janet, are you able to help us start the committee process to get a bill reported out of committee?
Yeah, thank you, Senator Hickman. We haven't decided, and you can start with me, and we'll figure out the rest. And I don't know if I can give you guys a summary right now about the process for reporting out a committee bill if you'd like, or if you don't need a refresher, you can just go forward and tell me your intent, and then we'll get it going.
Yeah, I think we don't need a refresher, and if we do, we'll get it on Monday. But for today, Representative Riley, the chair recognizes Representative Riley to speak with Sam right in front of the committee about the intent of the committee bill. Representative Riley?
Thank you, Mr. Chair. I think after today's public hearing, and then after hearing from public comment, and then also stuff off the record as well, I think it would make sense to have an independent review of the guards' handling of sexual assault and misconduct. I mean, it's absolutely crucial that the legislature addresses sexual assault and harassment in the National Guard and really everywhere. And this needs to be done to prevent sexual assault from occurring, ensure perpetrators are held accountable, and foster a culture where survivors are safe to come forward. I mean, after having the opportunity to hear from Major General Douglas Farnham on the record, I would like to see an independent investigation into the current practices and culture in the Maine National Guard, involving the prevention and response to the incidents of sexual assault. And I also in this bill that we do, I'd also like to see an annual reporting to our committee about how the Guard is processing cases, treating survivors, and taking steps to prevent this violence from occurring in the first place.
Thank you, Representative. Are there any comments or questions from the committee on this proposal? I will say, having done this a few times, that when a committee bill is drafted and referred back to committee for consideration, and Sam can correct me if I'm wrong, there is usually a paragraph at the end of it that makes it clear that the committee as a whole doesn't necessarily support the language in the legislation for the committee bill, because it will be referred back to committee for public comment, work session, and a vote. Is that correct, Sam?
Thank you, Senator Hickman. That is a way it can be done. And if that's the will of the committee, we can absolutely do it that way.
Do we need a motion, Sam, to confirm that we would like to report out this committee bill?
I just want to double check. So am I correct in understanding that the intent of the committee right now is you want to report out a committee bill and then it'll originate from the committee, it'll go to the respective body and then be referred back for public hearing and work session?
That is correct, Sam.
I'm sorry, I'm thinking, and I think the committee should vote that it's your intent to do that, and then you won't be actually reporting out the committee bill until we have like the draft language for it. Does that make sense? So it's a vote to approve the will to report out a committee bill, and then we'll bring the draft back, and you will handle the reporting it out then.
Thank you. Chair recognizes Representative Corey.
Thank you, Mr. Chair. Obviously, to the subject matter, this is something that we would want to do in as bipartisan, manner as possible. Is there a way that, and this is new to, I'm going to say me, like I didn't know about this, and I'm not sure if or Senator Farron has heard about it yet either. I don't know if it's something that you all discussed in caucus or not, and I've had some opportunity to look at language or at least discuss language. I'd like to think that if we're putting together a committee bill, that it's something that we would write together as a committee and kind of agree upon in the committee prior to submitting it, just because like I said, I'd like it to be as bipartisan and supportable by everybody as humanly possible. So like I said, this is very new to me, and I think it's probably very new to Senator Farron as well, and like I said, this is a very serious thing that we would all like to be involved in. So thank you.
Thank you, Representative. Chair recognizes Representative Chiazza.
Thank you, Mr. Chair. If I understand correctly, this is just we're authorized to create a bill. We're not creating the bill. We haven't created something already, and we're just sending it through to get it approved. So my question, I guess, to Sam is when we put in a request, in essence, it's a concept draft, correct, for a committee bill, or do we need to have specific language with what it is we intend to do? My impression is we could put it in just as a request for title, and then we would work that like we would any other bill that came through. Is that correct, or am I mistaken?
I think we can do it that way, where the first thing that needs to happen is I'll have to put in a request for the committee to get an LR number for the committee bill, and then I think yes, we can bring it back pretty much blank, and the committee can decide what you want it to say. Yes. So I think we can do it that way, and obviously you will see what the language is before it gets sent to the greater body, and then refer back to the committee in any instance, in any case. So.
Thank you, Sam, for that clarity. I certainly respect what Representative Corey is saying. Senator Farron is here, he can weigh in or not. I think the way I see it is that if at the request of the original bill sponsor would like to take the opportunity for the committee to report a bill out, we would be authorizing the printing of the bill today. We wouldn't be agreeing to the content, and in that case, we've already got an outline from the bill sponsor of what he would like for the committee to consider being printed and referred back to us. But I just want to let everyone know that, again, there can be language in the draft that says that the committee is taking no position on the draft, so that when it comes back to committee for the public hearing, that is when every member of the committee can weigh in yay or nay on what is finally voted on, just like we do with any other piece of legislation. So I say that not to force a vote. I just say that if there is a motion to report out a committee bill, we at least know what the bullet points are from the intent of Representative Riley. And so we would only be agreeing to report the bill out or not. And if people aren't willing to take that vote today, we're having a public discussion and we can hold off until Monday. The only reason why I feel as though if we're going to do this, we would start the process as soon as possible because of where we are on the calendar. Sam.
I was gonna jump in and clarify and just say a note on what might be most efficient given the time we are in session, but I know Janet just logged on and might be able to speak to this a little with a little more affirmation than that I've been giving you.
Thank you, Sam. Thank you, Sam. Janet, welcome.
Hello.
We started the day with you. We're ending the day with you. It's lovely to have you return. Please weigh in on the subject at hand.
So my understanding was that Representative Riley, although he spoke very quickly and I was planning to replay the YouTube later to hear exactly what he said because I could not write that fast. He had a very specific proposal of what he wanted the bill to be. And Sam and I, we don't know which one would work to draft that up. And what you would be voting today is for authority to report it out. I can show you the disclaimer language if you would all like to see it, if that makes people feel better or not, and it may not, but it might be helpful to see.
That would be something that would be helpful, I believe, for the committee to see whether, like you say, we vote to do this or not. So could you please share your screen?
So you could say right at the bottom, you would put the summary in, and then at the bottom, you would say that the committee hasn't taken a position on the substance, but by reporting it out, the committee isn't suggesting and doesn't intend to suggest that it agrees or disagrees with any aspect of it, but you're just doing it merely for the purpose of allowing it to go through the public hearing and work session process. So this I have seen on committee bills in the past. Not every committee does put this disclaimer language on, but I have seen situations where this makes more people comfortable to report out the bill. And if you're reporting it out to have it come back, your vote is not a vote in favor of the bill. It's just a vote to report it out. Whether you are in favor or against the bill will be part of the final vote after it comes back for the work session. So there is only one minor drawback to this language. And I think it's very minor, and I don't personally see it as a problem, but other people like for us to point it out. So that is, if you vote straight ought to pass and there's no fiscal note and there's no amendment whatsoever, if somebody looks at the legislative history, they'll just see this as part of the summary. I don't think that's all that terribly confusing because it says when you originally reported out, that was your position, and then your final votes will say how you felt about it. But if that is a worry for you, and it's helpful for me to point it out, that's fine. Obviously, if the committee has an amendment to the bill, you wouldn't put this in there because you would no longer be not taking a position, you would be voting on your position. I hope that makes some sense.
Thank you, Janet. Chair recognizes Representative Corey.
Thank you, Mr. Chair. When I read that kind of language, I feel like, it's an out for not working in a bipartisan manner, that, we're reporting out an idea that, a majority of the committee, kind of agrees with, even if there's a final, do you know what I mean, different vote in the end. I'd like to see us, I think, and I was saying this earlier, work in the spirit, do you know what I mean, of reporting out, a bill that makes sense. So I don't think I would be comfortable with that kind of language.
So I just want to be clear what it is you're saying, Representative Corey, because I can't say that I am, and that's okay. You would rather the committee, if I understand you correctly, decide what the content is, have us agree on the content, take a vote on the content, and then vote to report it out. Is that what I think you're saying?
Yeah, I mean, we could go through a process of, I just don't know that we work in good faith with a disclaimer like that on the bill. I'd prefer to see us work in good faith. I think having a disclaimer like that says that, well, we may not agree with this, and I'd much, that we may not all agree with this, but I'd much rather, move forward in sort of a position of feeling like it's something we all can agree on.
So I think I understand what you mean, which would mean, and Janet or Sam, please answer this question. Can you draft a bill without the committee asking for authorization to draft a bill? Because it sounds like what Representative Corey is saying is that he'd want to see the language of a bill before even voting to authorize the committee to report it out. And that might be putting the cart in front of the horse. Can you please provide clarity about that, Janet?
Well, we can draft language. You can say that Representative Riley, for example, is directing us to draft language for the committee to consider. I know Monday is soon, but as long as it's not 30 pages long, hopefully we'll be able to put that together. And then you could see that Monday. It would not be a revisor's office draft. It would be our draft, just like you would see in a lot of proposed amendments for bills.
Need a vote for you to do that. Is that correct?
I don't think so.
Chair recognizes Representative Piazza.
Thank you, Chair. I will defer to Representative Corey if he wanted to respond. That's fine. I know he was in the middle of that.
No, I mean, I think Janet partially answered the question. I think that I think when she was even presenting that language, she said some committees prefer to use that language and others, haven't used it. So I don't think it's something that automatically has to be added. But Janet can correct me if I'm wrong. Thanks.
It does not automatically have to be added. I have worked with other committees where not everybody agrees with the bill being reported out, but they all agree to report it out so it can go through the public hearing process. So they all vote for it, even though in the end they all don't vote for it. But they just don't include that language because they don't think that language is necessary. They think that language is understood.
Thank you for that clarity, Janet. Chair recognizes Representative Piazza.
Thank you, Mr. Chair. And I again, this is the first time I'm doing this, so bear with me. It's been a long day. Is it possible for us to vote it out as a concept, in essence, just like a title only, to get the LR number, to get it to come back to us, and then we can hash out in a language first from the concept draft portion, but in essence, just getting a title? Can we do that, or do we need to have a body of language to come back to start that process?
It is possible you can do that. I've never seen that happen.
Okay, thank you,
If
Janet.
you can hold 5 seconds, I can go ask my director.
We are going, thank you, Janet. You ask your director. Chair recognizes Representative Farron. Senator Farron, excuse me, it's been a long
Well, I got a promotion there for a minute.
Promotion today, right?
So listen, folks, this is obviously a very sensitive issue, and you heard a lot of conversations this morning. And we've had lots of conversations about this, and Representative Riley brought this forward to us so that we'd get this report back and we could see what's going on. And we also heard from the TAG, and I've taken time to speak with some of the senior enlisted folks, and it's been almost 30 years between active duty and the Guard, and things have changed. Some of the stories you heard today, I can relate to. I was probably part of the process 30 years ago when things were going on. I think one of the big things that we need to be cognizant of is that there are federal programs and oversight that are in the works. This isn't just a Maine National Guard issue. This is across the board in our armed forces and our services. There's millions of dollars in the hopper for programs and resources, because I will tell you, our Army and Air National Guard forces are stretched thin, and they're doing a tremendous amount of work for all of us and for the nation every day. And are there a few bad apples? Most likely. You can read about them. But I think, trying to go down the road of providing additional input or a bill or oversight before we know even what the details of those programs are is kind of getting the cart before the horse. And I think it sends a message to our soldiers and airmen that the majority of them perform their duty admirably and with a lot of respect and everything else. So I personally think that we have put a spotlight on it. I think the department's been very open and honest with us about what their processes are and what comes forward. There's also the piece of the civilian piece and our traditional status guardsmen and our full-time AGRs. There's lots of things that we might not totally understand unless you live in that world. With that all being said, I also believe in our process. And if we are simply saying to give Representative Riley a chance to put together some language for a bill, I think that's part of the process that we do as mutual respect to go through it. I do wish we would have had a heads up about this a little bit beforehand, because I've been sitting here struggling with my response since we started this discussion. But I also want to be kind of on record that even though this is a serious issue and it impacts soldiers and airmen and their families, I think we have some leadership that is addressing that. And I think it's leadership here in the state of Maine, as well as being recognized at the federal level.
Thank you, Senator Farren. I ask a question of the committee, which is this. My brain says that I mentioned the possibility or the authority that we could report out a bill at the very beginning of the day, but maybe I didn't. So I'm asking the committee if I did, and if I didn't, then Senator Farren is correct. But I know he wasn't here at the beginning of the day, so that's the only thing that I'm asking the committee about. It's not going to stop or move forward the process, but I thought I said it. I just don't remember. The chair recognizes Representative McCray.
Thank you, Mr. Chair. I would have said yes, but I can't be sure. I guess I sort of thought it was, it was always a possibility when we had a report. But my comment is, I really appreciate what Senator Farren was talking about. But I would just stress that this is such a serious issue. And I really felt like the testimony we heard from General Farnham and staff was very much that they're taking it seriously and not closing the door to wanting to do even more. So I think, whatever we come up with would be intended to be helpful, not to interfere with process. But we talked about culture. I guess the climate survey that they do is about the culture, and the culture is not just in the military, but everywhere. It has its problems, and it's people don't necessarily even realize that they're doing what they're doing. So I would like us to at least look at, as Senator Farren said it much better, our process is that we can do this, and I would like us to take that step and see what we come up with. We don't have a lot of time, but the statements of survivors are pretty dramatic, and I think, as I said during the hearing, some of it is visible and some of it isn't. And it's the invisible that we don't necessarily know about unless people tell us. So I'm sort of rambling at this point, but I think it's really important that we take this a step further and at least look at a bill, have the discussion about a possible bill.
Thank you, Representative. And Senator Farren, I want to say that I agree with your comments. They're on point. I will also say that the portion of the report back that is being referred to here just deserves, it's not long, it just deserves to be repeated for this conversation so that anyone who is joining us and listening to this conversation understands what it is Representative Riley is asking us to consider authorizing a bill to do. It says the creation of an independent review panel to examine the way sexual assaults are investigated, prosecuted, and adjudicated under the Maine Code of Military Justice. That was section 4 of the report. This recommendation was not accomplished due to changing federal regulations. And then he summarizes what those regulations were. 2011 and 2014 was very prescriptive. We can all see this for ourselves. In February 2021, at the direction of President Biden, Secretary of Defense Lloyd J. Austin III ordered a 90-day independent review commission on sexual assault in the military to take bold action to address sexual assault in the military. That paragraph ends. The last paragraph that General Farnham has in this report reads as follows. The Maine National Guard is firmly committed to properly and transparently adjudicating substantiated, unrestricted reports of sexual assault. If a further independent panel is legally created to review these cases, the Maine National Guard would be fully capable of complying with informational requests of the panel. And I think that that speaks to Representative McCrate's comment just now that we have an adjutant general who is willing to do what is ever legally required by the legislature to do on this issue of independent panel. Chair recognizes Representative Chiazzo.
Thank you, Mr. Chair. Janet's back. I was hoping that she ran. I saw her run on screen, so I didn't want her to run for nothing. What was could you get a response?
You cannot report out a concept draft.
You cannot. So we have to have a body of language.
Right. So it was my understanding, like I said, Representative Riley had content that was his motion. So as Sam mentioned earlier, if you vote and you only need a majority vote, but I understand the importance of unanimity to you all. But if you vote to report it out, you would see the language before it is reported out, hopefully Monday, but as soon as possible, whenever we can bring it to you. And then it would have to appear on the calendar and come back to you because that's what we understand your direction to be. So we communicate that to the clerk and the secretary so that they know that this needs to be referenced. Okay. And then everybody would have a chance to put their substantive vote then later. Although I totally understand Representative Corey's concerns, and I think that's a policy question for all of you to work out. I just wanted you to know all the different steps that are involved.
Thank you. Thank you, Janet. Thank you, Sam. Thank you, committee. What is the will of the committee? Chair recognizes Representative Chiazzo.
Thank you, Mr. Chair, and I don't want to belay the point. I mean, I understand. The department, we put 14 recommendations and 6. What was the report back for 625? There were 14 suggested actions. They complied with 11 of those 14. That tells me they are obviously, and 11 of them, one of them partially they could do, and 2 of them they couldn't. The one that they couldn't was the independent council or the independent panel that Senator Hickman had mentioned. I do think it would be important because talking to General Farnham through testimony, it sounded like maybe there was some misunderstanding of what that intent was or what the request was, because it seemed like it made sense with his response, but I'm not sure if that's really was the right question to ask. So I would be willing to put some language in there, but I am not, a precursor, it's not going to be rubber stamped. We're going to have a very viable discussion about what that means, what the impact is going to be. And I want the department to weigh in on that as well, like they would any other bill that'll be presented to us. So I will support reporting a bill out because I want to respect Representative Riley's decision. It was his report back. But B, I also think that's a conversation that maybe we want to spend some more time around to see where we're at, and we may end up changing the bill completely or not voting it out, depending on the response we get from the department. So I'll support Representative Riley's concept, but obviously we are going to be working this bill pretty hard, I think. So
I am going to recommend that we caucus for 15 minutes and return with more discussion. But we need to take a break because we need to take a break. The committee will be at ease for 15 minutes. Thank you.
No. Yeah.
And Senator Hickman?
Welcome back to the Joint Standing Committee on Veterans and Legal Affairs. It's Friday evening. It's 5 o'clock. We don't need to vote on anything, according to Janet. We don't have a quorum at the moment anyway, and it's okay. I just wanted to make sure before we adjourn for the weekend that if anybody wants to say anything more in our meeting around this very important but difficult and sensitive issue of sexual assault in our National Guard, please, I will recognize you to do so. Seeing none, Janet, I do believe that Representative Riley will talk to you shortly about language. I want to thank the dedication of our staff who have been busting the clock on both ends. This week in particular, last night especially, yesterday, Sam is a superhero. I want to thank Darlene for coming in from another committee to do the work of this committee, since our beloved Karen Montel has resigned to go on and try to do bigger and better things in the journey of her life. And I want to thank Janet for her tenacity under very difficult circumstances, and the work that she does in both this committee and the Judiciary Committee, which I have watched and have been a part of, is absolutely remarkably outstanding. And I don't know how you do it, Janet. So take it, whether we're supposed to give it in this particular form or not. I'm going to tell you that you're about the most brilliant thing I've ever met. And you just work and produce results, a work product that is like nothing I've ever seen. Sam, don't take it personally. This is just what I have to say. It's a great work product, and you do it no matter what. And so please accept this committee's great big hug for all that you do to help us produce a better work product as well. With that, the Joint Standing Committee on Veterans and Legal Affairs stands adjourned until Monday. Have a great weekend, everyone.
Senator Hickman, you want to call your aide ASAP?
You too.
Darlene, did you say something to me? I'm so sorry.
No, that's okay.
My computer was down. The volume was all the way down.
Oh, okay.
We're not live streaming, correct?
Yeah, we are. We're still live streaming, but all you need to do is call your aide because he needs to leave soon, and he called for you.
Okay, great.
Jared.
I appreciate it. Thank you very much.
No problem. Have a nice weekend.
Have a great weekend, everyone.